trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film free therapist, you know, keeping everyone in the groove. Right you with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial. Take it to trial.
No, I am not remixing this on here for you guys. No, 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 no. No, 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 no. Good afternoon. Good afternoon, good afternoon, good afternoon. What's up, what's up, what's up? Y'all in Hawaii? Y'all doing, y'all? Y'all in Hawaii? Y'all got y'all skirts on? Y'all luau skirts on? Dang, I should have worn my Aloha shirt again. Dang it, I be forgetting. I got some little beads from Hawaii. I'm gonna see if I can get them on the break. Get my little beads on so I can do my hula dance. I seen when I went to Hawaii, I seen one of those live, and they with the fire and they was up there shaking it like, whew. And it was raining outside, because it rained the entire time while I was in Hawaii. They knew I was coming. They was like, let it rain, let it rain, let it rain, let it rain, and let it rain some more and shit. And as soon as we left, the sun came out, and I was like, "Are you serious?" No, I don't know. But it was definitely something. It was definitely something. So we are on day 8, and we are going into closing arguments because the defense has rested, the state has rested, everybody has rested. We have all the evidence in. Our guy guilty of sin. And next, I'm gonna put a poll out. I would really like to know from your perspective, how long will the jury be back there deliberating? Will this be a long one? I see a lot of people talking about some he say, she say, they say, the rock say, the sun say. And I'm like, what is everybody talking about? You can't believe nothing that he was saying. I didn't believe nothing he was really saying, except for he was a stalker and that he didn't want her to be with nobody else but him. And he had created all these thoughts in his head about her cheating and having an emotional affair. And when he kept saying emotional affair, I was done. Like, he ain't even talking about a DNP emotional affair. He not even talking about that type of an affair. He just talking about an emotional affair. He ain't talking about a Smex affair. He ain't talking about none of that. He just talking about a DP, an emotional affair. And I can't deal. No, I can't deal. And wrote the man's wife. He was married. The guy that he accused her of being messing with. Like, he is the most crazy of the cray. Could you even imagine dealing with somebody at work? They just your work person that y'all just flirt around. Y'all ain't never been out. Y'all ain't never did nothing together. Y'all ain't never had sex together. Y'all share pictures. Y'all share family ideas and different stuff like that. And they creepy partners start sending messages to your significant other talking about, hey, I just want to give you a heads up. They're talking on the phone a whole bunch. They're doing a lot. They're doing this and they're doing that. And ooh, me, I am hurt. I think they're having an affair and I just want to let you know, but it's emotional. It hasn't got sexual. Man, if this guy don't kick rocks. So those are my thoughts there. Let's see here. So we got Marilda was in the house. SD, I don't know if she didn't came back yet. SD says she checking in early. Shoot. She gonna check in at 8 and then she'll be late. Fashionably. Hey, Barb. Today is closing arguments. Yes, today is closing arguments. Hey, Susie. Let's see here. Hey, Brooklyn in the house. Brooklyn said, does anyone know if the defense rested? Yes, they rested the last day we was in court. What was that, last Thursday? Hey, Sam. Hey, Drunky. Hey, Claire. Hey, Lynn. Hey, Just. Hey, Derek. I hope I ain't missed no one. Yeah, this trial has been going on for the last 4 weeks, man. I'm so over this trial. I mean, I'm over it. Especially when you see somebody that you know is clearly probably most likely guilty. Like, I'm over him. I'm over this trial. I'm over Hawaii at this point in time. What's up, TT? Yeah, I'm over it. Me personally, I know some people are still, yeah. I think they're gonna come back with a verdict pretty fast too. I don't think we're gonna play any games. And I don't think it's gonna be no slow roll, baby. I think we gonna be in and out. We're gonna be ready for our drinks later at the luau, baby. With the little fire. Oh, and the man that he would take the stick and he had a fire on the both sides and he was spinning it and stuff. Shoot. Welcome in. Yes, the testicles. She grabbed his balls. Both of them, clutched them like this, y'all. She grabbed him like this. You should have said she was tickling my balls. She was tickling my testes. I don't know, because I think if she would have grabbed him, it probably be like he probably would have wanted to show them to the people and let them take pictures of them because they probably would have been really bruised. But she just pinched him like this and tickled his balls for him. You say you think he getting off? Oh, dude. Y'all, I was with him and I gave him reasonable doubt until his son got up there. His his testimony was very endearing. It was very for real. I don't believe it was anything made up. I don't think he even has a reason to make anything up. His father said what he said. And yeah, I'm done. Hey, Martina, how are you? I don't know what the potential sentence is. That's something I can look up for us to see. But yeah, I'm out on him. After his son got up there, not her biological son, his biological son. After his biological son got up there, I was done. Me personally. I don't know. You guys have to put in the chat. What was your turning point? Were you, I know a lot of people like my Lynn and my Jasons, they be done with you after opening statements. But I got some people that have different turning points. Maybe your turning point was when she testified. Maybe your turning point was when he testified. Maybe your turning point was when the son testified. Drop in the chat when you had your turning point where you was like, he guilty. The son, I see a lot of people saying the son. Yeah, after I heard the son testify, I was like, I was even still at reasonable doubt when she got up there and testified. I was like, yeah, well, okay. It's a he say, she say at this point in time. But now, not at all. But let's see what we got here. Let's go ahead and get in here and see what.
1 CPC-25-373 for further jury trial. Counsel, can I have your appearances, please?
Good morning, Your Honor. Good morning, ladies and gentlemen. Deputy Prosecuting Attorney Joel Garner for the state. Also present is Deputy Prosecuting Attorney Franklin Don Picaro Jr.
Good morning, Mr. Garner. Good morning, Mr. Picaro.
Good morning, Judge.
Good morning, Your Honor. Good morning, ladies and gentlemen. Thomas Otake and Method Dirks on behalf of Gerhard Konig, who is present.
Good morning, Mr. Otake. Good morning, Mr. Dirks. Good morning. Good morning, Dr. Konig. Gentlemen, you can all be seated. Ladies and gentlemen of the jury, good morning to all of you. Welcome back to courtroom 15. It's good to see you. I have to admit, it was a long weekend when I started court yesterday and I walked in. When I didn't see you, I thought it was a bit odd. So it's good to see all of you here back in court. Here's the schedule for today. I've had a chance to talk about it with the attorneys. We're going to finish up the presentation of the evidence this morning. We don't expect it to take very long. And then I'm going to be reading the jury instructions. The jury instructions are the law that you must follow in this case. And then we'll take a break and we'll physically reset the courtroom. When we come back from that break, from that first recess, we'll move straight into the closing arguments of the attorneys. So the prosecution will have its chance to begin with its closing argument. We'll take another break, reset the courtroom. The defense has the opportunity to present its closing argument, followed by any rebuttal argument by the state. Once the closing arguments are done, I will have the final charge to the jury, and I'm going to ask the 12 jurors that are going to deliberate in this case to go into the jury deliberation room to begin consideration of the case. I expect all of that to happen this morning. I smile a little bit. What I mean is all of that is expected to happen before lunch. Our lunch break may be a little bit later, just so we can get all of that in before you begin your deliberation. As you already know, lunch is going to be brought in for the deliberating jurors. So that's the schedule that we're looking at. Lunch maybe a little bit later than 12:30, but hopefully not too much later. So that's the schedule for today. Before we continue, does anybody need any more notebooks, any pens? I see no hands. Mr. Otake, does the defense wish to present any other evidence in this case?
Yes, Your Honor. The defense will recall Detective Thomas Inuma to the stand.
Please. You can have a seat, Detective. Detective, you're still under oath.
Okay.
Good morning, Detective.
Good morning.
Just a few follow-up questions. I'm going to keep this short, but there's a few things I wanted to ask you about. You testified last week when you were called in a case by the state and asked questions by the prosecutor. You testified about your search of Gerhard's computer and how you went through a number of files that were seized pursuant to the search warrant, correct?
Yes.
You worked with Mr. Gardner, the prosecutor, in preparing for trial in terms of going through the computer documents and your testimony, yes?
I work with the lead detective, but as far as the exhibits, the prosecutor's office were in charge of it.
Yeah, so you worked primarily with the lead detective, but the prosecutor's office and worked with HPD to settle in on the exhibits, yes?
Yes.
Now, One of the things that the prosecutor focused on in his questioning of you and in his questioning of Gerhard,
Objection, argumentative and beyond the scope.
Oh, let him set up the question. Please ask.
related to the files seized, one of the things you're asked about was the last access timestamp on the files. You remember testifying about that?
Yes.
And isn't it true, Detective, computer operating systems like Windows records when files were last accessed, yes?
Yes.
And then you use the magnet Axiom software in this case to pull certain files that you're allowed to pull by the search warrant, yes?
Yes.
Axiom then reports, amongst other information, what is called the last access time for those files, yes?
Yes.
And that's the last access timestamp generated by the computer system, yes?
Yes.
Now, Detective, isn't it true computers routinely access files on their own without human action, correct?
Yes.
For example, operating system processes sometimes access files, yes?
Yes.
Search indexing functions on a computer can access files, yes?
Yes.
Antivirus or security scans can access files, yes?
Yes.
Backup or sync programs can access files, yes?
Yes.
All of those can access files. A computer can access a file doing those things without any human clicking on or viewing the file, correct?
Yes.
And when a computer accesses files that way, it will often update the last access time, yes?
Yes.
Even though it was not a human that accessed the file, correct?
Yes.
And you talked about your experience and the training that you've gone through to become qualified as an expert in computer forensics. Have you read literature related to computer forensics and the appropriate use of these timestamps?
Yes.
Isn't it true that there is literature that cautions computer forensic examiners from drawing too strong of an inference from the last access timestamp because of this issue related to computers accessing files instead of humans? Have you read literature that talks about that?
Yes.
Now, to be fair, the search warrant only allowed you to look at some files, some files that were accessed, yes?
Yes. Just within the time frame and 32 items.
Yeah, the search terms, right?
Yes.
So you didn't have access to all of the files that may have been opened or accessed during that time period, correct?
Yes.
And that being said, you cannot rule out with certainty that some of the last accesses you discussed last week may have been caused by automated processes instead of a human, correct? You cannot rule that out with any degree of certainty. Well,
Yes, that's correct. Based on the data I received, yeah, I cannot rule it out.
Okay, thank you, Detective. No further questions.
Mr. Garner, any cross-examination?
Yes.
Please.
Okay. Good morning, Detective.
Good morning.
Welcome back. All right. So you were asked just now about the computer opening up files on its own. Is that right?
Yes.
How does that apply to the files that you testified about last week?
So for the files to open up automatically, so there's a thing called antivirus software, right? So how that program works is there's two options, right? One is if you want to do a quick scan, which would target specific files, which is known by the company where the malware or the virus might be hiding inside the computer. And there's also another a term we use is a full scan, which the antivirus software will scan the entire computer, right? Every files. How that works is if you do a full scan, it's going to look at every individual files and it's going to create a new access time. It's going to verify that these files does not contain virus. For targeted, it's going to be looking at certain files or folders which may contain the virus, right? If it doesn't have it, then just that folder itself is going to have all the same date, time where it was accessed, because how the virus scan works, it's a sweeping. It might show in within the same date, the time, within milliseconds apart.
Okay. Now, based on the fact that there are multiple different dates where all these different files, the financials, the divorce documents, where all these were accessed, what does that tell you about whether this was a virus scan or a person?
Okay, so how using the Axiom software, if it's a case that's involved, if it's important to last access time, the file created date time or the modified date time, what I usually do is I look at the metadata. The metadata is data about the data. So for example, for photos or videos, right? It contains data such as created date time. It also have a modified date time. It's going to also show the last access time. It's going to contain GPS location data and the make and model of the device that was used to capture it. For files, it's going to contain basically the same thing. Might not have the GPS location data, but it might contain the author's name. And as far as when I was looking at when I filtered, just by looking at the date range where it was last access, I noticed that all the dates and the date and time that was accessed were all different. It'll be a strong indication if all the access time were all within the same date, the same time, within milliseconds. If it shows that there was over 50 files that were accessed at the same second, then that would be a strong indicator that there was some kind of automated software that accessed all of them. And it's humanly impossible to open up 50 files within a second.
Okay, so let's focus on the files from the defendant's folder that we talked about last week about divorce. Those files were accessed between December 2024 and February 2025. Is that right?
Yes.
On at least 4 different days, correct?
Yes.
And what does that tell you about whether it's human access or antivirus software or automatic access?
Okay, so just based on the limited data that I received, it appears that it was likely a human action that caused it, because if the antivirus software went into that folder, it's going to do a sweep of all the files within that folder. It's not going to just individually pick one file for that day, come back a couple of days later, look for another file, and so on.
So overall, the file access that you talked about last week, is that more consistent, or that file access that you talked about last week is more consistent than with user access than automated access, correct?
Based on the data that I had, yes.
Thank you. No further questions.
Detective, you said based on the data that you had, and you said based on the limited data I recovered, it appears more likely to be human. But you say based on the limited data because you didn't have all the data to look at what other files may have been open at that time, correct?
Yeah, so yeah, correction. So based on the limited data, it appears that it was a human action, but I'm not certain because I will need the full access to the computer.
Thank you, Detective. Nothing further.
Any other questions for Detective Meany?
No, thank you.
Detective, thanks for coming back.
Okay, thank you.
Mr. Otake, does the defense wish to present any other evidence in this case?
Your Honor, at this time, the defense rests.
Thank you. Mr. Garner, does the state wish to present any rebuttal evidence in this case?
No, Your Honor.
Counsel, if I can briefly have you appear at the natural record. I'm sorry, on record.
He should have said we arrest for the second time in a row, we think. Now, if they do a rebuttal, then we may want to reopen our case again. Thank goodness the prosecution team decided that they didn't want to do a rebuttal for this case. Oh, I got to get our little survey out. I don't know. Maybe some people don't think he's guilty. Let me make sure I put that out here for y'all. We'll do that survey first. Let's check the temperature. Somebody think that he's not guilty, Lynn.
Thank you, counsel. So at this point in time, ladies and gentlemen, I'm going to read the jury instructions to you. Ms. McCallum is going to pass out to each of you one set of these jury instructions. So you're welcome to read along with me, but you're not required to do so. Because when you go into the jury deliberation room, each of you will have your own set of jury instructions.
Leah said, who think that? Ain't no way. I knew she'd be hot for anybody saying that. Don't nobody click come jury or not guilty because Lynn probably go crazy in the chat. Want to point you out, want to do a lineup. It's no longer a poll, anonymous poll. She want to know. You're going to have to be front and center. Oh, gosh.
Does anybody not have a set of jury instructions? Okay. Ladies and gentlemen, I will now instruct you on the law that you must follow in reaching your verdict. You are the judges of the facts of this case. You will decide what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. You must consider all the instructions as a whole and consider each instruction in the light of all the others. Do not single out any word, phrase, sentence, or instruction and ignore the others. No word, phrase, sentence, or instruction is more important just because it is repeated in these instructions. In the event that a statement or argument made by a lawyer contradicts or misstates these instructions, you must disregard that statement or argument and follow these instructions. You must presume the defendant is innocent of the charge against them. This presumption remains with the defendant throughout the trial of the case, unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan, but an essential part of the law that is binding upon you. It places upon the prosecution the duty of proving every material element of the offense charged against the defendant beyond a reasonable doubt. You must not find the defendant guilty upon mere suspicion or upon evidence which only shows that the defendant is probably guilty. What the law requires before the defendant can be found guilty is not suspicion, not probabilities, but proof of the defendant's guilt beyond a reasonable doubt. What is a reasonable doubt? It is a doubt in your mind about the defendant's guilt, which arises from the evidence presented or from the lack of evidence, and which is based upon reason and common sense. Each of you must decide individually whether there is or is not such a doubt in your mind after careful and impartial consideration of the evidence. Be mindful, however, that a doubt which has no basis in the evidence presented, or the lack of evidence, or reasonable inferences therefrom, or a doubt which is based upon imagination, suspicion, or mere speculation or guesswork is not a reasonable doubt. What is proof beyond a reasonable doubt? If, after consideration of the evidence and the law, you have a reasonable doubt of the defendant's guilt, then the prosecution has not proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant not guilty. If, after consideration of the evidence and the law, you do not have a reasonable doubt of the defendant's guilt, then the prosecution has proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant guilty. You must consider only the evidence that has been presented to you in this case, and inferences drawn from the evidence, which are justified by reason and common sense. The charging document is a mere formal accusation, and it is not evidence of the defendant's guilt. You must not be influenced at all because the defendant has been charged with an offense. Trial procedures are governed by rules. When a lawyer believes that the rules require it, it is their duty to raise an objection. It is my responsibility to rule on such objections. You must not consider objections made by lawyers in your deliberations. Statements or arguments made by lawyers are not evidence. You should consider their arguments to you, but you are not bound by their memory or interpretation of the evidence. If I have said or done anything that has suggested to you that I favor either side, or if any of my statements or facial expressions has seemed to indicate an opinion as to which witnesses are or are not worthy of belief, or what facts are or are not proved, or what inferences should be drawn from the evidence, I instruct you to disregard it. You must also disregard any remark I may have made unless the remark was an instruction to you. You must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Both the prosecution and the defendant have a right to demand, and they do demand and expect that you will carefully and impartially consider and weigh all of the evidence and follow these instructions, and that you will reach a just verdict. You must disregard entirely any matter which the court has ordered stricken. You may, but are not required to accept as conclusively proved any fact or event which the court has judicially noticed. You must accept as conclusively proved any fact to which the parties have stipulated. While you must consider all of the evidence in determining the facts in this case, this does not mean that you're bound to give every bit of evidence the same weight. You are the sole and exclusive judges of the effect and value of the evidence and of the credibility of the witnesses. It is your exclusive right to determine whether and to what extent a witness should be believed and to give weight to his or her testimony accordingly. In evaluating the weight and credibility of a witness's testimony, you may consider the witness's appearance and demeanor, the witness's manner of testifying, the witness's intelligence, the witness's candor or frankness or lack thereof, the witness's relation, if any, to a party, the witness's temper, feeling, or bias, if any has been shown, the witness's means and opportunity of acquiring information, the probability or improbability of the witness's testimony, the extent to which the witness is supported or contradicted by other evidence, the extent to which the witness has made contradictory statements, whether in trial or at other times, and all other circumstances surrounding the witness and bearing upon his or her credibility. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. In weighing the effect of inconsistencies or discrepancies, whether they occur within one witness's testimony or as between different witnesses, consider whether they concern matters of importance or only matters of unimportant detail, and whether they result from innocent error or deliberate falsehood. If you find that a witness has deliberately testified falsely to any important fact, or deliberately exaggerated or suppressed any important fact, then you may reject the testimony of that witness, except for those parts which you nevertheless believe to be true. You're not bound to decide a fact one way or another, just because more witnesses testify on one side than the other. It is testimony that has a convincing force upon you that counts, and the testimony of even a single witness, if believed, can be sufficient to prove a fact. The prosecution is not required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. The defendant has no duty or obligation to call any witnesses or produce any evidence. The defendant in this case has testified. When a defendant testifies, his credibility is to be tested in the same manner as any other witness. The defendant has a constitutional right and a legal duty to be present throughout the trial and while other witnesses testify. You must not draw any unfavorable inference regarding the credibility of the defendant's testimony on the basis that he was present during the trial. During the trial, items are received into evidence as exhibits. These exhibits will be available for your review when you deliberate. In addition to facts which counsel have stipulated to be true and facts which the court has taken judicial notice of, there are two types of evidence: direct evidence, such as the testimony of witnesses who assert actual knowledge of a fact, and circumstantial evidence, which permits a reasonable inference of the existence of another fact. Facts may be proved by direct evidence or circumstantial evidence, or by a combination of both. The state of mind with which a person commits an act, such as intentionally, knowingly, recklessly, or negligently, may be proved by circumstantial evidence, while witnesses may see and hear, and thus be able to give direct evidence of what a person does or fails to do. There can be no eyewitness account of the state of mind with which the acts are done or omitted. But what a person does or fails to do may or may not indicate the state of mind with which he does or refrains from doing an act. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required states of mind, as these instructions specify, with respect to each element of the offense. The instruction for the offense charge specifies the states of mind required to be proved. During the trial, you heard the testimony of certain witnesses who were allowed to provide opinion testimony. training, and experience may make a person qualified to provide opinion testimony in a particular field. The law allows that person to state an opinion about matters in that field. Merely because such a witness has expressed an opinion does not mean, however, that you must accept this opinion. It is up to you to decide whether to accept this testimony and how much weight to give it. You must also decide whether the witness's opinions are based on sound reasons, judgment, and information. The defendant, Gerhard Konig, is charged with the offense of attempted murder in the second degree. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. There are two material elements of the offense of attempted murder in the second degree, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant intentionally engaged in conduct, and 2, the conduct, under the circumstances as defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Konig. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit murder in the second degree, which is intentionally or knowingly causing the death of another person. Self-defense is a defense to the charge of attempted murder in the second degree and its included offenses. Self-defense involves consideration of two issues. First, you must determine whether the defendant did or did not use deadly force. Second, you must determine whether the force used was justified. The burden is on the prosecution to prove beyond a reasonable doubt that the force used by the defendant was not justified. If the prosecution does not meet its burden, then you must find the defendant not guilty. The first issue is, did the defendant use deadly force? Deadly force means force which the defendant uses with the intent of causing, or which he knows to create a substantial risk of causing, death or serious bodily injury. Force means any bodily impact, restraint or confinement, or the threat thereof. If you determine that the defendant used deadly force, then you are to proceed to the section of this instruction entitled Deadly Force Used. If you determine that the defendant did not use deadly force, then you are to proceed to the section in this instruction entitled Deadly Force Not Used. The determination of whether or not the defendant did or did not use deadly force must be unanimous. You must then follow the law in the applicable section to determine the second issue, which is whether the force used by the defendant was justified. Deadly force used. The use of deadly force upon or toward another person is justified if the defendant reasonably believes that deadly force is necessary to protect himself on the present occasion against death or serious bodily injury. The reasonableness of the defendant's belief that the use of protective deadly force was necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be when the deadly force was used. The use of deadly force is not justified if the defendant, with the intent of causing death or serious bodily injury, provoked the use of force against himself in the same encounter. The use of deadly force is not justifiable if the defendant knows that he can avoid the necessity of using such force with complete safety by retreating. Deadly force not used. The use of force upon or toward another person is justified if the defendant reasonably believes that the force is immediately necessary to protect himself on the present occasion against the use of unlawful force by the other person. The reasonableness of the defendant's belief that the use of protective force was immediately necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be. The defendant may estimate the necessity for the use of force under the circumstances as he reasonably believes them to be when the force is used without retreating. Unlawful force means force which is used without the consent of the person against whom it is directed, and the use of which would constitute an unjustifiable use of deadly force or force. A person cannot consent to the infliction of death, serious bodily injury, or substantial bodily injury. Self-defense is not available for the included offenses of assault in the second degree by recklessly causing substantial bodily injury, and assault in the third degree by recklessly or negligently causing bodily injury, if the prosecution proves that 1, the defendant was reckless in believing that he was justified in using deadly force or force against the other person, or 2, the defendant was reckless in acquiring or failing to acquire any knowledge or belief which was material to the justifiability of his use of deadly force or force against the other person. If, and only if, you unanimously find that all the elements of attempted murder in the second degree has been proven by the prosecution beyond the reasonable doubt, and you unanimously find that the defendant was not acting in self-defense, then you must consider the affirmative defense of extreme mental or emotional disturbance. Extreme mental or emotional disturbance has 2 elements. These 2 elements are: 1, the defendant was, at the time he attempted to cause the death of the other person, under the influence of extreme mental or emotional disturbance. And 2, there was a reasonable explanation for the extreme mental or emotional disturbance. The reasonableness of the explanation shall be determined from the viewpoint of a reasonable person in the circumstances as the defendant believed them to be. The question of the defendant's self-control, or lack of it, at the time of the offense is a significant factor in deciding whether he was under the influence of extreme mental or emotional disturbance. The defendant must prove an affirmative defense by preponderance of the evidence. This means that the defendant must prove that it is more likely than not, or more probable than not, that each element of extreme mental or emotional disturbance occurred. In determining whether the defendant has proven an affirmative defense by a preponderance of the evidence, you must consider all of the evidence that has been presented to you regardless of who presented it. If you unanimously find that the defendant has proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted manslaughter based upon extreme mental or emotional disturbance. If you unanimously find that the defendant has not proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted murder in the second degree. If you are unable to reach a unanimous verdict as to whether the affirmative defense has been proved or not been proved, then a verdict may not be returned on attempted murder in the second degree. If, and only if, you find the defendant not guilty of attempted murder in the second degree, or you are unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of attempted assault in the first degree. A person commits the offense of attempted assault in the first degree if he intentionally engages in conduct under the circumstances as he believes them to be, constitutes a substantial step in a course of conduct intended to culminate in his commission of assault in the first degree. There are 2 material elements of the offense of attempted assault in the first degree, each of which the prosecution must prove beyond a reasonable doubt. These 2 elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant engaged in conduct which, under the circumstances as the defendant believed them to be, was a substantial step in a course of conduct intended by the defendant to culminate in the commission of assault in the first degree. And 2, the defendant engaged in such conduct intentionally. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit assault in the first degree. The defendant commits the offense of assault in the first degree if he intentionally or knowingly causes serious bodily injury to Ariel Konig. If, and only if, you find the defendant not guilty of attempted assault in the first degree, or you're unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the second degree. This offense can be committed in one of two ways: assault in the second degree, substantial bodily injury, or assault in the second degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the second degree, substantial bodily injury, if he intentionally, knowingly, or recklessly causes substantial bodily injury to another person. There are two material elements of the offense of assault in the second degree, substantial bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused substantial bodily injury to Ariel Konig. And 2, the defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the second degree, dangerous instrument, if he intentionally or knowingly causes bodily injury to another person with the dangerous instrument. There are three material elements of the offense of assault in the second degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Konig. And 2, the defendant did so with a dangerous instrument. And 3, the defendant acted intentionally or knowingly, as to elements 1 and 2. We are to consider each alternative of assault in the second degree separately. The fact that you may find one of the alternatives has or has not been proved beyond the reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the second degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, have been proved beyond a reasonable doubt. Proof beyond the reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the second degree. If, and only if, you find a defendant not guilty of assault in the second degree, or you are unable to reach a unanimous verdict as to any of the alternatives, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the third degree. This offense can be committed in either of two ways: assault in the third degree, bodily injury, or assault in the third degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the third degree, bodily injury, if he intentionally, knowingly, or recklessly causes bodily injury to another person. There are two material elements of the offense of assault in the third degree, bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Konig. And 2, the defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the third degree, dangerous instrument, if he negligently causes bodily injury to another person with a dangerous instrument. There are three material elements of the offense of assault in the third degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Konig. And 2, the defendant did so with a dangerous instrument. And 3, the defendant acted negligently as to elements 1 and 2. The fact that you may find one of the alternatives has or has not been proved beyond a reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the third degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, has been proved beyond a reasonable doubt. Proof beyond the reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the third degree. Ladies and gentlemen, I'll amend the instructions so that it reads the way I read it out loud. If and only if you find that the prosecution has proved the offense of assault in the third degree beyond a reasonable doubt, you must also consider whether the fight or scuffle was entered into by mutual consent, whether expressly or by conduct. You must determine whether the prosecution has proven beyond a reasonable doubt that the fight or scuffle was not entered into by mutual consent. This determination must be unanimous, and it is to be indicated by answering yes or no on a special interrogatory that will be provided to you. Dangerous instrument means any weapon, device, instrument, material, or substance, whether animate or inanimate, which in the manner it is used or is intended to be used, is known to be capable of producing death or serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Substantial bodily injury means a major avulsion, major laceration, or major penetration of the skin, or a burn of at least second-degree severity, or bone fracture, or a serious concussion, or a tearing, rupture, or corrosive damage to the esophagus, viscera, or other internal organs. Bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally with respect to his conduct when it is his conscious object to engage in such conduct. A person acts intentionally with respect to attendant circumstances when he is aware of the existence of such circumstances or believes or hopes that they exist. A person acts intentionally with respect to a result of his conduct when it is his conscious object to cause such a result. A person acts knowingly with respect to his conduct when he is aware that his conduct is of that nature. A person acts knowingly with respect to attendant circumstances when he is aware that such circumstances exist. A person acts knowingly with respect to the result of his conduct when he is aware that it is practically certain that his conduct will cause such a result. A person acts recklessly with respect to his conduct when he consciously disregards the substantial and unjustifiable risk that the person's conduct is of the specified nature. A person acts recklessly with respect to attendant circumstances when he consciously disregards a substantial and unjustifiable risk that such circumstances exist. A person acts recklessly with respect to a result of his conduct when he consciously disregards a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if, considering the nature and purpose of the person's conduct and the circumstances known to him, the disregard of the risk involves a gross deviation from the standard of conduct that a law-abiding person would observe in the same situation. A person acts negligently with respect to his conduct when he should be aware of a substantial and unjustifiable risk taken that the person's conduct is of the specified nature. A person acts negligently with respect to attendant circumstances when he should be aware of a substantial and unjustifiable risk that such circumstances exist. A person acts negligently with respect to a result of his conduct when he should be aware of a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if the person's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a law-abiding person would observe in the same situation. The law allows the introduction of evidence for the purpose of showing that there is more than one path to prove an element of an offense or to disprove a defense. In order for the prosecution to prove an element of an offense or to disprove a defense, all 12 jurors must unanimously agree that the same act has been proved beyond a reasonable doubt. You must not discuss or consider the subject of penalty or punishment in your deliberations of this case. A verdict must represent the considered judgment of each juror, and in order to reach a verdict, it is necessary that each juror agree thereto. In other words, your verdict must be unanimous. Each of you must decide the case for yourself, but it is your duty to consult with one another and to deliberate with the view to reaching an agreement, if you can do so without violating your individual judgment. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest belief as to the weight or effect of evidence for the mere purpose of returning a verdict. You have been allowed to take notes during this trial. When you begin deliberations, you must follow some important rules with regard to notes. 1. Notes may be used only by you to assist in refreshing your memory of the evidence. Notes are not a substitute for your own independent memory of the evidence. 2. Keep your notes to yourself and do not share or read them to any other juror. 3. You must not give certain evidence more weight simply because it appears in your notes. Do not assume that your notes are accurate or complete. 4. Some of you may not have taken notes. If you have not taken notes, you should rely on your memory of the evidence and should not be influenced by the fact that another juror took notes. Notes are not entitled to any greater weight than the memory of each juror as to what the testimony may have been. Anytime you leave the room during deliberations, leave your notes face down on your chair. 6. If you go home overnight without reaching a verdict, your notes will be kept by the court and returned to you at the start of the next day. Your notes will not be read by anyone. 7. After you've reached a verdict, your notes will be collected and destroyed. At the start of your consideration of this case, elect one of your members as foreperson to preside over your deliberations and be your spokesperson in court. You may take such time as you feel is necessary for your deliberations. You may inform the court if you have any questions about or do not understand the court's instructions. When you reach a verdict, the foreperson is to sign and date the verdict, an appropriate form for which will be given to you. When you begin your deliberations, and until you are through with your consideration of this case, or you are otherwise excused by the court, it is necessary that you remain together as a body. Court personnel will be sworn to attend you and take care of any personal problems you may have and see to your comfort. If you need to communicate with the court, send a note through the bailiff. Please do not attempt to communicate with the court except in writing. During the course of this trial, you have received all of the evidence you may consider to decide the case. You must not attempt to gather any information on your own, which you think might be helpful. Do not engage in any outside reading on any matter having anything to do with this case. Do not refer to dictionaries or other outside sources. Do not visit any places mentioned in the case. Do not in any other way try to learn about the case outside the courtroom. During your recesses from deliberations, when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not review to the court or to any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and it has been received by the court. You may bring in either one of the following verdicts. 1, not guilty. Or 2, guilty as charged of attempted murder in the second degree. Or 3, guilty of attempted manslaughter based upon extreme mental or emotional disturbance. Or 4, guilty of attempted assault in the first degree. Or 5, guilty of assault in the second degree. Or 6, guilty of assault in the third degree. Your verdict must be unanimous. After a verdict has been reached and your foreperson has signed and dated the verdict form, you will notify the bailiff and court will be reconvened to receive the verdict. Okay, ladies and gentlemen, we'll take our first morning recess. You'll leave your notebooks on your chair along with your set of jury instructions. As I indicated, the jury instructions, these 2 pages will be amended. So 2 pages will be replaced. So the written instructions that you have will be as I read them out loud here in court. Okay, we'll take a recess. We'll take a 15-minute recess. Ms. McCallum will come get you at 10:10. We'll come back in. We'll continue on or start with the summation or closing arguments of the parties. All rise. attempted murder in the second degree. So it should be amended. Last sentence in the first paragraph, the words between of and murder, the word attempted should be inserted. Same change, last sentence of the instruction, it should be attempted murder in the second degree. That's how it's read to the court. Mr. Gardner, any objections to the amendment of the instructions?
No objection.
How about you, Mr. Otake?
This is on page 19,
Yes,
correct?
sir. Yes, sir.
In the two places where it said murder instead of attempted.
Correct.
Yeah, no problem.
And
Thank you.
then one more change, counsel, page 24. And I need you to take a look at not just page 24, but also page 22. I read to the jury the last paragraph that's in page 22 that is not on page 24, indicating that, again, they need to consider the alternatives separately. They must be unanimous if they're going to come back on an alternative or both alternatives. And that if they do come back on two, it results in only a singular conviction. It mirrors the language in page 2, except it's assault in the third degree. As it was read and to the amendment, Mr. Garner?
No objection.
How about you, Mr. Otake?
No objection, thank you.
Yeah, no. As the instructions are read to the jury, counsel, any objections to the instructions as a whole, other than what we've already settled on the record?
Other than our previous objections, nothing new.
None from the state.
Mr. Garner, have you had the opportunity to review the proposed verdict form, special interrogatory, and communication forms?
Yes.
Any objections?
No.
How about you, Mr. Otake?
No objections, I did review it.
Okay. Anything we should take up before we take our recess?
Nothing from the state.
Just that we're gonna take a break after, I'd ask that I think we need to take a break after the state's closing, so I can set up and also show the state my PowerPoint at that point.
That's fine.
Yeah.
I intended that anyway. I did have one more thing. I'm sorry. I'm glad I remembered it. The normal course of closing is the state, take the break, defense, okay, and then go straight into the state's rebuttal.
Correct.
If the defense is going to argue the affirmative defense of extreme or emotional disturbance, then defendant has to rebuttal. We didn't discuss that, but that is the state. So if the defense is going to argue that, then there's rebuttal. It'll come right after the state's rebuttal. And then I'll give the final charge to the jury before I send them to deliberation. Counsel, any agreement with that?
Yes, with the understanding that should that happen, the rebuttal is limited to the EMED.
Oh, it's only on email. Yeah. Okay. Counsel, thank you. Court's in recess.
And off record, I'm gonna now look at his PowerPoint.
Well, we are on break. We'll come back and we'll go to closing arguments. And I guess that they are trying to present the defense that he was emotionally unstable, emotionally distraught, and it led to this. Then the defense can put on a rebuttal. So, you know how it's usually state closing, defense closing, then state does a rebuttal. Well, in this one, the defense also has the opportunity to do a rebuttal if they are going to go all in. It's basically go all in with the defense that he was emotionally distraught. Like, he was emotionally distraught, and this is why it happened. Let us tell you all the ways. So let's see here. We don't have any TiVo time to pull us past this. Let me look at our survey and see what we got so far. We got 9% say it's hung. Got 13% say not guilty. 78% says guilty. Got about 54 votes in there. Interesting. Interesting. That's different. I wonder, could the jury end up being hung because they don't know who did what? Oh gosh. I think if you saying he say, she say, then you just skip past all the he say, she say, and go to son's word. That's the deal breaker right there. In my eyes.
Yeah, yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in check. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the feed. We the California's rolling deep online. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing got a Shamrock spark.
Yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Susie, Shamrock,
Oh,
Shamrock.
we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this.
So I think I seen something in the chat where y'all said the closings is an hour each. That's what I want. Okay, so I think they said about an hour each, and I guess we shall see. These notes that they can take back there and stuff, that's kind of, I never even thought that they even take their notes the court each night until, I don't know what I thought they did with their notes. I don't know why I thought they left them in the chair, or maybe they had a locker for them. But for the courtroom staff to have their notebooks every night, like I wouldn't want the courtroom staff having my notes, seeing all my doodling. Let's see here. I wonder if she in the courtroom. Y'all think she in the courtroom? Because we don't see pans of the actual courtroom. Do y'all think she been in court every day since this happened? You know, since she testified, when we talk about Ariel, we know his parents been in there because they right behind him. Interesting.
Yeah, lights on, shadow awake. What's the move tonight? Sweet pea in the room, yeah, you know the vibe, right? Quick, sharp mind cutting through the noise. Got the whole room laughing when she drops her voice. Eyes on the screen, yeah, she reads the whole room. From drugs to facts, she's ahead of the boom. Not just talk, yeah, she bringing receipts. When Sweet Pea speaks, everybody hits repeat. She don't just show up, she sets the tone. One line from her in the chat's blown. Smart, funny feelings, yeah, that's the code. Main character energy fully in mode. Oh, Sweet Pea, say it louder when she enters the scene. Sweet Pea, got the jokes, got the facts, got the mean. When she talks, everybody leans in. Sweet Pea, yeah, you know she always wins. One line of queen, yeah, she never thinking that's the trend. Say it again, who runs the chat? Sweet pea, yeah, that's that. Sweet pea, yeah, you know she always wins.
Hey Jason, how you doing? All is well here. I think you have to ask us as soon as we get a verdict. I think they should be coming back any minute, y'all. Let's see here. In a minute. I don't know why today I'm like, we start so late today that I'm like, I know tomorrow, if we even get a verdict here tonight, I think tomorrow I'm gonna probably start our stream like early. I think they're probably gonna be doing jury selection for the Fulio trial early in the day. I don't think they're going into the actual trial part. But I got some stuff that we need to cover, some last minute hearings that they had and some last minute motions. So we'll do that tomorrow morning. And if they go into opening statements, then we'll be able to pop back right in for opening statements. But I don't know, this Hawaii trial, even though we don't get them that often, it's like right smack mid in the middle of the day. And then it's in the evening time for everybody else. Or early in the wee hours of the morning. Right? Yeah. Let's see here. Yeah, sometimes my thing, it doesn't keep it on. So yeah, I definitely think that's what we're gonna do tomorrow. I really want to see. I hope they pan out into the doggone gallery because I want to see if she's there. I want her to be there.
All jurors are back in the courtroom. Ladies and gentlemen of the jury, the attorneys will now have their opportunity to give you their closing arguments. Keep in mind, what they say is not evidence, and you're not bound by how they see or how they remember the evidence. You should consider their arguments to you, but again, you're not bound by how they see or remember the evidence. Mr. Garner, are you ready with the state's closing argument?
Yes, Your Honor.
Please.
And for the record, the state is reserving some time for rebuttal.
Understood. Thank you.
A motive, a beating, a confession. Ladies and gentlemen, beyond a reasonable doubt, the state has proven that on March 24th, 2025, Gerhard Konig tried to kill his wife, Ariel. The state has proven beyond a reasonable doubt that Gerhard Konig committed the offense of attempted murder in the second degree. There are two elements, as Judge read to you a couple minutes ago. Element number one, on or about March 24, 2025, that if in the city and county of Honolulu, the defendant intentionally engaged in conduct. Element number two, we'll get back to in a moment, but the conduct, starting with element one, what is the conduct? What did defendant do? First, he tried to push her. That's the first conduct the defendant did. The second, the syringe. He tried to inject her with an unknown substance. And third, the beating with the rock. That is the conduct that defendant engaged in, intentionally. That is the conduct that we are here to talk about for the last several weeks and for today. The second element, that conduct, under the circumstances under which defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Konig. So element number one, simple, it's conduct. Element number two defines what that conduct is, what it's meant to do. And the conduct in this case was meant to kill. The intent behind each one, plan A, the push, the intent was to kill. When plan A didn't work, the defendant moved on to plan B. Plan B, inject her with the syringe, knock her out, push her off the cliff. The intent behind plan B was to kill. Plan C, when the first two plans didn't work, beat her with the rock, knock her out, drag her over, or just simply kill her outright. The intent behind every single plan was to kill Ariel. Every plan, every backup plan ends in Ariel's death. The substantial step starts with the plan. The plan's in yellow because it's not a substantial step yet, it's just a plan. Next, the hike. Again, it's in yellow because he hasn't taken that last step. That last step to show he's committed to carrying out that plan, that shows he's committed to killing Ariel. The first time you get that is with the push. When the defendant takes his hands, tells Ariel, I'm sick of this shit, and tries to push her back off the cliff. That is the first substantial step the defendant took. That didn't work. Ariel went to the ground. Ariel protected herself. The defendant took the next substantial step. He took that syringe out and he tried to inject her. But Ariel fought back. Ariel fought back, fighting for her life, knocks the syringe away, and then the defendant moves on to plan C, his third substantial step, where he takes that rock, exhibit 2, this rock right here, the same rock that you've all held, he takes this rock and he beats her with it again and again and again and again. Those 3 steps are the substantial steps the defendant took to carry out his plan to kill Ariel Konig. Before we get any further, what is not a defense? The result of the defendant's conduct. The severity of Ariel's injuries, you'll hear many times trying to minimize them. That is not a defense. The law treats somebody the same, whether they're successful or not. The law treats you the same no matter how good you are at executing that plan, no matter how good you are at actually succeeding in killing somebody, the law treats you the same. As an example, somebody who tries to shoot somebody, who points a gun and tries to end a life, but misses, they've committed attempted murder the same way the defendant committed, in a similar way, in a similar idea as the way defendant did it in this case. You cannot look only at the results to determine intent. You have to look at everything together. And when you look at everything, it shows one clear answer beyond a reasonable doubt, and that's that the defendant intended to kill her. Let's review how we got there. First, we have Ariel's testimony, and she testified in 3 different areas. First, Ariel told you what happened on the Palipuka Trail on March 24th, 2025. She told you what happened when she went up the trail. She told you how she was afraid, how she was nervous about the heights. She told you how the defendant reacted. She told you what happened when she met up with the defendant later, that he pushed her, that she went to the ground, that he took the syringe, that she fought back, and then ultimately he took that rock, this same rock, and hit her in the head again and again. Then Ariel told you what happened leading up to that day. She told you about their marital issues. She told you about her messages with Jeffrey Miller. She told you all of that. Embarrassing as it may be, she put it all out there. And then Ariel told you about her treatment, her medical treatment, her recovery. She showed you the scars that she carries to this day. She showed you the scars on her head where she will never grow hair again. And everything that Ariel said is corroborated. These are the credibility factors. These are listed in your instructions that you should be considering for every witness who testified. And I'm not going to go through all of them right now, but there's a couple that are relevant for Ariel here. First, appearance, demeanor, intelligence, candor, frankness. Ariel testified in a straightforward, coherent manner. She testified clearly. There were no histrionics, barely any tears. It was straightforward. This happened, then this happened, then this happened. It was not over dramatized. It was not over exaggerated. It was straightforward and simple and coherent. She was open to cross-examination. When the answer was yes, she said, yes, sir. When the answer was no, she said, no, sir. And when she didn't know, she said she didn't know. But the last factor is the most important here. The extent to which Ariel's testimony is supported by other evidence. What this means, simply, is corroboration. What level of corroboration is there? There is a lot. Ariel is corroborated by the physical evidence, the scene and location, the rock, the blood evidence, the injuries, the medical supplies. Ariel is corroborated by the digital forensics. What was going on in the defendant's computer corroborates what Ariel said. Ariel is corroborated by the other witnesses, by their sworn testimony, by Emil Konig. Ariel is corroborated by Amanda Morris. She's corroborated by Sarah Buxbaum. She's corroborated by HPD. And in the most important ways, she's even corroborated by what the defendant told Emil. You've seen the photos of the scene. Ariel's testimony is corroborated. There's the cliff. It's right there. There's the bloody, the blood pool in the bush where the defendant was on top of her, where the defendant was hitting her. The physical evidence of the scene, the blood, the crushed plants, the location of this so close to the cliff edge, all corroborates Ariel. The physical evidence, the rock, corroborates Ariel. You've held the rock, you've seen it, you know how much it weighs, you know how sharp it can be on the sides. You've seen the photos of Ariel's blood and Ariel's hair on that rock. The rock corroborates what Ariel said. The DNA evidence. The DNA evidence shows two things very clearly. One, every single sample that was positive for human blood had a likelihood ratio of over 1 trillion for Ariel Konig. Every single one. The blood on the rock, the blood on the samples from the trail, the blood all over defendant's shirt and shorts. Every single one had a likelihood ratio of over 1 trillion for Ariel. Reason and common sense tells you all of that blood is Ariel Konig's, not the defendant's. Second, Ariel Konig's DNA was on both sides of the rock. And think back to how Ariel demonstrated what she did. She held up her hand. She held up her hand trying to block the defendant. She suffered defensive injuries from it on her fingers, on her thumb, and that's how her DNA is on that rock. Because she touched it. Her touch DNA is on the rock because she touched that rock to try and stop the defendant. The search warrant of defendant's work bag on Maui corroborates Ariel's statement. It shows clearly, conclusively, that defendant had actual possession. Not as some sort of theoretical, oh, he's a doctor, he can get this stuff. No, he had actual possession of syringes, he had actual possession of vials, he had actual possession of drugs that can kill. This isn't some, he could have gotten them, he had them. This corroborates Ariel's testimony. And more importantly, these drugs weren't stored in a controlled environment. They were stored in his home where he had access. He could take them, didn't have to log them or anything, just remove them from his home and do whatever he wanted with them. This corroborates Ariel as well. Lastly, Ariel is corroborated by her injuries. The physical evidence of Ariel's injuries corroborates exactly what she said. Think of the injuries to the top of her head. The stellate laceration. Dr. Grosstein told you there was debris throughout the entire injury. There were rocks. The defendant swung this rock so hard that pieces of rock broke off into Ariel's scalp. There was dirt throughout the entire laceration. And the middle of Ariel's scalp, he described as macerated or crushed. Went all the way down to the bone. You've seen the photo of Ariel from the front. You've seen what's missing from her head. You've seen that there is a chunk of her scalp that is gone. It's right there in that photo. And you've seen that she didn't just have scalp injuries. She had injuries above her eye. She had injuries below her eye. She had injuries to her hand, not even to just her thumb. Her thumb was only where there was a break, but she had injuries to 3 of her fingers, her thumb, her index, and her middle finger. Ariel's testimony is corroborated by the physical evidence in this case. Ariel's also corroborated by the digital forensics, the digital evidence. The digital evidence tells you what defendant was thinking, what he was thinking from December 2024 to March 2025. It shows you that, first of all, it confirms the motive. It confirms the strong motive defendant had to kill because he was looking up infidelity. He was looking up Ariel's financials. He was looking up his prior divorce. He was going into Ariel's hard drive to look up documents on her computer or from her computer about divorce. He even went to the point where he was buying a spy device to spy on Ariel. This shows what was going on in defendant's mind. It wasn't some simple research. It wasn't taxes. It wasn't self-help. It was obsession. It was an obsession with Ariel. It was an obsession with infidelity. It was an obsession with going over those financials, and it was a plan for divorce. The second thing that the digital forensics shows, most importantly, it shows defendant's familiarity with that hike. It shows you what the defendant looked at before deciding the Polypuka Trail is the hike that he should be taking Ariel on. It showed the defendant this picture right here. It showed that the defendant was only interested in difficult hikes. Easy hikes were not for him. The defendant wanted difficult hikes, steep trails, big drops, narrow trails. This is where the defendant wanted to take Ariel. This trail, about a foot wide, somewhere around there. One push is all it would take on this trail. Nothing for her to grab onto. One push, and it's a tragic accident. That is what the defendant was researching. He knew that this trail was not popular from his research. He knew that 99% of the people wouldn't be going on this trail. And he knew that this is where he could execute his plan. And he didn't share this with Ariel. He didn't share this website with her, so she could make that informed decision before she went on that hike with him. She had no idea what kind of trail she was getting into that day. Lastly, Ariel is corroborated by the other witnesses. Ariel is corroborated by Amanda Morris. Amanda Morris, the first person on the scene. Amanda told you the sequence of events. 3 things. First, she heard a woman's voice screaming, "Help, help me." And she gets up the trail because she thinks somebody's fallen off. She knows it's dangerous, she thinks somebody's fallen, and she sees the defendant over Ariel. Amanda sees the defendant over Ariel. She sees the defendant with this rock in his hand, and she sees the defendant hit her. And when she sees that, Ariel cries, "Help, he's trying to kill me." And Amanda sees how the defendant responds. How the defendant responds is nothing. He just looks at her. Ariel's also corroborated by Sarah Buxbaum, the second woman on the scene, the second hiker who intervened. Sarah came in behind Amanda. She saw the defendant standing over Ariel. She saw the defendant standing with that rock. And most importantly, Sarah looked the defendant in the eye. Sarah made eye contact with the defendant and told you how that made her feel. It made her feel unsettled. It made her feel so afraid for herself and her safety when she was looking at the defendant in the eye. It made Sarah feel so unsafe that she and Amanda went back down the trail before they called 911 because they realized this was a dangerous situation for them. They realized after looking in his eyes what could happen to them. And they took those steps after seeing what was in the defendant's eyes. After seeing that look, they took steps to protect themselves. Listen to Sarah's voice on that 911 call. It's Exhibit 3. You'll have it. Listen to her voice, and you can hear what she's thinking about. You can hear the worry in her voice. You can hear that she's afraid for her own safety after she's seen the defendant. It's all there. And you may hear argument today or have thought, maybe you thought to yourself, well, Amanda and Sarah only saw the end. The evidence shows that Amanda and Sarah didn't see the end of the incident. They caused the end of the incident. Because when they showed up, that is the only thing that stopped the defendant. Ariel screaming for help didn't stop the defendant. Ariel fighting back for her life didn't stop the defendant. The only thing that stopped the defendant, the only thing that was enough for him to stop, is two eyewitnesses coming up on the scene and seeing him beat her with that rock. The only thing that got him to stop was being caught red-handed. The responding officers, Corporal Wu, Corporal Chun, they corroborate Ariel as well. They showed you the hike. You saw the hike on their body cam. You saw their struggles with trying to get up the hike. They showed you the scene. Once more, right there in the foreground of this photo, that's where this happened. That's where the beating with the rock happened. And right there, just a couple feet away, that's where the defendant tried to push her. They showed you Ariel's condition. Ariel's condition immediately after the defendant did this. They showed you that. They showed you the closest thing to what the defendant last saw Ariel as. And they even caught it on their body cam. They even caught Ariel's condition as she states her name.
Ariel Konig, J-R-I-E-L-L-E. Birthday is March 24th, 1989.
You heard Ariel testify for hours. But also, you heard in this video her slurred voice, her heavy breathing, her condition after the defendant beat her with that rock. She was not okay. The manhunt corroborates Ariel as well. It took 3 different agencies, HPD, DLNR's DoCare, HFD, several different units from them, SED, SSD, a canine unit, the major events unit to search with drones. It took 2 drones, 1 helicopter, and after 8 hours, or almost 8 hours, they were still not able to find the defendant. And that tells you one incredibly important thing. The defendant did not want to be found. The arrest corroborates Ariel just as much. Officers Nicola, Koki, and Borges approached Ariel in their vehicle. Officer Nicola testified he got within an arm's reach of Ariel, or I'm sorry, of the defendant before he jumped out the car.
Objection, misstates his testimony.
He got within an arm's length or close to an arm's length before he got out that car and tried to apprehend the defendant. He identified himself as police. And how did the defendant respond? The defendant tried to flee into the woods. It took a total of 835 pounds of HPD officers to subdue the defendant. That's how much he was resisting. He knew they were police. They identified themselves as police. And as Officer Nicola testified, the defendant, in his attempt to get away, fell on his face, and then Officer Nicola fell on top of him. That's why you see the grass on the defendant's head. That's why you see the dirt on the left side of the defendant's face, because that's where he hit the ground. That's where he hit the ground while he was being arrested. And the defendant's own actions finally also corroborate what Ariel told you. Defendant's actions corroborate Ariel's testimony. First, he fled the scene. Second, he collected the evidence from the scene. He collected Ariel's phone. He collected Ariel's purse. And he collected those syringes. He took all those items from the scene and he disposed of them. Ariel's mom still tried to ping her phone, and it was up at the poly hours later, but they could never find it. And think back, where the police, where DoCare couldn't search. They couldn't search the bottom of the cliff. They couldn't get down that way. They searched the whole mountainside, couldn't find it, but the bottom of that cliff that's several hundred feet tall, that's where they couldn't search. Defendant confessed. Defendant called Emil just minutes after the incident and told Emil, I tried to kill Ariel, but she got away. And lastly, the defendant hid in the woods for almost 8 hours. These actions that the defendant took corroborate what Ariel told you. They make sense. That being said, the defendant in this case has testified. And you need to judge his testimony the exact same way that you judge anybody's. At the beginning of this trial, you heard a theme, some alliteration with a theme, unwilling or unfaithful, unwilling, untrue. But ladies and gentlemen, after listening to the defendant's testimony, you only need one word to summarize it. One word. Unbelievable. The defendant's story. She started an argument. The defendant's story is that somehow Ariel, on her birthday, on an unfamiliar hike next to a massive cliff, decided to start an argument. Does that make sense to you? No. Ariel decided somehow to start an argument about she said she wanted to go back and continue to work with Jeff Miller. She wants to travel with Jeff Miller. Does that make sense that Ariel would bring this up on that cliffside? No. It contradicts common sense. It even contradicts the defendant's own testimony, where he told you they don't talk about this outside of counseling. The defendant told you that, and that's what worked for them. And somehow Ariel's bringing it up, ruining her birthday on a hike. Ladies and gentlemen, it's unbelievable. The next part, the defendant's story. She pushed me. The defendant says he felt a hard push from behind, that he was looking out over the cliff. He barely holds himself on. He turns around, and Ariel's already 5 to 10 feet away. Ladies and gentlemen, unbelievable. Ariel was trying to push him off that cliff. She wouldn't be that far away. She would have been right behind him, trying to push him again. Defendant's story. She pulled me down on top of her. Think about how that makes sense. Defendant's story is that then he approached Ariel, that he grabbed her arms, and Ariel somehow responded by pulling him down on top of her and not letting him go. Defendant's bigger than her. Defendant's stronger than her. Ask yourself, what person would hold a bigger, stronger person on top of them as an act of aggression? It doesn't make sense. It's unbelievable. Defendant's story, she hit me first. Somehow while Ariel's sitting down, or while Ariel's underneath him, while he's in the position of power, while he's on top of her, the story is that Ariel held him down so he couldn't escape, grabbed his genitals, wrapped her legs around him, and then she picks up a rock and hits him in the face. And as the defendant told you, he said, she hit me one time really good, and that she keeps swinging. The same rock that defendant used to beat Ariel? Really? The same rock that defendant has told you he only used 2 times, that he only hit her twice with. Ladies and gentlemen, unbelievable. The same rock, no. You can tell it's different injuries. This is the photo of the defendant immediately after his arrest. This was the photo of the defendant almost 8 hours after the incident up on the trail, after the defendant tried to kill Ariel. Yes, there's a small dark spot on his cheek. Is it a bruise? Is it dirt? I don't know. This is Ariel. The idea that this same rock caused these different injuries is unbelievable, ladies and gentlemen. The idea that Ariel could hit him really good, and that's it, is unbelievable. This is the defendant at the hospital that night, and this is Ariel at the hospital on the same day. Again, minor bruise, major laceration. The idea that these injuries were caused by the same rock, completely unbelievable. You can only see that by looking at the next day. Look at the defendant 1 day later. There's nothing. There's no more. Ariel's got her head wrapped up. She's still got these injuries on her eye. The defendant's story is unbelievable. And lastly, the defendant told you that he wanted to turn himself in, that that's what he was doing when he left the trail. Sunset was coming soon. The sun was getting low. But instead of doing the logical thing and walking down the trail where he knew the police would be, the defendant decides he has to come out of the forest onto the road. The defendant doesn't go back to the trailhead. He doesn't put his SIM card back in his phone. He doesn't turn his phone on because he's not trying to surrender himself. He's not trying to turn himself in. He's trying to escape. And that's why he ran when the police apprehended him. That's why he resisted. The defendant's story, unbelievable. The defendant's story, unlike Ariel's, where Ariel is corroborated, the defendant's story is filled with contradictions. The defendant is contradicted by Amanda and Sarah. Somehow, Ariel finally let go of his private parts, and then he just stands there and looks. He's not on the ground writhing in pain. Does that make sense? He says that she held on so hard that he couldn't escape. Does it make sense that afterwards he would just stand there and stare? No. The defendant is contradicted by the physical evidence. He's contradicted by the fact that there's no blood of his up there. There's no evidence of injuries that support what defendant says happened. He's even contradicted by his own hired doctor. The defendant told you he hit her twice. No more. But even his own doctor said 2 to 3 hits to the scalp. Hits to the face. Hits to the fingers. So even the defendant's own witness shows that he hit her more than twice. He hit her Add them all up. 4, 5, 6, could be any of those times. He hit her again and again and again and again. And he only told you 2 times. Ladies and gentlemen, it's unbelievable. He told you he removed his SIM card with a paperclip. Well, state 72 through states 86, that's all the photos. That's all the contents of defendant's backpack. Where is that paperclip? He could have just as easily used that syringe. Open his SIM card, dispose of the syringe. Hiding evidence 2 ways at once. The substantial step again. He made the plan. He made the plan to go hiking that day. He didn't share with Ariel what hike they were going on. He didn't share the details of that hike with Ariel. He didn't share the dangers of that hike with Ariel because his plan was to push her off that cliff. So they start the hike and Ariel deviates from the plan. Ariel doesn't go up to that section from the photo, the super narrow section with no trees. Ariel doesn't want to go up there. So the defendant improvises. The defendant takes a different cliff. The defendant sees his last chance when they take this selfie, his last chance before they get to that lower part of the trail. And he takes it. He takes that chance to try and push Ariel off. He takes that chance. He makes that substantial step. And plan A, the push doesn't work. Ariel falls to the ground. He can't push her off anymore. So he takes that next step. He pulls out the syringe. Plan B. He tries to stab her with it. Plan C, when that doesn't work, he takes that rock and he hits her well over 2 times. He hits her again. He hits her again. It doesn't matter that she's blocking. It doesn't matter that she's screaming. The only thing that gets him to stop is these 2 women who walk up. That's it. You have gotten instructions about self-defense. It should be clear. The defendant was using deadly force in this case. This rock is known to the defendant to cause death or serious bodily injury. You don't need to be a doctor, although he is. He's actually treated patients who've had rocks fall on them. So the defendant is well aware of the damage that he was doing. He's more than aware because it was his intent. It was his intent to cause that damage. It was his intent to cause death. So yes, it is clear the defendant was using deadly force. And because of that, self-defense doesn't apply. Or self-defense does apply, but defendant cannot claim it because he was the initial aggressor. He was the one who started the physical altercation. He was the one who used deadly force. And lastly, he had a duty to retreat. When using deadly force, before you use that deadly force, the law states you have a duty to retreat. And the defendant didn't do that.
Incomplete statement on the law.
Objection overruled. Ladies and gentlemen, the court instructed you on what the applicable law is. You need to follow the court's instructions as read out to you and as it's provided in the jury instructions that you have.
The defendant did not follow the law. The defendant attacked her. Self-defense is not applicable. The state has disproven it beyond doubt because the defendant was the initial aggressor. The defendant was the first one to use force. Based on these facts, self-defense is not applicable. Next, you're given instruction on extreme mental or emotional disturbance. This is a long instruction. We'll keep it simple. There's no evidence that the defendant was acting under extreme mental or emotional disturbance when he tried to kill Ariel. Don't be confused by his testimony. He did say he was under severe emotional distress, but he said that after he tried to kill Ariel. He said he was under severe emotional distress after he started to think about how this would affect his job, how this would affect his life. He was under severe emotional distress after he began to think about the consequences of his actions and how his actions would affect himself. That's what that is. The defendant was not under extreme mental or emotional disturbance when he tried to kill her. He only became that way when he began to think about the consequences. The second part of that instruction states that the defendant's self-control, the defendant's logical thinking is important here. It shows the defendant, when plan A didn't work, he moved to plan B. When plan B didn't work, he moved to plan C. And when he got caught, he fled the scene, he hid the evidence, and he hid himself. That shows the defendant was using logical thinking. The defendant was solving problems as they came. He was not acting under extreme mental or emotional disturbance. Okay. You got a list of other included offenses. You got a list of a bunch of assault charges that are included in the attempted murder and second-degree charge. When you think about those, just think one thing. He did more. This is what he did. Assault in the third degree, causing bodily injury. That means physical pain. He did more. He did more than cause physical pain to Ariel. Assault in the second degree. He did more. Yes, the defendant caused a major laceration to Ariel's head, or severe laceration. The defendant caused a bone fracture to Ariel's thumb. Yes, he did those things, but he did more. But he did more because he was trying to kill her. Attempted assault in the first degree, same thing. Defendant took actions that he knew would cause a substantial risk of death. Yes, but he did more. Because the evidence all shows that the defendant wasn't intending to do an assault. The defendant was intending to kill. All right. 3 things: motive, a beating, and a confession. You've seen through this trial the defendant's motive. He was upset. He was angry. Wherever he turned, Ariel wasn't being punished. First, he talks to Ariel's best friend, tries to air the dirty laundry. But the best friend stays on Ariel's side. Deanna stays on Ariel's side. She's not punished. Then he emails Andrea Miller. Giving this other woman Ariel's personal contact information, her cell number, her personal email. But Andrea Miller never responds. Ariel's not punished. And then he goes to counseling. They go to marriage counseling. And instead of focusing on the affair, what do they focus on? These intimacy issues, these issues that Ariel testified about, these issues that were defendant's fault. Everything the defendant tried to do made sure Ariel was never punished. So he did it himself. Every response defendant had to this emotional affair showed the defendant's need to control Ariel. He wanted to control where she lived. He wanted to separate this woman from her 18-month-old child. That was his response. His response to finding out was, you should move out. He wanted to control her job. He wanted her to quit. He wanted her to be dependent on him. Because once Ariel quit her job, it's much harder to divorce. She has no more income. She can't go find another remote worker, nuclear engineer job. The defendant knew how much a divorce would cost. He was looking at his own documents, his own records from his prior divorce. He was looking at his own records that showed how much he paid in his prior divorce, because that's what he was thinking about. He was doing that math. He was doing that math on what it would cost to divorce Ariel, what he would give up. And he just couldn't stop thinking about it. He couldn't stop thinking about this emotional affair that he's built up in his head. And because he couldn't stop thinking about it, he made a plan. He made his plan to kill Ariel. The beating. Plan C, the third substantial step, the one that's the most visible, the one where she got these injuries. The defendant took the rock. He picked it up. He swung at Ariel again and again and again and again and again. That many swings shows that the intent was not just to hurt. It was not just to defend. The intent was to end her life. That's what the number of swings tells you in this case. Ariel's only relief, the only thing that stopped him, was the defendant being caught in the act. It was the intervention of Amanda Morris and Sarah Bucksbaum. That's it. So we end with the confession. 10:42 a.m., just a couple minutes after this happened, the defendant calls Emil. It's a video call, not a phone call. So Emil could see what the defendant was saying. He could see the defendant's face. He could see the defendant's mouth moving. There's no gray area with this confession. As Emil testified, he has no doubt about what the defendant told him. There's no phantom gust of wind that came up. There's nothing like that. The defendant confessed to Emil. He told Emil that he tried to kill Ariel. He told Emil why. He told Emil that Ariel got away. He told Emil that Ariel was having an affair. That doesn't sound like a goodbye suicide message, does it? He told Emil that he was at the end of this rope. And think back to the last thing that the defendant told Ariel before he tried to kill her. He told Ariel, I'm sick of this shit. That's corroborated that he's at the end of his rope. Same idea. What didn't he tell defendant? What didn't the defendant tell Emil? Nothing about self-defense. Nothing about Ariel attacking him. Nothing about what he testified to you. Is that reasonable? Does that make sense? No. 10:42 a.m., the defendant FaceTime video calls Emil. He confesses. And Emil's next step, after being put in that situation, after being put in a situation as a 19-year-old that he had no want to be part of, Emil does what he does. He goes and tells his grandparents. He goes and tells them what the defendant said. And Judith Mast, ends up texting the defendant, 11:33. She texts the defendant, is Ari okay? She asks the defendant about her daughter. And the defendant says nothing. He doesn't respond. But what he does do shows his intent. What he does do, he calls Emil again and he asks him, did you tell anybody? That shows the guilty conscience of the defendant. That shows that the defendant was not acting in self-defense. That shows the defendant was thinking about what his actions would do to himself. He was thinking about himself. He wasn't thinking about Ariel. He wasn't thinking about her condition. It was only himself. So, ladies and gentlemen, there's one verdict and only one verdict that does these things. There's one verdict that holds the defendant accountable for what he intended to do, for what he tried to do to Ariel. There's one verdict that's supported by the physical evidence, the digital evidence, the corroborated testimony of witnesses, and the defendant's own confession. There's only one verdict that's corroborated that makes sense with all of that. There's only one verdict that the evidence and justice demands. And that verdict is that you find the defendant guilty as charged of attempted murder in the second degree. Thank you.
Thank you, Mr. Gardner. So, ladies and gentlemen, this is our second morning recess. Ms. McCallum will get you, I'll just say 11:10. We'll reconfigure the courtroom during the recess. We will come back. The defendant will have the opportunity to present the closing argument. All rise.
Wow. So there we go, guys. I think the opening his closing statements were great. Oh, but okay. Now that the ambulance didn't pass, I can get back on the mic. Mic check, 1 2 1 2. Yeah, so I definitely think that his closing was good. Like he pieced it all together. No, it was not this, it is this. I seen that a lot of stuff Mr. Konig didn't believe in because he was over there shaking his head like no, 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 no. You know, and their youngest child was 18 months at the time of this incident happening. He wanted to actually get her out of the picture, get her away from her 18-month-old son, her other son. Like she just had like these baby, her baby wasn't even 2. Not even 2 at the time. Yeah, so I don't know what the defense is gonna have come up in regards to their closing, but we do know they're probably gonna do the rebuttal. They probably gonna say he had lost all his marbles. I think they're gonna go with the emotional aspect of saying that he was just out of his mind. He couldn't take it. He was distraught. His wife was having an emotional affair, not a smexy affair, but an emotional affair. She wasn't even sleeping with the guy, which is weird to me. I don't know what you do with that. It's like complaining because somebody played a game all day or something. Like people better be careful what they complain about because it could be so much worse than what it is. But JJ face, dang. I just look up and I see that OnlyFans and put that. What is you talking about? But J face, what? Whoa. Yeah, he said he wanted to leave 15 minutes for his rebuttal. I didn't think that's how they was. I didn't know that that's what they were going to do. So I wonder if the defense can only do 45 minutes. Oh, that's interesting. Oh, we got another South Cal in the place. Barbara Littlejohn. We got a lot of Callies in here. A lot of Ireland. We got a lot of UK. Wow. Okay, so CCG TV, you say the defense still gets an hour, but he'll get his rebuttal also. So state 45 minutes, defense an hour, state come back for 15 minutes for rebuttal, and then the defense gets to come back for another rebuttal for 15, 20 minutes. The defense can get a rebuttal if they want a rebuttal. Where y'all getting no rebuttal for the defense? No, that's not the case with this one. Oh, y'all must not been here when the judge was talking. The judge offering them a sir rebuttal, y'all. Okay, so some of y'all must not been here when the judge was talking to them. So just for y'all know, the judge stated, oh yeah, well, I'm telling y'all they get a sir rebuttal. Trust your sweet pea. So the judge offered the defense a sir rebuttal if they are presenting evidence in regards to the defense of his emotional state or his affirmative defense, right? OnlyFans. So in this case, y'all, they do have a sir rebuttal. It was another case that we watched that had a sir rebuttal, and we was like shocked. I can't remember what case it was, but yeah. So this one, if they do that in their closing, if that's what they're going with. So that's why I was asking, like, when the defense goes up and do their initial closing for 45 minutes, Is it going to be an hour or 45 minutes for this one? Yeah, this case is like different anyways. Like Derek, remember they actually rested the last time we were in court on last Thursday, and then today they was like, we don't want to rest, we want to reopen and call some more witnesses. We was like, what? So we actually had a witness that was there last week actually come back and they reopened it. Yeah, I couldn't remember what it's called the way they got it because of that affirmative defense. Okay, so you say it's 45 minutes then. Okay, so because I was like, well, dang, that really means the state. So it looked like the defense will have the last word. Donna said, thank you for the super chat, Donna. She said, what do y'all think about the lawyers in this case? Well, I like Doogie Howser. That's what he remind me of. And now I'm talking about the state attorney. He remind me of Doogie Howser. And then far as the defense attorney, he just reminds me of, he know his stuff because when he was trying to fight that one evidence in regards to that technology coming in, like they had to, that was that could have been a big game changer. But he just remind me, he just seemed like he like a little Sparky from the Canero trial for me, but he not getting a whooping all the time. Like the lady in the Canero trial, she just got a whooping every time she opened her mouth to the judge, but she didn't know what she was talking about. But I do think this guy, they trying to really plant the reasonable doubt. So I don't mind the defense. I know a lot of people are saying, different things about the defense, and I think a lot of us do that in a lot of our cases, beat up on the defense, but that's the job of the defense. The defense is supposed to be the defense. So no matter what we like and how they doing, they got to defend their client. So I'm good with the defense. I think he good. Look, there we go. Knew it. SD. I don't like the defense lawyer, Donna. Why you don't like him? Why you don't like him, SD? Claire said, Derek, I'm inclined to agree with you there. Mad stuff. I knew as soon as I say I like the defense, somebody's going to say it. Leah said, thank you for your support, Donna. Defense men fighting the uphill battle, the entire case, but they always fighting the uphill battle, right? So when they attack certain witnesses and when they do certain things, I'm not mad at them. Look, I'm gonna tell y'all, who was that attorney? I want to say, I don't know if it was the attorney in I can't remember what case it was that we was watching recently, and the attorney was like going all in. And I'm like, dang, if I ever catch a case, I want that attorney's number. You say his voice is annoying. Oh gosh. I don't like how he talks to the judge. I think that okay, I can see that. I can see that, Billy. I can see that. I can see that, like aggressive, like with some authoritative. Like I can see that. I can see that part. I ain't think about you, SD. His voice is annoying. I think the defense lawyer is really smart. I'll bet he's expensive. I think he probably a PD. I think he probably a public defender. Maybe or maybe not, because he is a doctor. He do got a bag. He do got some money. So maybe not. Maybe he do got some money that he was able to pay him, or his parents, because his parents seem like they well off too. Picture of the injuries to her head was it. Oh, that's what you say. That was it. Yeah, Derek. See, I didn't find him guilty until his son testified, and then I was done. Billy said he arrogant and rude. I watched some of the motions, and he kept talking over here on Yes We Pete. He said aggressive. Yeah, I think and they be just trying so hard. I think they be trying so hard any way they can in order to get their client off and get their point across. That's why sometimes you'll see them with the theatrics, raising their voice. But I got to think of who that one attorney was that I was just like, everybody hated that defense attorney, and I was in love. Okay, here we go, guys.
We want to take objections to the defendant's proposed closing slides.
Yes, Your Honor. The first is on slide number 14 on page 5, where the printout that defense counsel handed both of us. It's a slide that says examples of deceptive behavior. I do believe this is impermissible argument that is essentially stating that Ariel has been deceptive in the past. It's an argument that is trying to make a 404 argument that says that she is deceptive now. That is the one reason under HRE 404 that you cannot use prior bad act evidence for. It is explicitly stated that you are not allowed to use prior bad act evidence to show conformity therewith. And that's exactly what this slide is attempting to do. So we'd strenuously object to introducing this, using this slide, using this argument that is against the rules of evidence. It's asking the jury to consider something evidence for an inadmissible purpose. So I do believe that's not appropriate. And that's the first objection.
We'll start with Mr. Siriato. Mr. Otake.
Your Honor, obviously her credibility is at issue, and there's been multiple examples in this case that has come up in the evidence about deceptive behavior, and it is critical, obviously, that we be able to point that out. So I've never heard of, we can't point out in closing how a complainant has been deceptive or dishonest. I mean, he just spent half an hour saying how Gerhard was dishonest. So obviously that's fair game in any closing argument.
The issue is not commenting on the evidence. It's inviting the jury to not follow the law. That's the issue here. They are allowed to comment on the evidence that was introduced at trial, and I understand that. But what this is asking is not that. It's asking the jury to consider this evidence as, again, under the only improper purpose under 404B, conformity.
State's objection is overruled. You will be allowed to argue the complainant wins his credibility. It might be inadmissible under 404 with no exception of 404B. But there is the avenue of admissibility to have credibility with specific instances of conduct in those 608. So state's objection is overruled.
The other objection from the state is somewhat throughout the defendant's proposed closing argument. There appears to be snippets of transcripts, and they appear to have been, some of them highlighted, some of them not. As the court and everybody here is well aware, the jury will not have transcripts available when they go into deliberations. They won't, and these transcripts are purported to be of the testimony during the trial. So they're not transcripts that were identified as exhibits and introduced into the trial. They're transcripts of the testimony of the trial. Everyone's aware the first question the jury always asks after going to deliberations is, can we have a transcript of the witness's testimony? And the answer is always, transcripts are not available. So it's not fair to the jury. It's to put these essentially unmarked exhibits into the PowerPoint. It does give undue weight to what that is, especially consider the jury is instructed to remember the evidence on their own rather than what a court reporter may have written, that it essentially gets around that instruction that the court gave to the jury. It puts undue weight on only these portions that the defense wants to put weight on. So I do believe it's not appropriate for transcripts to be referenced, trial testimony transcripts to be referenced in closing argument.
Can we drill down on that a little bit more, Mr. Garner? The real objection is the form with which they're displayed. Because if it wasn't question and answer, and it was just not even the paraphrasing, if it was just the verbatim testimony without the Q&A descriptions, that would not be objectionable.
That's correct. And that's why putting it in, this format with the new Courier font, when it's clearly a transcript written by somebody else, gives it undue weight. It takes away that.
Sorry, it's not the font. Only we know it's Courier font, but it's the format of the Q&A.
Yes, that's the main reason.
Okay. Mr. Otake.
Your Honor, I've done this in many trials. It's pretty commonplace. I've done it in civil trials. I've done it in criminal trials. We took the time and money to order the dailies, and it's what was said in court. It's the best evidence of what was said. And I'm just, whether it's in that format or another format, it's the same substance. There's nothing improper about doing this. I've done it many times. in many courts, they had the option to order the transcripts and use their government resources to pay for it. They chose not to. And so this is what was said in court. And I'm not taking it out of context. I'm not gonna argue it inappropriately. You know, I'm not gonna, I mean, it's just what was said. It's I don't know if, I mean, what font it's in or what, like, so it is what was said. And we chose to order it and pay for it, and I've done it many times. And I'm not aware of any rule that says we can't do this. So I'm asking that the objection be overruled and we get on with closing.
Anything else you want to add?
No.
The slides with the transcripts, and they are in fact transcripts, there's no dispute about that, are not, they're the actual transcripts as represented by counsel. It's not a misrepresentation of what was said. It's not even a paraphrasing of it. While I'm uncomfortable about the form, at this point in time, I'll overrule the objection to all the cards to proceed.
Thank you, Your Honor.
What has been provided to court will be made part of the record to document the state's objections. It will be court's exhibit 1 for trial.
And Your Honor, I did show the state some demonstratives. If I would like, Dana, I don't believe they have an objection, but it's gonna be facing away from you, so I'll show it to you now.
Please.
This is the first one. Accurately describes page 2 of the instructions. And then, oh, shoot. Darn it. This is the second one.
Mr. Gordon, no objection.
To these two demonstrative aids, no objections.
Anything else we should take up before the jury returns?
No, Your Honor.
Nothing from the state. Actually, can we approach really quick? Sorry. On the record's fine.
Off record?
On record.
all jurors are back in the court. Ladies and gentlemen, thank you very much for your patience. Before we hear from Mr. Otake, the argument that the state made about justice requiring a particular verdict that Mr. Garner made right before we ended is stricken from the record. You are to return a verdict based on the evidence that's presented, or the lack of evidence, or reasonable inferences therefrom, as well as the court's instruction on the matter. Mr. Otake, are you ready to present the defendant's closing argument?
I am. Thank you, Your Honor.
Please.
Good morning, ladies and gentlemen. I want to begin by thanking you all for your time and dedication to this case. Most people serve on juries, couple, 2-3 days. You guys have been here for close to a month now, and I want to just express heartfelt thanks for that. It was your time and doing that made sure that Gerhard got a fair trial. That's what this was about, and we appreciate your time tremendously. You know, we're at the end of the trial here, but I want to actually circle back to the very beginning. The very beginning, jury selection, and remind you guys about that. Multiple days, started off with 200-something jurors, whittled it down, excuse after excuse. People couldn't be here, couldn't be fair, couldn't set aside what they heard, weren't willing to give him a fair shake. And we whittled it down to less and less and less, and we ended up with the 16 of you here. And it wasn't by accident. It wasn't by accident. It's because we saw in you what we were looking for. Jurors that would wait until you heard everything. Jurors that weren't going to convict somebody based off of media reports. Jurors that weren't going to just look at one side of things. Jurors who had logic, reason, and common sense. And most importantly, jurors who had integrity to follow the law on reasonable doubt.
Objection, move to strike. Now this is evidence.
Sustained. Please
So
continue.
I'd like to move to strike the entire closing argument up to this point.
Sustain the objection. Mr. Otake, please continue.
We went through that process. You guys promised us you would do certain things, and we knew that you would. Now, I'm going to walk you through the evidence and the law today, and it'll be clear that there's reasonable doubt all over this case. All over this case. Before I do, he wants to, whole unwilling, unfaithful, unwilling, untrue. We talked about that. He wants to say unbelievable. I'll add another unword. Undeterred. They're undeterred by the evidence. It doesn't matter what it shows. They're going to spin it in their favor. They came up with a theory and they went to search for facts to support it. They didn't look at the evidence and say, what's the theory that points that out? They came up with a theory and they tried to find any fact they could to fit it. They were undeterred. Undeterred by the DNA. The DNA shows, and I'm going to go through it, she's holding the rock. She's a trillion level DNA on the unstained side. Undeterred. Oh, must be because when she was blocking. Undeterred. The computer, I have to call Inuma again to say that sometimes the computer accesses these files. Undeterred. Still shows that he's looking at this credit card statement from 2018 to show that he has a financial motive, that it's cheaper to kill her than divorce her. Undeterred. Undeterred by the fact the eyewitness picks the wrong person out of the photo lineup. And still, she stared at him, looked into his cold, dark eyes, saw him very clearly, picks out the wrong person. Undeterred. Undeterred by the bruise on his face. Or maybe it's dirt. Maybe it's dirt. Evidence should lead to theories. You don't come up with a theory and then search for evidence to spin it to fit your theory. That's what happened in this case. Ladies and gentlemen, I'm going to go through just some of the law initially, and then we're going to come back, go through all the evidence, and then I'm going to come back on some other parts of the law. So I want to start off first by reminding you, as you know, you took an oath, right? You told us that you would give your word that you would follow the law. You'd follow the law, and we know that you will. I want to start, you can follow along in your instructions if you want. I'm just going to start on page 2. Page 2. I talked to you at the beginning about these 3 principles of justice and fairness that keep our system safe for all of us. Anytime the government waves its accusatory finger at anyone, these principles kick in, and it's a safeguard. It's a safeguard, and that's summarized on page 2. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan. Not a mere slogan, but an essential part of the law that is binding upon you. It's binding on you. It places upon the prosecution the duty of proving every element, material element of the offense charge against the defendant beyond a reasonable doubt. Now, I'm a visual learner. I had this chart earlier to help you guys understand how that works. We talked about how the presumption of innocence, you don't start in the middle. You don't start in the middle. It requires that you start here. You start here. It requires that. And then there's a gap, and it's a proof gap. This has to be filled with proof beyond a reasonable doubt before you even step this way. Before you even step this way. If there's no proof beyond a reasonable doubt, you don't move. You don't move. And let's look what a reasonable doubt is. You must not find a defendant guilty upon mere suspicion or about evidence which only shows that the defendant is probably guilty. Probably guilty is not good enough under the law that you took an oath to uphold. What the law requires, ladies and gentlemen, what is required by law before the defendant can be found guilty is not suspicions, not probabilities, but proof. And think about that word. It's a strong word. We don't pay enough attention to that word. Proof. That's a powerful word. Proof of the defendant's guilt beyond a reasonable doubt. That's the law. Probably not enough. That's the law. Again, visual learner, I have a chart to help you with this. This chart summarizes page 2 in a more simple way. State's burden, it's their burden, right? We talked about they brought the charge. Make no mistake, this is not Konig versus Gerhard Konig. This is the state of Hawaii versus Gerhard Konig with their resources, the police force, their computer experts, their everybody. Their burden, state of Hawaii versus him. This is their burden. If they only provide, if obviously 100% you think he's not guilty, not guilty. Probably not guilty, not guilty. Possibly not guilty, not guilty. Maybe not guilty, not guilty. Maybe guilty, not guilty. If you're like, maybe, maybe not. If you're left thinking, I don't really know what exactly happened. Maybe, maybe not. If you're here, not guilty. Possibly guilty, probably guilty, not guilty. That's how high the burden is. It's a safeguard against convicting innocent people. This is what you took an oath to uphold. I'm going to circle back to this, but this is what you told us you would apply. Now, I'm going to go through more of the law later, but just very quickly, the law on attempted murder, the elements are on page 14. Page 14. Before we go through the evidence, page 14. Second paragraph. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. That his intentions was to kill her. That was his intentions all along. That's what they have to show. It goes down, paragraph 1, the elements. The defendant intentionally engaged in conduct. And 2, the conduct under the circumstances as the defendant believed them to be was a substantial step in the course of conduct intended or known to be practically certain by the defendant to cause the death of Gerhard Konig. That's what they have to prove, more than maybe, more than possibly, more than probably. That his intention and his knowledge was practically certain he was going to kill her. That's their burden. That's what they have to prove. We'll come back to this. There is an instruction on self-defense. I'm going to talk about that at the end after we go through the evidence. They are the included offenses. I'll walk you through those as well. But let's now look at the evidence, and it'll be clear there is just massive amounts of reasonable doubt. So the first thing, one second here. this issue about, was this planned? Okay. Was this planned? This big plan, he just went through this motive that Gerhard Konig, you got to know him, that he came up with this plan in late December that it was going to be cheaper to kill her than divorce her. Was this plan? Let's look at the evidence. Is there a reasonable doubt about that? Let's walk you through that. First of all, she brought up the idea of going on a trip to Oahu. That was her idea. Why would that be the plan? If you're planning on killing somebody, you're an anesthesiologist, you have access to, as they fault him for being a doctor, I'm going to get into that a little later, having these things at home that he uses to save people's lives, that your plan is, let me not stay on Maui where there's probably 800,000 less people and more secluded areas. Let me sneak syringes through TSA onto an airplane, come to the busiest island there is in Hawaii, million people, go to a place, a trail, a parking lot I've never been to, that I'm not familiar with, and in broad daylight, 4 minutes from a very busy parking lot, I want to try and kill her. That's the plan. That makes absolutely no sense. Logic, reason, common sense. Why would you do that? The life insurance issue. Well, this is the busy parking lot. So I apologize. You saw this in, this was the plan to come here. With all these cars, all these people, he says 99% don't hike or whatever. He didn't know that. He put in here, this is the plan, according to them, that he's going to come to this unknown place with all these people, all these cars, and try to kill his wife instead of just doing it on Maui. That's the plan, according to them. The life insurance issue. Now, this shows two things. I mean, we're going to get into later about how he told her about it that morning, and she learned that morning if something happened to him, she would get $1.5 million. But it's relevant in another way. If in December and January and February, you're planning to kill your wife, why are you going through the process of obtaining $1.5 million on your life for her? That's not the sign of somebody plotting to kill somebody. That's a sign of somebody trying to work on, okay, look, we got to figure this out for our kids. And if something happens, there's, he's not planning to kill her. Now, the birthday card, he writes this morning. It's the only time she got emotional because she knows it was genuine. And I'm going to talk about that more later. He writes this. There isn't an obstacle in this world too hard for me to fight through for you. I would take on anything just to see your smile. You're one of the kindest, most giving and selfless people I know. Selfless people I know. Putting others before yourself. So much love. You're the heart of our family. Fun, fearless, and a terrific mom. The kids and I hit the jackpot with you. He meant that. You don't write a letter like this because if you're planning to kill somebody 2 hours later. There was no plan. There was no plan. The Fed reservation. He made a reservation to go to dinner that night. He's not planning on killing anybody. There was no plan. This is from that day. They're having a great trip. They had gone through some rough times, but they were making some progress, in part because they weren't really talking about it. And that's why she felt comfortable. I'm not saying she was trying to hook up with Miller again. She wanted to travel for work. And that's why she felt comfortable bringing, hey, we've been making progress, but, I got to travel for work, And then she says, my mom can come with me. That's what Gerhard told you about. So this is them on the trip the day before. This so-called big plan. There was no big plan. Now, why are they committed to saying that there was this pre-plan and financial motive? Well, because of course, it makes no sense anyone would have syringes on this hike unless this thing was pre-planned from earlier. So they have to stick to that, even though it makes absolutely no sense. There was no plan. And I got to tell you, I got to tell you, okay. When they get into the fact that in like December or whenever it was, there's a text message where she's like, are you coming home soon? And he's like, this lady just got hurt on a hike and a rock fell on her. So I'm trying to save her life. The fact that they're trying to say that at that time, the light bulb went on in his head and he was like, I got it. I can kill her on a hike with a rock.
Objection.
I mean, that's ridiculous. That's ridiculous.
And move to strike.
Granted, that's why.
Okay. Well, that's what he was pointing out.
Objection again to improper argument.
Sustained.
The idea that he came up with this plan because he was trying to save a patient's life who was hurt with a rock on a hike is ludicrous. So, ladies and gentlemen, as much as they want to avoid it, as much as they try to talk about witnesses and corroborations, the reality is this. What happened on the mountain before the hikers got there, it is essentially she said, he said. The witnesses told you. They didn't see much. One witness only saw one hit. The other didn't see a hit at all. One of them picks out the wrong person in the photo lineup. Okay. Everything before that, they told you they can't say what happened. They don't know how it started. It's she said, he said. Now, by the way, these witnesses who apparently stood there and stared at him for 30 seconds, looking into his deep, cold eyes, they didn't see no syringes on the ground. You know, the one she says she flicked out of his hand that landed right there? They're nurses. They didn't see that because it didn't happen. The point is, ladies and gentlemen, when it's your burden of proof, it's this high, and it is she said, he said. Your she said better not offend logic, reason, and common sense. Better not offend be contradicted by the physical evidence. Better not be highly motivated. Better not have examples of many times where she was deceptive to the police and to you. And all of those are present with her testimony. I'm going to walk you through that. Now, logic, reason, and common sense. The bottom line is Gerhard Konig is not reliable. She's not reliable. We talk about credibility. The question is reliability. Okay? Logic, reason, and common sense. We don't ask you to leave that at the door. We want you to bring that in here and look at what was said. Let's look at what she said, right? I mean, basically she's saying she wouldn't take the selfie, and then he was like, I'm tired of this shit. Let me throw you off the cliff. And then he tries to stab her with a syringe as he's loading it first, and then he bashes her up to 10 times. That's her story, okay? First of all, the way she describes it makes it sound like he had multiple arms, like an octopus. She says that she's covering, he's on top of her, covering her mouth, and then he has a syringe, and then he's loading he has a vial, and he's loading it, but he's holding her down. Can we approach, Your Honor?
Sure, come on up.
The inference is, why would you have a vial unless you're trying to load it? He has a syringe in his hand. The other hand, he's holding her mouth. He's down on top of her, doing all of this while she's supposedly kicking and fighting. He only has 2 arms. And in the middle of it, they're having a full conversation. Your mom's not going to be very happy if you do this. You know, the kids aren't going to be, you know, her story makes no sense. Now, logic, reason, and common sense as we look at her story, and it is a story, okay? If we look at her story, if this was a big plan that someone's going to bring a syringe to incapacitate somebody and stab them to make it easier to throw them off the cliff, don't you think they would load the syringe ahead of time? Don't you think they would load the syringe ahead of time? Their story is that he's that's the plan. And in the middle of it, he's like, oh, wait, I got to take out this vial and get it ready. That makes no sense, especially given the fact that it's undisputed. He had just gone up the mountain by himself for 10 minutes. If he had it and wanted to use it, he could have loaded it. It makes no sense because it didn't happen. It didn't happen. The other thing, and I'm glad he brought up this thing about plan A, plan B, plan C, because it proves the point I was going to get to. Why in the world, if you bring a syringe to incapacitate someone to make it easier to throw them off the cliff, why would the syringe be plan B? It would be plan A. You would use the syringe first, and then you would throw them off. You wouldn't start the scuffle and make that, start the scuffle and then be like, oh, wait, now I'm going to stab her with the syringe. That makes no sense. It makes no sense that, that's the plan. He knows if something like that happened, he's a doctor, and toxicology report would show propofol in her thing, in her blood, that this is
not an evidence.
It makes no sense that he would start the scuffle before using a syringe if that was his big plan, because it didn't happen. This idea that she could just flick the syringe out of his hand, he's holding it tight, according to her, just flicks it. None of that makes any sense. This idea about, well, he hid evidence. The rock is found right there. We don't know exactly where because HPD should have photographed it before they moved it. But why would he get rid of the syringes and leave the rock? None of that makes any sense. And then, of course, we get into him leaving her on the mountain. Leaving her on the mountain. If this is a big plan to use this hike as an opportunity to throw her off and kill her, why would he walk away and leave her there alone thinking he's going back to the car? And they're trying to say, well, all kinds of things about that. But the reality is this: if you think, even though it's not true, if he went off on his own, because if she said, well, it's too high, I'm getting a little scared, and his plan was to kill her, he wouldn't leave her. He would say, okay, you know what, that's fine, but let's just at least go over here and take a selfie and then try to throw her off, right? He wouldn't have left her for that reason. If he was planning to try and throw her, he would have stayed with her. And then her rationale, it went, to get around the idea that undisputable that she clearly said when he got back, she told the detective that he said, oh, you're still here. He was surprised that she was still there. She says, well, he knew I meant I was going to go exploring in that area. Where was there to explore? We heard from witness after witness. It was you either go up or you go down. You don't go off and go exploring. That was her way to try and cover up that it was clear he left there thinking she was going back to the car, which you wouldn't do if you had a plan to kill somebody by throwing him off the cliff. PSA, we've all been through it. Sharp metal syringe objects, sharp objects, not going to work. Not going to work. Logic, reason, common sense that he has this intent to kill her, but then he lets her crawl away. He lets her go down to the witnesses. Doesn't come after. Doesn't make any sense. Her demeanor. They say, oh, she was very matter of fact and just told it. Ask yourself, if someone's describing what should have been the most horrific thing they've ever been through, bloody murder, someone's trying to stab you with a syringe, a monster's trying to throw you off a cliff. When you're recounting that, you might get a little emotional. Not at all. And she's not just someone who doesn't get emotional, because we saw her get emotional when we showed her the card. When she read the birthday card, she got emotional. I submit to you that was probably guilt, but whatever it was, she knew it was genuine, and she showed an ability to show emotion. That was real. The card was real. You cannot get emotional over a made-up story that didn't happen when you started the fight. Reasonable doubt, logic, reason, and common sense. Now, Ariel's story contradicts the physical evidence. It just does. And this is a huge problem for them. And they try to come up at the last minute with, well, maybe when blocking it, her DNA got on it. But let's talk about that. Because we're talking more than probably, right? He wants to say maybe blocking her DNA got on it. Maybe, okay? But let's use our logic, reason, and common sense and look at the physical evidence. What does Scott Henderson say, the DNA guy? Generally, yeah, you could expect higher likelihood ratios with the more DNA that's present in a sample. The more DNA present in the sample, you can expect a higher ratio, yes? Generally speaking, yes. The more someone's DNA is on the sample, the higher the number. Higher the number. He then goes on, we learn from him and Amarin, that, very important, the rock. Swabbing from the unstained area. There was a stained area that looked like blood, and there was the unstained other side. They swabbed the blood. They tested. Of course, it's Ariel's blood. I told you that in opening statement, right? The blood side was Ariel. The stain side, they don't test for blood. They test for human skin cell touch DNA from people holding objects they told you, okay? The unstained side had a profile for 2 people, Ariel and Gerhard. Ariel's number was 1 trillion. His was 290. Let's go back to what Henderson said. The more DNA present on the sample, you can expect a higher ratio. Yes, yes. 1 trillion to 290. The rock was in her hand. The rock was in her hand. The DNA shows that. That blows away her whole story. That she didn't have the rock. The rock was in her hand. Her DNA is all over that. This idea, well, maybe when she was blocking it hit her, that's not going to lead to that much of her DNA on it, more than him.
Objection, speculation.
If he's holding the rock the whole time and she's just blocking, there's going to be more of his DNA than hers. She was holding the rock, and that blows away their entire theory. Scientifically, I asked Amarin, what about scientific evidence, Miss Amarin? And we talked about it. It's unmotivated. Scientific evidence is not trying to get full custody. His retirement. It doesn't lie. It is what it is. And they may say, well, maybe it was there because of this. Again, maybe, maybe not. A huge reasonable doubt. A huge reasonable doubt. She had the rock in her hand. 1 trillion to 290. Now, the other thing about the physical evidence is the injuries. They want to say, we heard about the stellate laceration. I'm going to talk more about it later. But it has 1 point and it spreads, right? And you heard, she at the end said she doesn't know how many times she was hit. The doctor, Grosjean, said 2, maybe 2. I cannot say how much more. Dr. Arden says 2 to 3. Okay. If she was hit 7, 8, 9 times with all his might, it would be way worse. Physical evidence doesn't support her version of events. Also, if she's under attack, she's going to be scratching, doing biting, as she says. He has no scratch marks, defensive wounds. There's no bite mark on him, even though she said she bit him. The physical evidence doesn't support her story. And that's a huge problem when it's this she said, he said, and this is your burden. That's a huge problem. Further problematic is the examples of deceptive behavior that we saw through her. Many examples of deceptive behavior that makes her unreliable. We heard about her deleting the text messages to hide it from her husband, to hide the extent of a relationship. That is inherently deceptive to do that. That's inherently deceptive. Now, the affair. Look, I'm not the morality police, okay? I'm not here saying she's an awful person because she had an affair. That's for you to decide, okay?
Objection,
The relevance.
improper. And move to strike.
Last argument on morality is stricken from the record.
The relevance of the affair is primarily that she lied about it to the detective. The context is showed in the relationship in January, February, and December, but the relevance is she lied about it to the detective. And that is incredibly important when it is she said, he said, and it's proof beyond a reasonable doubt. Let's look at this. This is, he said, well, she describes it to the detective as just some flirty text messages. He says, well, there's nothing in the text messages about sex. Well, she deleted most of them, so we don't really know what's in there. But we do know what we saw. On the trip, the day before he's going to confront her, this is at 11:22 p.m., presumably Hawaii time, or maybe it's California time, whatever, but it's late at night. She's sending this to Jeff Miller. Jeff Miller is sending her this. They have a nickname for Gerhard, HALEU, which is that radiology nuclear whatever. They call that's I have HALEU. They have a code word to let each other know when he's around. She's listening to an audiobook, How to Help My Spouse Heal from My Affair. That's what she's listening to. He says to her, you're engaged and continue an elaborate secret affair instead of coming to me asking to work on our relationship. And her response is, if anything, I learned how stupid it was this time, and I know how to make sure it doesn't happen again. That's her response. Okay? Now, to the detective, no affair, just some flirty text messages. To you guys, no affair, just some flirty text messages. You saw 12/1, December 1st, all day long on a Sunday. Good morning, all day long, all day long, all day long, good night. And that's how she says it to the detective. She was misrepresenting, deceptive, and lying to the detective. Further examples of deceptive behavior is what she does with her primary care doctor and the records. After the fact, she tells her primary care doctor in an email to add, can you add traumatic brain injury? I want to make sure the documentation is consistent between my care at Queens back here in Mount. And that's the important part. Why is that important? Because, number one, she says she doesn't recall reviewing the Queens records. The Queens records doesn't mention traumatic brain injury. Arden told you that, the two don't you think if traumatic brain injury was in her Queens records, they would have asked Grosjean or Carl Whitney that? It wasn't in there. So this shows she is not just asking the primary care doctor to do this, she's deceiving the primary care doctor into believing that the Queens record said traumatic brain injury. So the PCP will be like, oh, okay, I'll add it. It's deceptive behavior. It's incredibly misleading. Now, she says she's surprised about the work bag. She's surprised about the work bag. Oh, I didn't know. She knew he had it there. She knew there was syringes and vials in there. She calls her attorney. And then they turn it in and say, oh, surprise, look what I found. She knew it was there. She knew it was there. She lied about that. She lied about her affair. She lied to her primary care doctor. There is I really like quotes. So there's an author, famous author by the name of Samuel Clemens. Most of us know him better as Mark Twain. Mark Twain was giving a speech once to some young people about the dangers of being untruthful. And what he said was, you ought to be very careful about lying. Because once caught, you can never again be, in the eyes of the good and the pure, what you were before.
Objection to improper argument.
You guys come in here, you give people the benefit of the doubt. They come in here, you say, I'll hear them out. And then they lie about different things, they deceive. In the eyes of the good and pure of all of you, you can't look at her the same again. It's dangerous. It's dangerous. If she's going to manipulate her PCP doctor, if she's going to be deceptive to the detective, do you think for a second she would hesitate to be that way with you? And then we get into bias interest motive. We talked about this. How she knew a divorce was coming. She wanted full custody, how they're using these allegations against him to get full custody, to make it where he can't ever see his kids again, to get half his retirement, to get all of the house, things that she might not get. She knows that. She said to you that their statement is, we want full custody, but if depending on the outcome of the case, that can be revisited later. She knows the ramifications. Now, let's compare that to Dr. Gerhard Konig. You got to see him. Trust your gut. Trust what you know about people. Is he somebody that is a monster that came up with this plan to stab his wife and throw her off a cliff? Is that the sense you got from him? Or was he a hurt human being struggling with infidelity, but trying his best? They talked about his parents, how they moved from South Africa when he was young. He worked really hard to become a doctor. This, he talks about, oh, she was trying to control everything about her. All of this awful controlling guy. What does she say? Prior to December, you generally describe your marriage as good, right? Yes, sir. This is what Ariel said. You don't describe your marriage as good if somebody is a controlling, coercive, violent person. There's a lot embedded in this. You don't describe it as a good marriage if somebody's, unless they're a good dad. Look, domestic violence is horrible. There's some awful men out there that use their power, control, financial means to control women in improper ways. This is not him. That's not him. She wouldn't say it was a good marriage if he was like that. His version of events, they fault him for wanting to see her phone and things like that. The audiobook said that's what it takes. This is Ariel. I asked you earlier, you understood the audiobooks you're listening to by these professionals says to give up privacy, give up access, get them to trust again. She says, yes, they're faulting him for the professional advice, what is said. He's not trying to deprive her of her career. He's trying to stop her from seeing the guy that she had an affair with. He was fine with her getting another job. That's a very human thing. Why would you be okay with her going back to work with the guy that she had an affair with? Now, he went into detective mode when he found out about the affair. That's a very human reaction. Very human. He was on the computer looking up Reddit and infidelity and getting some advice. It's not easy when your partner cheats on you. He's struggling with it. They're making some progress in January and February because counseling, she turns it not about the affair, but about other issues. But they're making progress. They're kind of heading in a good direction. They go on this hike. And it makes sense that at that hike, she brings up this issue of, again, not that I want to be with Miller, but hey, I got to travel for work. Okay, I got to travel for work. And this is a detail that you just can't make up, right? He says, then when they're fighting about it, she said, well, my mom can come with me to chaperone. He leaves her because they got into a fight, not because she's afraid of heights. She goes on all kinds of bungee jumping hikes all the time. He comes back and he's like, oh, you're still there. He described to you what happened. He's not saying, oh, he grabbed me and pulled me down. The scuffle started on this mountain trail and they ended up on the ground. Whether they tripped or fell, whatever, he ended up on her. And then he told you how she's grabbing his testicles. And she admits to it. And then I also squeezed his testicles. That's her testimony. It was all happening so fast. We spent a lot of time going through it all. That's not real life. In real life, you don't get hours to be like, okay, and then you did what? Well, why didn't you do this? Well, did you consider that? Did you consider doing this with the rock instead? It was happening in seconds, and he reacted, and he had a reflex, and that's human. That's human. That's human. He reacted. And then he felt horrible about it. And he told you about that. He never wanted to hurt her. Never. He felt terrible about it. He was shocked that he could even do that to her in that moment. He felt horrible. The physical evidence supports his story. The DNA, and I'm going to get into the medical evidence a little more in a second. You have this, which apparently might have been dirt. Undeterred, might have been dirt. You have a cut, you have bruising. Right where he said he was hit. Reasonable doubt. Now, the FaceTime with Emil that they call a confession. There's no assurances of reliability. He explained to you what happened in that call. We need to consider it in the context in which it took place and ask ourselves, is this a reliable, thing that happened that we can rely on? Two highly emotional participants in the phone call. One is suicidal. One is thinking his life is over. He's very emotional, calling his son to say goodbye. The other, obviously, not blaming Emil at all, incredibly emotional. His grandma says she was shaking, crying. Two very, very emotional people. Then you look at the environmental factors. He's on the side of a cliff. And they made it a point to get the HPD officer to say, it's very windy over there, notoriously windy. Very, very windy day, according to the police. He's on speakerphone on the side of a cliff talking. And he told you what he did. He was explaining to her, look, she was having this affair. She got hurt. This is her blood. She crawled away or got away. She crawled away. And she said, I tried to kill her. He was telling her that's why he was going to end his life. He wasn't confessing. He was telling her, that's why I'm going to end his life. Now, we know this is his testimony. So as you sit here today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim, word for word, correct? He said, yes. He cannot tell us exactly word for word what was said. And then we have an example of him making assumptions. He first tells the detective, my dad said he tried to push her off the cliff. That's what he assumed. Not blaming him, that's what he assumed. But later on in the conversation, in the interview, the detective asked you about that, and he clarified. He said, the part about her pushing her off the cliff was what you assumed he meant, not what he actually said, correct? He said, oh, yes, correct. So we have an example already of him saying something that he assumed that wasn't accurate. He wants to say, it was so clear at the end of his redirect, he said, without a doubt, I know what was said. Do you recall how he had to try 4 times? The first 3? Emil said, yeah, I was confused. I'm kind of confused. And he asked again, yeah, I'm kind of confused. I'm kind of confused. And finally, Emil understood what the prosecutor wanted him to say and agreed. I'm not faulting Emil at all, okay? This was a misunderstanding. The second call shows that. Gerhard calls the second time, and he wasn't saying, why'd you rat me out? He was saying, wait, what? You told Ariel's parents I tried to kill her? Oh, like, I gotta go. And he was gonna go kill himself again. This idea that he wasn't giving Ariel a blow-by-blow what happened, Emil a blow-by-blow what happened, he was trying to say goodbye to his son. This is not a confession they're making it out to be. I just point out to you, it's not his fault. He's lived with Ariel the last year. He wants to be on Maui. He likes it here. He knows the only way he can stay here is living with her. We talked about her and her actions with the detective and the primary care doctor. He understood what the prosecutor wanted him to say after the 4th try. This was not a confession. Gerhard's actions after the incident, they want to say it's consciousness of guilt. I say it's conscious, it's proof he's human. He went into deep despair. He couldn't believe that he could cause that kind of harm to the person that he loved. And that can coexist with defending himself in the moment, in that reaction. He felt horrible about it. He went into where he was suicidal. What he was saying to Emil on the phone was, I gotta go. I don't want the police to find me, is because he wanted to keep open the option of killing himself, which was turning to be harder than he thought. He didn't want to get caught at that time because he was still thinking about jumping and killing himself. He wasn't evading the police for the purpose of, I don't want to get caught. He wanted to be able to kill himself and have that option. And we'll talk about when he turned himself in later. And that's why he did what he did with the SIM card. He didn't want the police to find him because he was thinking about killing himself. And this idea that in the middle of this suicidal place of being super emotional, that you open your SIM card, you bend a paper clip, open it, and you're going to take the time to put it back where it was instead of just leave it over there. It shows he's human, that he felt terrible about this. He told you how bad he felt. And that can coexist with self-defense. Now, this idea that he was fleeing from the cops, first of all, the officer didn't say we pulled up right next to him. Very clearly, they said we pulled up. There was a lane in between us, and he was on the grassy area. This grassy area right here. They said he was here when they got out of the car, and he started to flee. And remember, And I said, come on, you know, how the heck was he not going to get in the bushes if that were the case? And then, shockingly, the prosecutor asks him, well, you played D1 football, right, officer? I mean, the fastest man in the world, Usain Bolt, Olympic sprinter from Jamaica, could not get to him from the car if he's trying to get into the bushes. Look, I get it. Officer safety. Look, I'm not faulting them. They came in hot. They're the strategic enforcement detail. Apparently, you got to be 300 pounds to be in it. I get it. They think he has a syringe. Okay. They come in hot. They couple strikes. Don't hit him in the face and arrest him. I'm not faulting them for that. I don't know about this, you know, saying he was trying to flee. Okay. That's not cool. Okay. But I get it. Officer safety. He has an injury. Look at this. It's dry blood and it's bruising. It's the kind of purple bruising that takes place hours later. When you first get an injury, it doesn't bruise. This happened earlier. Dry blood, purple bruising. That takes time to get to that point. A theory in search of facts. I talked to you guys about this. To try and use a computer to manufacture financial motive without telling us last week that sometimes, I'm sorry, how much time is that? Thank you. That sometimes the computer opens files and shows it was accents. Don't you think that would have been fair to tell you guys that? Instead of leading you to believe that 100% Gerhard looked at all of these things? Look, make no mistake, he said 80% of it he looked at. He's not hiding that. He's just, when he's up here saying, like, I don't remember at 3 a.m. looking at a 2018 Amex credit card statement that was in my old divorce file. And, he, you know, I mean, but undeterred. It shows he had a financial motive. He was looking up how much his divorce costed him in the past. What? He makes a lot of money as a doctor. The search terms: kill, push, shove, syringe. They're looking for the smoking gun. They have had it with his computer, looking for the smoking gun. What do they find? No smoking gun. Just some search about hikes that you would search if you were truly just going on a hike. Again, maybe, maybe not. They were looking for a smoking gun. They don't find it. So what do? They manufacture a motive, undeterred, theory in search of facts. Oh, no smoking gun. But you know what? It shows he's looking at financial documents. He has a financial motive. It's not fair. I submit to you that whatever they found on that computer, they would find some way to spin it. Whatever they found, they would find some way to spin it. That's not fair. The work bag. And this, I gotta say, he uses these tools and materials to save lives. And they want to fault him for having it? He's a doctor. He talked to you about why he has it on Maui, not on Oahu. He uses these things to save lives, not try and somehow poison his wife. And she knew he would take it from work every day. Now, self-defense, first thing you got to decide is whether or not this was deadly force that he used. We know it wasn't. We're going to get into that in a second. But it doesn't matter either way because it's the same rock that she hit him with. So even if it was, even if you say it was deadly force, it was the force that was used against him. So it doesn't matter. It's the same rock. The only thing it does say about it, and this is the part that was incomplete about the duty to retreat. It says the use of deadly force is not justifiable if the defendant knows he can avoid the necessity of using such force with complete safety by retreating. You only have to retreat if you can do so safely. She's holding on to his testicles, hitting him. And it just talks about being reasonable. He used the same force that she used against him. And they want to say, well, look at the difference. How could it be the same rock? Obviously, if one gets hit cleaner than the other, the same rock can do that. You know, like I could throw something at a baseball at someone's head, and one it hits them in the face and one it hits them in the arm. It's going to cause obviously it can be depending on how the direction, how hard the landing was. He stopped. He didn't keep going. What amount of force was used? We know, like I said earlier, we know what Ariel says she doesn't know. I don't know the exact number. They are downplaying what she said because they know it doesn't make sense. They're saying, oh, up to 10 times. So what does that mean? 6, 7, 8, 9? Doesn't mean 2. But now they know that doesn't make sense. She was hit 8, 9 times. And oh, maybe she meant less. She doesn't know. Grosjean says possibly 2, maybe more. I cannot tell you. Arden says 2 to 3. He says 2. Grosjean talks about, oh, there's rock in there or dirt. He's not a forensic pathologist. He didn't test the material just to show like what it was. You know, her condition after. You saw her walking. She's walking on the hill. Okay. But more importantly, this is her talking after. And I'm going to ask you to do something with me now. If you could help me out here, either close your eyes or don't look at the screen and just listen to her voice.
Where does he work?
He works for TMG at Maui Memorial Medical Center. TMG is called it.
At Maui Memorial.
Memorial, yeah. So TMG's a group of anesthesiologists.
Did you guys drive here today?
Yeah.
Which is your car?
It's a Nissan Rogue.
Do you remember the license plate? If not, that's okay.
It's not our car, we live on Maui.
What color is it? The Nissan.
It's like black or it's gray. It's gray. Isn't it just wet my mouth? Or wet paper towel to my mouth for the works. I don't have any more. Sorry, I know. No, you're an angel. Trying to stop the bleeding until they get me. I know.
What was Gerhard wearing today?
Wearing like a light gray shirt and
Okay. Does she sound like she has a traumatic brain injury to you? She sounds okay. Look, I'm not saying it wasn't a bad cut. And look, I'm not, nobody wanted her to have that cut. I'm not saying it's not, I'm just saying the level of force he used, you can see. He talks about chunks missing from his scalp. No doctor said that. It was soft tissue. You heard from Dr. Arden, a very credible man, that apparently for 14 grand is going to sacrifice his integrity. Obviously, he's not going to do that. He told you the blood is not a good indication of the severity. The blood is not a good indication of severity. No skull fractures, no soft tissue. The tip of her thumb, he said it was just the very tip. And sure, after the first hit, he puts her thumb, it hits it, just the tip is fractured. We heard about that. All 3 doctors agree. No substantial risk of death and no serious bodily under the law. All 3 said that. We talked about the stellate laceration. The Glasgow coma score was 15 out of 15. Triage, they waited a few hours outside because she wasn't in that serious of a condition. She had a bad laceration. They sewed it up. She went home the next day. And I don't mean to. He feels terrible that happened, but he wasn't trying to kill her. That's about the amount of force that was used. Now, her eye. Let's look at this photo. The orbital is the most fragile area there is. And he said, very fragile bone. If he hit her with that rock, it would have broke bones. There was a scuffle. They landed on the ground. They're fighting. There's elbows. He's going for the rock. They're fighting for it. There's no doubt her eye got hurt in this thing. But he didn't smash her eye with the rock the way they want you to believe. And then you have his injuries. We talked about that. Now, it's the state's burden to prove to you this was in self-defense. More than probably. that it wasn't under the circumstances, that he reacted as a human when she was doing these things to him and hit him. They have to prove to you it doesn't apply. It was a reflex. It was a reaction. It was a human reflex and reaction to defend himself in the moment. And that can coexist with him feeling terrible about it after. This happened extremely fast, and then he stopped. Now, we talked about the elements of attempted murder. He had no intent to kill her. You see on the bottom, and self-defense applies. They have to disprove those two, self-defense. Then there's something that takes you down to the others, right? The other offenses. If and only if you find the defendant not guilty of attempted murder, then or unable to reach a verdict, unanimous verdict, then you must consider these other included offenses. None of them apply. Self-defense is a defense to all of them. If you think that they didn't disprove self-defense, it goes all the way down. But you work your way down through these things. I'm just going to go through it quickly because I don't have a lot of time. The next one is attempted assault in the first degree. That he took a substantial step in conduct intended to culminate in the commission of assault in the first degree. That he intentionally or knowingly was trying to cause serious bodily injury. Let's look at the definition of serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The doctors say she didn't have that. He wasn't trying to do that. This doesn't apply. Self-defense, no intent to cause serious bodily injury. You go on to assault in the second degree. Again, serious, no intent to cause serious bodily injury. Self-defense applies to all of this. So you work your way through, self-defense applies to all of it. Her motive to try and get custody and conviction of any of these things helps her with that. Assault in the third degree.
For improper instruction of the law.
Should be substantial. Ladies and gentlemen, we have the instructions of the law. That's the instruction of the law.
Then you get to assault in the third degree, bodily injury or negligent use of a dangerous instrument. Again, self-defense. He wasn't negligent. He was reacting. Reasonable doubt as to every one of these included offenses. So you just work your way down. And then there's something after that called a mutual affray. If this was a mutual affray. Reasonable doubt as to all of these. Now, I'm almost at the end here. I have couple more minutes. I want to end by saying a few things. This is the law. I ask you to use this as a guide to your deliberations. It's not about trying to figure out what happened. Your only goal is to answer the question, is there a reasonable doubt? Did they prove beyond a reasonable doubt this was not self-defense? More than possibly, more than probably. Let that guide your deliberations. It's a way to simplify things. After you talk about any piece of evidence, come back and remind each other, yeah, but does that prove this beyond a reasonable doubt? Let that guide your deliberations. I couldn't help but think last night. When they moved here to the United States, there's these constitutional rights that we all have. They didn't know it at the time, but it was for a moment just like this. When a jury of his peers would come together and follow the law and follow through on the oath that he took. I want to end with a quote. There was a politician back in the day who was giving a speech, and it was to other politicians, but I think it applies pretty well to jury service. It says, for those to whom much is given, much is required. And when at some future date, the High Court of History sits in judgment on each of us, recording whether in our brief span of service, we fulfilled our responsibilities to the state, our success or failure will be judged by the answer to 4 questions. First, were we truly men and women of courage? Second, were we truly men and women of judgment? Third, were we truly men and women of integrity? And finally, were we truly men and women of dedication? I ask you to keep those 4 things in mind as you deliberate. Courage to follow the law and do what's right, even if it may not be popular. Judgment to see through some of this ideas that he had a financial motive, that it was cheaper to kill her. Common sense judgment. Dedication to these principles and our Constitution. Dedication to it. Uncompromised dedication to the presumption of innocence and reasonable doubt. Deliberate that way. Uphold your oath. Follow the law. Let this guide you. Enforce the reasonable doubt standard. Follow the law. Do these things. And integrity will be yours. Thank you for your time over the last month. On behalf of Dr. Konig and Manta Dirks, thank you all for your time.
I feel like he's not doing a rebuttal, y'all, from him saying that. Give him a high five, Dr. Konig. You should have given him a fist bump or something. 61 minutes? Oh, yeah, he took all his time.
Mark Twain also said, if you tell the truth, you don't have to remember anything. Think back to defendant's testimony. Think back to every time he was asked on cross-examination something that made him look bad, something that made him look like he had a motive, something that was incriminating. Think back to every single time the defendant was asked something like that. And what was his answer? I don't recall. Ariel Konig was able to sit here and testify in front of you for 3 reasons. First, she had her intuition. She saw the defendant looking at her feet on that trail. She saw the defendant tracking her every move. She saw the defendant making sure he saw where she was. And that's what made her feel uneasy. It was her intuition. Second, she fought back. She fought for her life that day. And defense wanted to characterize it as a full conversation, but it was Ariel begging for her life from the defendant. It was Ariel saying, think about the kids. It was Ariel saying, nobody's going to believe this was an accident. This is Ariel trying to reason with somebody who is trying to kill. And the third reason, and the most important reason that Ariel was here to testify to you, is Amanda Morris and Sarah Buxbaum hearing a call for help, going forward, looking at what they saw, and helping Ariel out. Because the evidence shows that is the only thing that stopped the defendant that day. The only thing that stopped him from continuing to beat Ariel with that rock, from continuing to hit her, from continuing to try and kill her, was Amanda Morris and Sarah Buxbaum catching him in the act. Defense wants you to think about the life insurance. But you should think about it differently. This is a couple who's going through it in their marriage. Why is it time to renew life insurance? Does that make any sense? No. What the life insurance is, what many of defendant's actions are, is the defendant covering his tracks. The cover-up proves the crime. Defendant had control of the scene when he was done, so he took the evidence with him. He didn't need to take the rock. In fact, he knew that he was seen with the rock. He knew that Amanda and Sarah saw him with the rock. Why take it? And what reason would Ariel have to make up the syringe? None. Think about what Ariel knew. Ariel knew that he had tried to push her. Ariel knew they were right next to a cliff. Ariel knew that people walked up as she was being beaten with that rock. She had enough already. There's no reason to make up the syringe. Defendant's attorney said something. These are the facts you just can't make up. And that's what the syringe is in this case. It's a fact you just can't make up. Let's talk about the confession. Emil told you he has no doubt about what the defendant told him. If this was truly a goodbye phone call, if this was truly the defendant telling his son that he was going to commit suicide, what purpose at all would there be to accuse Ariel of having an affair? What purpose does that serve in saying goodbye? That makes no sense. It's just trying to throw dirt on Ariel. That's all it is. It's trying to throw dirt on her. It's trying to make her look bad. It's trying to justify his actions because he knew from the minute he did it, and he knew from the minute he planned it, that it was wrong. And then look at that timeline again. Why? It makes no sense. The defendant was simply trying to say goodbye. It was simply a miscommunication between himself and Emil. If it was a miscommunication, why wasn't it cleared up? Why wouldn't he just tell Emil in that second phone call? Why would in neither of the FaceTime calls the defendant say anything about self-defense? Why wouldn't the defendant say anything about Ariel supposedly attacking him? Because in that moment, he was confessing. In that moment, he had a guilty conscience. And that's why he did what he did. That's why he hid. That's why he tried to run from the police. Think about the list of people that would have to participate in this, what essentially is being alleged as a massive conspiracy to believe what defendant's saying. You have to disbelieve Ariel. You have to disbelieve Emil. You have to disbelieve Amanda. You have to disbelieve Sarah. You have to disbelieve the medical evidence. You have to disbelieve the doctor that the defense hired. And you have to disbelieve what you saw with your own eyes. That's why the defense asked you to close your eyes when they played that video. They wanted you to ignore what you see. That's what this case is about. That's what they're asking you to do. Open your eyes, make a decision based only on the evidence, and the decision is clear. The defendant tried to kill her. The defendant tried 3 different ways, and he learned out multiple times that day. It is harder to kill. than you may imagine. You were told earlier about the defendant's constitutional rights and the founding of this country and how important that is. What are those three phrases that this country was founded on? You've probably heard them before: life, liberty, the pursuit of happiness. And in this case, the defendant, beyond a reasonable doubt, made a conscious choice to try and take Ariel's life. He made a conscious choice to kill her. And that is why the only verdict that is supported by the evidence is that the defendant is guilty as charged. Thank you.
Thank you, Mr. Burnham. Just about to send the jury in for deliberation. Before I do, to the first 12 jurors, is there anybody here who feels for any reason they cannot participate in deliberations in this case? I see no hands. So that means Mr. Kiyama, Ms. Kishi, Ms. Pang, and Ms. Yang, I'm able to let you go, but you're not quite yet done. If one of the other jurors cannot complete deliberations, you may get a call to come back and participate in deliberations. Okay. So even though you get to go back to your regular lives and you're not sitting here in the courtroom, those three rules still apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom until one of two things happens. Number one, you get a call to come back. Or number two, you get a call letting you know that deliberations are complete and the case is done. So unless or until you get one of those two calls, those three rules apply. Don't watch any media, just in case you might have to come back and do further jury service. On behalf of the parties and the rest of the judiciary, thank you very much for your time and your service. I talked about Gold Star jurors early on. You're weathering two storms to be here, and all flexibility and perseverance that all of you showed that still remains true today as more storms come our way. So again, thank you very much for your dedication, your perseverance, and your service. If I do not have a chance to talk with you later on, I hope you and your families remain safe during this upcoming storm. And again, you have our gratitude. Thank you very much for your service. You're free to leave the courtroom. Thank you. Please be seated. So, ladies and gentlemen of the jury, as you already know, lunch is going to be brought in for you while you're in the jury deliberation. I do have a couple of final instructions before I send you in. Your deliberations take place during what I call banker's hours. So you're allowed to deliberate up until 3:45 today. If you're unable to reach a verdict, I ask you to come back, start again at 9 o'clock. The reason why if you ask why is it so early, because if there is a verdict, there is time needed to assemble everybody to receive the verdict, and it won't happen before the end of the day. So that's why I released jurors at 3:45. Have you come back at 9 o'clock if you don't reach a verdict today. You will have communication forms along with the verdict forms that will go into the jury deliberation room along with the exhibits. One note about the communication forms. If you do send the communication to the court asking a question, it does take some time before an answer can come back to you. Sometimes it takes up to 45 minutes, sometimes an hour. If you're waiting for a response, if you can continue on with the deliberations, please do so. A couple of other things. You will not have the opportunity to ask for any additional information that you think is helpful. So you have all of the evidence that's available to make your decision on this case. Also, there are no transcripts available for the testimony of the witnesses. So you have to rely on your collective recollection as to what the testimony may have been. Before I send you in,
is Calvin Ms. Alvin Fisher. Will you stand and raise your right hand? Do both of you solemnly swear or affirm that you will take this jury in charge, that you will not communicate with them except by order of this court, that you will allow no one to communicate with them, and that you'll conduct them into court again whenever so requested by them or by order of the court?
I will.
Thank you. So ladies and gentlemen, I'm going to ask that you take your notebooks, take your jury instruction packet, and all your personal effects as you go into the jury deliberation. All rise. Everyone can be seated. Jury is out of the courtroom. Mr. Barner, anything you want to face on the record before we recess?
Nothing from the state, Your Honor.
Mr. O'Connor, anything you want to face on record before we recess?
No, Your Honor.
To all of you, thank you very much for the work that you put in on this case. I remain impressed by the lawyering talents. I haven't been here that long, maybe it's long for some people, but one of the true joys of the job is watching excellent attorneys represent their clients and apply their craft. And I'm truly privileged to watch that in this case. So thank you very much for excellent lawyering. Until we hear from the jury, court will be in recess.
Thank you, Your Honor.
See, they wouldn't hug and everything. They friends. Birdie, clock up. Dun, 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 dun. So what do y'all think? Who did better? One or two? Prosecution or defense? Let me see those ones and twos in the chat. Who did the better job in your opinion? Mic check, 1, 2, 1, 2. 1 for the prosecution team, 2 for the defense. Real Happy says, I don't care about neither one of them. I wish the judge would use their damn mic. Like, that's what mics are for. That's what mics are for. For good times and bad times. We want to hear everything you said. That's what mics are for. Oh, I'm seeing 1s and 2s on the 1s and the 2s. Yes. 1s and the 2s and the 2s and the 3s. I tell you what, this one, dang, Derek says, forget all this mess. It's a hung trial, mistrial. So they are working through their lunch. As you guys are aware, is what, 12:45 there. Hey, Sherry. Hey, everybody. Any new subs, new subscribers, new people that just found us out here on this algorithm, welcome in. I am your host, Sweet Pea, and yeah, this is the Take It to Trial gang, I guess. I think it comes down to who the jury likes the best. That's interesting. I don't know. I like the defense attorney. I'm telling y'all, some of these defense attorneys out here, I can't remember what, I got to figure out what defense attorney I was in love with. Y'all couldn't stand. And I was like, boy, if I'm going to war or I'm going to court, I want their number on speed dial because I want them to get in there and act the absolute fool over me. I know I would definitely want Edric Foss attorney in there. I can't even remember his name. What was his attorney's name? I can't remember his attorney name, but I want him I want him behind me because he was like, his client is not guilty. Like he said it with his chest, Mr. Cruz, boy. I was like, sure, if I ever got to go to battle, I want to go to battle with him. I gotta look. I'm gonna look on our page and see what trials we didn't cover because I know it got to be one that we didn't cover. And I was like, I like that person, and y'all was like, nah, we hate them. We don't like them. They doing too much. Like, shoot, that was my attorney. Thank you. Let me see. I'm trying to think what case was that? We go through so many cases. I can't even keep half of them straight. It'll come to me one day, but I know I was like, shoot, that was my attorney. I'm glad you going all in 10 toes down. Fight for me all day, every day. Thank you. I appreciate it. I need that. I need that in my life. Okay, so we are on verdict watch. My question to you guys is, are we watching extra testimony? Are we what are we doing here? What would y'all like to do? Do y'all want me to come get y'all when the verdict is read? They have about, I would say like maybe 4.5 hours of, testimony of time that they can deliberate back there in the back. You said music first, pretty please. Okay, California girl. Okay, let me get that on and we'll play some songs, some tunes for real quick. Y'all can look at the verdict clock. Wait a minute.
Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in check. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the California's rolling deep on 9. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chest flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie,
Susie, Shamrock, Shamrock,
junkie, 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 junkie,
Susie, Shamrock,
Where
Shamrock.
we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride, Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this.
When the live stream flickers on and Sweet Pea takes a stand, Lynn is already there, coffee in hand. She settles in for the long trials, the twists and the turns, with a loyal heart and steady eyes that never miss a word. She's a constant in the courtroom, a familiar shining face, always ready for the arguments, the tension and the pace. And when the evidence is messy or the stories sound untrue, she leans forward just a little. Lynn knows what to do, 'cause Lynn thinks everyone is guilty, every suspect, every tale. Melody Ferris guilty, she says without fail, but Dr. Rachel shakes her head. Sure, the son is to blame, still Lynn stands firm, her verdict stays the same. Oh, she brings the truth with a calm, steady light, and her presence is a comfort on every trial night. She listens with devotion through each objection and plea, through the cross-exams and pauses. She's where she needs to be, in the sea of courtroom chaos where tempers sometimes flare. Lynn remains unshaken, a voice of reason there. And though the chat may chatter and the theories may divide, Lynn's perspective never wavers. She speaks with honest pride. She keeps the room grounded when emotions run loose, a quiet force reminding us she's here to find the truth. Yes, Lynn thinks everyone is guilty, that's just her way. From the first opening statement to the end of the day, Dr. Rachel can argue the son's the one at fault, but Lynn won't budge. She's rendered her final thought. We appreciate her always for her loyalty and her proof, 'cause the church shines a little brighter when Lynn brings the truth. Yeah, lights on, chat awake. What's the move tonight? Sweet pea in the room, yeah, you know the vibe, right? Quick, sharp mind cutting through the noise. Got the whole room laughing when she drops her voice. Eyes on the screen and she reads the whole room. From drugs to facts, she's ahead of the boom. Not just her talk, yeah, she bringing receipts. When Sweet Pea speaks, everybody hits repeat. She don't just show up, she sets the tone. One line from her in the chat's blown. Smart, funny feelings, yeah, that's the code. Main character energy fully in mode. Whoa. Sweet Pea, say it louder when she enters the scene. Sweet Pea, got the jokes, got the facts, got the meme. When she talks, everybody leans in. Sweet Pea, yeah, you know she always wins. One line of queen, yeah, she never miss. Turn a quiet room into a viral clip. Brains and humor in a perfect blend. When Sweet Pea starts talking, that's the trend. Say it again, who runs the chat? Sweet Pea, yeah, that's that. Sweet Pea, yeah, you know she always wins. She throws preguntas bien chidas, sharp like a blade. Cross-exam queen, nunca tiene afraid. And that dance so spicy, Cali mistakes close. She brings the fuego, everybody knows. Cuando Jason llega, ay caray, she flirts poquito. He just says hi, Sweet Pea laughs. Aquí vamos otra vez, SD drops the fuego and the chat says yes. She's fuego, fuego, lighting up the show. Text-Mex in the chat, everybody knows. Con su risa, su vibra y su
chat screen. When she pops on camera, we all say que show. Latina sparkle with that California glow. Los mos la quieren, they hype her name. She adds flair y sabor to the game. Que onda, gente? And here comes the fun. El chat se enciende like under the sun. When she teases Jason, boy, behave. But without a chaos, this chat ain't the same. Bailalo, mija, with your Tex-Mex vibe. Bring the cumbia flow, keep it alive. Stay with the groove, don't ever stop. Shake up the stream till we're all on top. She's fuego, fuego. Let her up the show. Tex-Mex in the chat that everybody knows. Con su risa, su vibra y su pelo tan cool. She turns a live stream to a Latin dance floor. Fuego, fuego. Esti's the queen. Spanglish magic in la chat screen. Each girl sparkle, courtroom delight. Esti keeps the chat shining bright. Sweet pea, the mods, we all agree. Take it to trial, ain't the same without Esti. Yeah. Oh, yeah. Oh, yeah.
You say my bird,
Yeah. Here comes Barbara in the chat, girl, she right on time. Sweet pea got the trials rolling, Barbara dropping her lines. She's a mama to two boys, gives them love every day. Autism warriors in her home, and she leads the way. And her husband's been through storms, but she's holding him down. A caretaker with a halo and a medical crown. With that nursing background, baby, she knows the game. First aid on the timeline and receipts on the frame. She's looking for the missing kids, like a mission from above. Heart, big feet moving, she's a justice power dove. And generous as heaven, giving spirit on display. Barbara lifts this whole community in her own special way. Cause Barbara don't play. She's calling out lies in the courtroom hallway. She thinks P. Diddy's guilty as hell, okay. And she don't take crap from any man, no way. She's riding with Sweet Pea every single day. And take it to trial, she forever gon' stay. And when therapist, you know, starts acting up, Barbara busts his chops like, boy, that's enough. Yeah, she be laughing in the chat, cracking jokes left and right. Keeping spirits lifted even in the darkest night. A supporter of the channel, honey, loyal and true. If Sweet Pea goes live, you know Barbara's there too. She brings fire to the panel, brings fun to the fam. Typing fast with that says, girl, she don't give a damn. If a troll tries to flex, she just swats him away. Not today, sweetheart, that's the Barbara way. When the courtroom drags, she keeps the vibe alive. When the mod squad's tired, she helps the tribe survive. She's the kind of chatter every channel hopes for. A legend in the chat room, say no more, cause Barbara don't play. She's calling out lies in the courtroom hallway. She thinks P. Diddy's guilty as hell, okay. And she don't take crap from any man, no way. She's riding with Sweet Pea every single day. And take it to trial, she forever gon' stay. And when therapist, you know, starts acting up, Barbara busts his chops like, boy, that's enough. So here's to Barbara, our queen of the screen. A hero, a mama, a courtroom machine. For the missing, for justice, for family, she stands. And she gives with a heart bigger than the whole damn land. Take it to trial, loves you, girl. Now drop that gavel in your hands.
It's after dark, where the filters fall, where we talk about the things you don't say at all. Sweet Peas in the chair saying, tell it how it is. We unpack real life, not just courtroom biz. It's opinions, confessions, messy and true. Real talk, real laughs, and a grown-up view. Not gossip, not drama, it's truth with style. You can plead the fifth, but we'll still see you smile. We don't tiptoe around the hard conversation. We break it down with truth and speculation. Therapy, law, comedy, insight. That's what trial talk sounds like at night. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial after dark tonight. Film freaks got receipts in the hidden scenes. TYK breaks it down like a therapy machine. Rachel keeps the facts sharp, logical, tight. Pretty brown girls got the clapbacks on sight. Fowler keeps the peace, well she tries at least. Morelia drops gems when the topics get deep. And Jason walks in with that wise guy grin. And the chat yells, here comes the chaos again. Not late night drama, late night perspective. Big brain debates that get introspected. It's real, it's bold, it's thought and fire. the lights get quieter. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial after dark tonight.
Don't dry always seal. Susie in the chat, don't miss that, don't miss nothing. I said, yeah. Log in early, she already there. Chat roll fast, but she don't even care. Trial on screen, notes all tight. She clock every detail morning to night. Karen read facts, she got the file. Timeline sharp, receipts on dial. Ask one question, she got three. Breaking it down like legally. Don't blink, don't lag, don't step away. She ain't miss one stream, now one day. Like run that around, name that case, yeah, she hold it down. 911 clips, she already knew before the host even gives the clue. Inside jokes, yeah, she locked in tight. Every verdict day, every late night fight. Mods look over like Susie got it. If knowledge of sport, she already spotted. She don't wanna miss a second go by. Refresh that feed, keep one eye. Life outside, yeah, maybe later. Right now it's court and the chat getting greater. Yeah, Susie locked in, she stay online. If it's life court, she front row prime. For more hit, yeah, she feel that heat, but she still got answer before you can tweet. Hands up if you know she right. Life track queen in the chat all night. Bald head love, yeah, that's a lane. Cool, calm, collected, no stress, no strain. No strain. Cool, calm, collected, no stress, no strain. Live trial queen, yeah, that's you.
Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, after dark gets spicy. No secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial. Yeah, we live tonight. Take it to trial. Yeah, we live tonight. Take it to trial.
So I think, guys, while we wait, and I thought it'd be good to look at the son's testimony. So I'm gonna play that for us right now while we in verdict watch. And then I was thinking about going to her testimony only because I want to hear her talk about how she squeezed his balls. You know how she grabbed his itty bitties and she pinched his balls. Remember, I was telling y'all how she pinched them. She hurt his balls. So, and then maybe we go to her testimony, but I wanted to go back to the son's testimony because, like I said, this was a game changer for me. Yeah, Jason, she grabbed the balls, the man jewels or whatever you want to call them. She like pinched them, and he said they was all bruised up, but he didn't want nobody to take no pictures of it. Oh shoot, the testy balls, yeah. The testy ball. So we'll listen to the son's testimony and we'll listen to her testimony. I don't know. And y'all can tell me if y'all want to listen to him. I don't know. I don't know if I really need to hear him. But the son is what changed me and crossed me over. And remember, he was like the last witness for the defense. So let's look at that for a minute.
You do solemnly swear or affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Thanks. Please have a seat.
All right, good afternoon.
Good afternoon.
Okay, the first thing I'm going to ask you to do is to scoot forward as much as you can and to speak as much in the microphone as you can, okay?
Okay.
All right, can you start off by stating your name, please?
Emil Konig.
Is it okay if I call you Emil for the rest of my questions?
It is.
Okay. Emil, what do you do for work?
I work for Maui Health.
Maui Health?
As a clerk.
As a clerk, you said? And how long have you been doing that?
About 2 months now.
And where do you live?
On Kahului, Maui.
Is that at 19 Pu'uehu Place?
Correct.
Who do you live with?
With my stepmother and my 2 brothers.
Your stepmother, who is that?
Ariel Konig.
Are you related to any person involved in this case, Emil?
I am.
Okay. Who are you related to?
The defendant.
Is that Gerhard Konig?
Correct.
And who is Gerhard Konig to you?
My father.
If you were to see him again, would you be able to recognize him?
I could.
Stipulate to identification.
Thank you.
Okay. We'll just move on then. All right, Emil, just over a year ago, on the morning of March 24th, 2025, where were you?
I was at home.
Normally, who lives in that house with you? Or on that date, who normally lived in that house with you?
My dad, my stepmom, 2 little brothers.
On the morning of March 24th, 2025, was your dad and your stepmom home?
No.
Do you know where they were that day?
Oahu, here.
They were on Oahu?
Mm-hmm.
Do you know why the defendant and Ariel were visiting Oahu?
For Ariel's birthday.
Do you know when Ariel's birthday is?
The March 24th.
So was anybody else staying at the house in Kahului with you on that morning?
Yes. Babysitter. For the little kids.
Got it. On the morning of March 24th, 2025, did you receive any calls from either Ariel or the defendant?
I did.
Okay. And which was it?
From the defendant.
Who contacted who?
Defendant contacted me.
What type of call was it?
A FaceTime call.
When you say FaceTime call, is that on the Apple iPhone?
Correct.
Was this call a FaceTime voice call or a FaceTime video call?
FaceTime video call.
How many times or how many calls were there from the defendant to you on March 24th, 2025?
2.
And what times were the 2 calls at?
I couldn't recall exactly.
Did you provide a statement to a Maui detective
I did.
regarding this incident, regarding those calls?
Yes.
And in that statement, did you tell the detective what time those calls were?
Yes, I did.
Would seeing that statement help you refresh your recollection as to when those 2 calls were?
It would.
Okay. I'll pull a page number here. Okay, I'm gonna approach with what's been marked as State's Exhibit 170. Page number 3 and page number 4. Okay, may I approach? Okay, Emil, could you quickly read pages 3 and 4 of this document? And when you're done reading, just look up, okay? Okay. Is your recollection refreshed as to when those 2 calls were?
It is.
Okay. I'm going to retrieve the exhibit and I'm going to ask you the same question again, okay? I'm going to retrieve exhibit 170 from you. Okay. And Emil, what time were those 2 video FaceTime calls on March 24th, 2025?
The first one was at 10:42 a.m. and the second one was at 11:46 a.m.
I'm going to ask you about the call from 10:42 a.m. first, okay? All right. Where were you when you got the FaceTime video call at 10:42 a.m.?
At home.
That's the same address we talked about earlier.
Correct.
What did you see on the other side of the screen when you picked up that call?
I saw the defendant.
Can you describe the defendant as you saw him on that call?
Wearing sunglasses, dry fit shirt. That's all I saw.
Did you see the area that the defendant was in?
Outside.
And did the defendant tell you anything during that call?
Yes.
What did the defendant tell you during that call, as close to word for word as you can remember?
That he would not be making it back to Maui and to take good care of the younger kids, and that my stepmom had been cheating on him and that he tried to kill her.
Okay. That's a lot, but I'm going to break that down a little bit. You said the defendant told you he tried to kill Ariel. Is that right?
Correct.
Did he tell you what happened to Ariel?
He did not.
Did he tell you where she went?
No.
Did the defendant tell you why he tried to kill Ariel?
No.
During this 10:42 a.m. call, did the defendant tell you anything about what he planned to do next?
During that call, the next plan that he said was to jump off the cliff.
And how did you react to hearing that?
Told him not to.
How did you react to the defendant telling you he tried to kill Ariel?
I don't remember what I said.
Do you recall what the defendant told you after he said he tried to kill Ariel?
Not directly after.
Did he say where Ariel went?
No, just away.
What did he say about Ariel and away?
He said that she had gotten away, and that was all I heard about her location.
During this first call at 10:42 a.m., did you ask the defendant any questions yourself?
Yes. I asked what was on his shirt because it looked like I saw splatters of something on his shirt, and he said, "Oh, it's just her," meaning Aries' blood.
Okay. So far you've told us that the defendant told you he tried to kill Ariel, that Ariel got away, that Ariel was cheating on him, that he planned to jump, and that the blood on the shirt he's told you was Ariel's. Is that right?
Correct.
Okay, did I miss anything so far?
No.
Okay. Did he tell you anything else during this call at 10:42 a.m.?
No.
All right. So Emil, after you get this FaceTime call and after the defendant tells you these things, what did you do?
I went over to my grandparents' house, which is Ariel's parents. Walked over to their house, told them what had happened.
How far away is your grandparents' house away from the Pu'uehu place address you mentioned earlier?
It's like a minute or so walk.
And could you tell us your grandparents' names?
Judith and Peter Mast.
Which of your grandparents did you tell about the call first?
Both. They were both there, so both of them.
What happened after you told Judith and Peter Mast about this 10:42 a.m. call?
The next notable thing is they received a phone call from, I believe it was Queens Hospital, one of the hospitals here.
Later on that day, did you tell anybody else what the defendant told you?
My mom.
Who's your mom?
Jessie Patelare.
Did you at some point also tell the police what happened that day?
I did.
All right. Do you know where your grandparents ended up going after you told them about this call?
Yeah, here.
They came to Oahu?
Correct.
Okay. All right. You said that there was a second call at 11:46. Is that right?
Correct.
All right. The second call, was this a FaceTime call as well?
Yes.
And just audio or audio and video?
Audio and video.
Did you pick up the call?
I did.
When you picked up this second call at 11:46, what did you see on the screen?
I saw the defendant.
Okay. And can you describe any background that you saw on the scene, if you remember?
Just trees, rocks, the sky. Was it?
During this second phone call at 11:46, what did the defendant tell you, if anything?
He asked me if I had told anybody, and I said yes, and I told him who I had told. And then he said that he was just going to jump, and said that a couple times.
Okay. To be super exact here, Emil, who did you tell the defendant that you told?
I told the defendant that I told my grandparents and my mother.
Okay. So you told them that you told Peter, Judy, and Jesse.
Correct.
Okay. So after the defendant told you he was going to jump a couple times during the second call, how did you respond?
Same way as before, said not to. I don't know.
You told the defendant not to jump.
Right.
Okay. How did the second call end?
With him saying, with the defendant saying, I'm going to go before the police catch me.
Did he tell you he was going to hang up? Do you remember that? I'm sorry.
Objection leading.
Sustain.
Okay. Bad question, Roy. All right. Sorry, I just want to clarify, Emil, but the last thing you told me about the police, what exactly did the defendant tell you about the police?
Asked and answered.
Could you clarify what the defendant told you about the police?
That he was, that the police was looking for him. He didn't want to be found.
Right. Did the defendant tell you anything else about his state of mind or what he was thinking?
He said he was at the end of his rope.
Anything else you can remember about that?
Thought about suicide for the last couple months leading, or for the months leading to the 24th of.
For both of these calls we've been talking about, who was the caller?
The defendant.
So at either call, were you the one to dial him up?
No.
All right, Emil, overall, did you choose to get involved in this?
I did not.
They so silly. That's not me. That's them. Oh boy. Let me see if I can refresh it.
All right, Emil, overall, did you choose to get involved in this?
I did not.
Oh gosh, y'all see it? It keeps stopping. It keeps stopping. He's stopping. No. Oh gosh. Let me see. I tried to refresh it and it just.
All right, Emil, overall, did you choose to get involved in this?
I did not.
Okay, they buffering. Oh my goodness. Yeah, that's messed up when your own child is up there testifying, like calling him a defendant. Like, he done. He should have just saved everybody the time. I don't even know why because he could have, did something else. He could have did something else, like, play it out or did something different than this, than taking everybody through this. Let me try to refresh it again. I may have to try court TV, but
overall, did you choose to get involved in this?
I did not.
Nah, it's nobody's TV. It's the stream. Hold on, let me see if court TV, but they usually have the same feed coming out of all the courtrooms.
Like a family group?
Oh, wait a minute, here you go.
Snapchat or something like that?
Yes.
Who was on that?
I believe just me, my dad, Ariel, and it might have just been those three.
Okay.
I can't tell you exactly.
Okay. But you were on it and they were your dad was sending photos of them on the hike, yes?
Correct.
Letting you know where they were, right? Yes? Well, I mean, just that they were on a hike, yes?
That they were on a hike, yes. Not letting me know where they were.
Well, yeah, I just meant like showing you pictures of the hike they were on. Maybe
Okay.
It's a better way to write it. Is that right? They were
Yes.
sending you pictures of the hike they were on, yes?
Yes.
And at least at that time, everything seemed normal to you, correct?
Correct.
There was no reason to be concerned at that time, correct?
Correct.
Now you get this call on 1042, and he's telling you, amongst other things, that he said he's not going to make it back. Yes.
Correct.
And like he was saying goodbye to you. Yes.
Correct.
And you quickly realize that something's wrong, right?
Yes.
You don't know exactly what's going on, but he's also telling you that he's going to jump and commit suicide, correct?
Correct.
And from what he was, saying, and from what and acting the way, what you could gather, you could tell that there was a lot going on in his head. Yes?
Yes.
You could tell that your dad was distressed when he was talking to you, yes?
No.
You remember you gave later the day of these calls, you talked to the detective on Maui. Remember that?
Yes.
And you remember telling the detective that your dad sounded like he was kind of distressed, trying to stay calm, but kind of distressed? Remember saying that to the detective?
No.
Okay. Would seeing the transcript of the interview with the detective help to refresh your memory of what you told the detective?
Yes.
Okay. This is 170, page 4. Okay. May I approach, Your Honor?
Yes.
Okay. So, email, I'm going to show you this transcript. If you can just read lines 14 and 15, well, if you wanted to start from lines 8 and read down to lines 15 and just read it to yourself and let me know when you're done. Okay. You remember saying that to the detective?
Yes.
But as you sit here today, you don't have a recollection of him sounding distressed, is that right?
Didn't sound distressed.
But you did tell the detective it sounded like he was kind of distressed, right?
And then I said afterwards, he sounded calm.
Yeah, you said it sounded like he was kind of distressed, but trying to stay calm. And he did sound calm. That's what you said, right?
Correct.
Kind of distressed, but trying to stay calm, right?
Yes.
Right? Okay. Now, he's talking to you, sounds kind of distressed, trying to stay calm. And you said also at some point, said something about he seemed like he was at the end of his rope. Is that right?
Yes. That is what he said.
Now, the first call, Emil, when your dad is having this first call with you, from what it was on a FaceTime, right?
Correct.
And there was video, right?
Yes.
So you could see him and kind of whatever was in the camera behind him, right?
Right.
And he's having this call with you. He's right on the edge of what looked like a steep cliff, correct?
Yes.
And he's telling you he was going to jump, yes?
Yes.
And did you assume that where he was talking to you at was where the incident with him and Ariel took place? Generally?
I wasn't aware. I wasn't thinking about that.
Okay. But it looked like he was in a steep place that kind of was high, like he had to scale on rocks to get to it, correct?
Correct.
You see blood on your dad's shirt, yes?
Correct.
And he tells you that this was Ariel's blood, yes?
Yes.
And he told you that he was explaining to you about how Ariel had been cheating on him for a couple of months, yes?
Yes.
And he told you that the blood was from her head, correct?
Correct.
And half an hour earlier, everything seemed fine to you, right?
Yes.
Now you're hearing this. You see the blood. You see the steep cliff. He's telling you he's going to jump. And I'm sure it was a pretty emotional, upsetting call. Yes.
Yes.
And it was also a little confusing to you. You're trying to kind of piece together and make sense of what happened. Correct.
Yes.
And also trying to convince him not to jump. Correct.
Correct.
This was on FaceTime and so it was on speakerphone, correct?
Correct. Correct.
After the first call, you then go to Judy and Pete's house, yes?
Yes.
And that's Ariel's parents' house, yes?
Yes.
But you call them your grandparents, correct?
Yes.
You also went to Judy and Pete's house with your girlfriend, right?
Yes.
Is that still your girlfriend?
No.
Okay, your girlfriend at the time, correct?
Yes.
Then maybe about an hour later, your dad calls you again. Is that right?
Yes.
And you guys are talking, and he tells you, well, he brought it up and asked, and you said, yeah, I told Judy and Pete, and then he starts saying, okay, I'm gonna jump then, or something like that. Is that right?
Yes.
And then he said he needed to go so the police wouldn't find him, right?
Yes.
Okay, so I mean, he was telling you he wanted to jump and kill himself, and he wanted to go so the police wouldn't find him. That's what he was saying, yeah?
Yes.
Okay. And, after these understandably, these so-called emotional calls, later that day, the detectives from Maui contact you, correct?
Yes.
And at least according to it was the interview started at 2:27 p.m., correct? Would seeing the transcript help you remember that?
It would.
Okay. May I approach, Your Honor?
Yes.
Again, 170. So email, if you just read that, this is the start of the interview. Okay, read it to yourself. Let me know when you're done.
Yep.
All right. So the interview started at 2:27 p.m. later that day, correct?
Correct.
And these were not Honolulu Police Department detectives, but Maui Police Department detectives, correct?
As far as I know.
Okay. And you were able to look on your phone later. Well, you were able to look on your phone and tell the detectives the exact timing of the calls. And that's why you were able to say the first call was 10:42 a.m. and the second call was 11:46 a.m., right?
Yes.
So the interviews with the detectives is at 2:30 or 2:27. So about 4 hours after the 10:42 call and about 3 hours after the 11:46 call, right? The interview with the detective.
Yes.
Roughly. And, obviously you didn't record the call with your dad when you guys were having them. You're just listening to him and talking to him about not jumping, right?
Correct.
And you didn't write down any notes after the call, right after, did you?
Correct.
Okay.
I did not.
But you tried your best, 3 to 4 hours later to describe the call you had with your dad to the detectives, correct?
Yes.
Okay. And, today, for example, you were asked by Mr. Gardner, after he was talking to you about jumping, you were asked, what did you say back to him? And I think you said, I don't remember what I said right after that. You remember saying that just a little while ago?
Yes.
Okay. So as you see there today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim word for word, correct?
Yes.
And for example, you were asked by Mr. Gardner about, what he said after a certain point. And there are things that you don't recall exactly what your dad said after certain parts of the conversation, right?
Yeah.
Okay. But you tried your best to explain to the detectives what you understood your dad to have been saying, correct?
Yes.
But to be clear, it wasn't like an exact word for word verbatim of the entire conversation, but you did your best, correct?
Yes.
Okay. For example, in an effort to do your best to explain to the detectives on Maui what happened, you initially told the detectives that your dad told you he tried to kill Ariel by pushing her off a cliff. You remember initially saying that to the detective?
Yes.
Okay. And that was what you had kind of assumed, given the things that he told you and where he was on the cliff. That's what you assumed that he meant, right? At least when you said that to the detective, right?
Can you repeat that question?
So when you initially told the detective, my dad told me he tried to kill Ariel by pushing her off a cliff, that's what you assumed your dad had meant, correct? When he said that, you assumed your dad meant that he had tried to. Well, let me phrase it this way. You remember telling the detective initially that your dad told you he tried to kill Ariel by pushing her off a cliff. You remember telling the detective that?
Yes.
Okay. But later on, in the conversation, in the interview when a detective asked you about that, you clarified and you said the part about pushing her off the cliff was what you assumed he meant, not what he had actually said, correct?
Yes, correct.
And then when the prosecutor asked you questions about it, you said at some point he said something about she got away, right? Something like that?
Yes.
Okay. Did anyone tell you about the two witnesses that had testified that when she was moving away from him, he didn't try to stop her? Did anyone tell you that?
Can you repeat that?
Did anyone tell you that about how the witnesses that were there testified when she was moving away from him, he didn't try to stop her?
At what point?
No. Overruled.
Did anybody share that information with you?
I don't understand the question.
Okay. Now, let me ask you a few more questions, email, and then we'll be done, okay? You were asked by Mr. Gardner about how after the incident you flew to Pittsburgh to be with your mom, Jessica. Remember that?
Yes.
And was it later that night?
Yes.
Okay. But you did return to live on Maui sometime thereafter?
Yes.
Maybe in a few weeks? How long were you in Pittsburgh? Couple weeks?
Couple weeks. I couldn't tell you the exact date.
Okay. But within a month you were back on Maui.
Correct.
And you, at the time, you had moved to Maui with your dad and Ariel when you were in high school, yes?
Yes.
And that was something that you chose to do, right?
Yes.
Okay. You were in Pittsburgh with where your dad was and your mom, Jessica, was, correct?
Yes.
And you chose to move to Maui to be with your dad and Ariel, yes?
Yes.
And so by the time we get to 2025, how long had you been on Maui? Roughly.
2 years at that point.
Okay. You had a girlfriend at the time, yes?
I did.
You had made friends on Maui, yes?
I did.
Your two younger brothers were there, yes?
Yes.
You had a job on Maui in March of 2025? What kind of job?
I worked at Chick-fil-A at the time.
Were you going to school?
I was not.
Okay. And you liked it on Maui, right?
Yes.
So your options were to stay in Pittsburgh with your mom. You could have done that, right?
Yes.
Jessica, right? If you could have stayed in Pittsburgh with her if you chose to, right?
Correct.
Or you could come back to Maui, where your friends were and your girlfriend was, but to do that you would have to live with Ariel, right? To come back to Maui, you could come back to Maui and live with Ariel, right?
It was an option, yes.
Yeah, it was an option. And over the last year, since this incident, you have continued to live with Ariel, correct?
Yes.
You also would see Ariel's parents, Judy and Pete, regularly over the last year, correct?
Correct.
And you refer to them as your grandparents, yes?
Yes.
And they came with you to court today, yes?
Yes.
Okay. And over the last year, though, you've limited your contact with your dad's side of the family, correct? You haven't seen them much, right?
I wouldn't say that.
Okay. Your grandparents, you haven't seen them much in the last year, have you? Or talked to them much?
I have. done both of those things.
How often have you seen that?
Probably seen them
Since
Two-
the incident. Since the incident.
since the incident 2 or 3 times.
The most recent time was when they were gonna come to see you play roller hockey on the mainland, right?
Yes,
And where was that?
Irvine.
And when was that? Roughly.
I couldn't tell you.
Okay. I mean, it was in 2025.
Yes.
Okay.
No, it was 2026.
I'm sorry. I meant that's what I meant. Sorry. It was in 2026.
Yeah.
Okay. And you're into roller hockey. You played a lot.
Yeah.
And you traveled to California earlier this year for a tournament, right?
I did.
Your grandma and grandpa, your dad's parents were gonna meet you in Irvine to watch some of your games, right?
Yep.
And when they got there, Ariel's parents, Judy and Pete, had traveled with you up there, right?
Yes.
Okay. And you have not spoken to your dad since the incident, correct?
Correct.
Okay. All right. Thank you, Emil. That's all the questions I have for you.
Yes. Right. Emil, one of the things that you were just asked about on cross-examination was the fact that you didn't tell the detective on Maui that the defendant told you that Ariel got away. Is that right?
I didn't ask that.
I'm sorry?
I didn't ask that.
Is my memory wrong?
Ask the questions.
Well, can we approach?
And they got to approach, of course. I mean, he should be over there crying. That gotta be messed up to see that she didn't even have him. He came out of you know. Well. Yeah, I think his testimony is good. I think his testimony is truthful. I think that it is what it is kind of testimony. If that makes sense. Like, yeah, he called me, he said he tried to kill her. She had been cheating on him emotionally. Oh my gosh, he is such a goofy. Gosh, and he an anesthesiologist, so I mean, he got money, right? Some money, I don't know. And she had a good job. I don't know why he thought he was going to pay that much in child support. Oh man. Why y'all be letting me talk all ratchet and stuff when I'm on here? I crack myself up. I should not be listening to myself. Oh goodness. Oh gosh. Yes, they are still deliberating, guys. It's just been a little bit over an hour. Oh man. Yeah, it's just been a little bit over an hour, but let's go back into this. I crack myself up sometimes. Oh gosh, he couldn't do nothing right.
You were asked about on cross-examination this being a confusing FaceTime call. Is that right?
Yes.
And you were clarify more for us right here, Emil. Was there any confusion about the defendant telling you he tried to kill Ariel?
Can you reword that?
Sure. Did you have any confusion about that statement by the defendant?
Was I confused at all? Yes.
I'm sorry. Let me. Is there any confusion in your mind about the defendant making that statement that he tried to kill Ariel?
Now?
In general.
yes.
Okay, could you explain?
I didn't expect it.
I'm sorry. I think I'm phrasing my questions poorly, Emil. Is there any doubt in your mind about the defendant telling you who tried to kill Ariel?
No.
Thank you. No further questions.
Any new cross based on what was asked on your right?
No, thank you, Emil.
All right, so ladies and gentlemen, let's take our afternoon recess. Have you come back yet? 3 o'clock. Leave your notebooks on your train. All right.
I don't know what to do.
Home.
I was at home. I was in my living room crocheting and listening to an audiobook.
Right there, that's when the parents get to speak. Both of the parents did come up and testify, Ariel's parents. The verdict clock is at 1 hour and 5 minutes. Let me get us into our next. I think that we should listen to his testimony. Then we can hear about his balls getting grabbed. Yes. Yes, sir. Let me get his testimony up from last week and we'll listen to what he had to say on the. Let me see. The doctor. Wait a minute. Okay, wait a minute. Is this his? Okay, this is his cross. Wait a minute. I want to get up his direct. Doctor. Let me get that up for us, guys. Doctor. Oh, yeah, he was on here all day long. All night long. Okay, let's get into his little testimony. I don't know why I feel like this. I don't know why I feel like this came on different, but maybe it didn't. Let me get up here for y'all.
And for the members of the jury.
Gerhard Konig.
Look
Gerhard,
at how happy.
how old are you?
47.
Where were you born?
South Africa.
And were your parents from South Africa?
Yes.
What are their names and are they still alive and are they still married?
Yeah. Peter and Anwell, they're alive and married.
Okay. And they've been here. Is that them here in the front row today?
That's them.
Where do they live now?
San Diego.
Growing up, what did your parents do for work?
My dad's a pharmacist. And in South Africa, my mom didn't work.
How long did you live in South Africa? Or maybe a better way to ask that is, how old were you when you moved from South Africa?
I was 14.
And where did you move to at that age?
San Diego.
Who moved with you to San Diego at that time?
My parents and my younger sister.
So what grade were you in when you moved to the United States?
9th grade.
Did your dad find work as a pharmacist?
Yes.
What did your mom do in San Diego?
She ran a home daycare.
Siblings?
Yes, 2 older brothers and a younger sister.
What year and what high school did you go to and what year did you graduate?
I went to Rancho Bernardo High School and I graduated in 1996.
By the way, was growing up in South Africa, was English your first language?
No.
What was?
Afrikaans.
Okay. After graduating from high school, did you go to college?
I did.
And where'd you go?
UC San Diego.
What did you major in?
Bioengineering.
Now, the jury has heard about how later in life you married Ariel Konig. Was that your first marriage?
No.
Okay. Were you married before that?
I was, yeah.
And to who?
Jesse Patella Ray.
Okay. How old were you when you and Jesse got together?
16 or 17, 11th grade in high school.
And then how old are you when the two of you got married?
20.
After graduating from college, what did you do?
I worked as a bioengineer for 5 years.
Okay. Doing what kind of work?
It was a biotech startup company. We were doing tissue engineering.
Okay. We don't need to get into exactly what that is, but it's in the field of bioengineering.
Yeah. So specifically, we were growing tissue engineered blood vessels. And so we were taking skin cells from a person and culturing them in the lab and growing large diameter blood vessels specific to them so they can use it for hemodialysis access or cardiac bypass grafts.
And where were you living when you were doing this work?
In Marin County, just north of San Francisco.
Okay. In California, but up by San Francisco.
Yes.
Did you and Jessica have kids while you were working and living in San Francisco?
Yes, 2 kids.
What are their names?
Ophelia and Emil.
And what years or how old are they?
Ophelia is almost 25 and Emil is 20.
Now, the jury has heard that you're a medical doctor. After doing this work in tissue genesis for a while, where'd you go to medical school?
At the University of Pittsburgh in Pittsburgh, Pennsylvania.
And is that a good medical school?
It is. It has a really good reputation, yeah.
So Ophelia and Emil were born before you started medical school? Or?
Yes.
Okay.
Yeah.
Why did you choose Pittsburgh?
Because the reputation of the school and because the cost of living in Pittsburgh was low.
Okay. And you had the 2 young kids.
The two young kids, and I wasn't going to make any money, and it was a great place to go to school.
Did you graduate from medical school in 4 years?
Yes.
What year did you graduate from medical school?
2010.
After graduating from medical school, what did you do?
I did a 1-year internship, and then I did a 2-year research fellowship.
What was the research fellowship in?
It was an NIH-funded fellowship at the University of Pittsburgh, and I did mostly blood transfusion research. Specifically, I was working on autotransfusion. It's when you take a patient's own blood that they're losing in the operating room, and I was figuring out ways how to give it back to them safely.
Okay. Did you and was that in the Pittsburgh area?
Yes.
Did you eventually do a residency?
Yes.
And in what field did you do your residency?
Anesthesiology.
If you could explain to the jury, what is anesthesiology? I mean, we all kind of know what it is, but generally, how do you define anesthesia?
Yeah, anesthesiologists are, it's a specialty of medicine, and we're trained to acutely treat organ system failure and techniques to limit pain and awareness. And so basically what we do is we take care of patients that are either very ill or injured, and we keep them alive until they can get patched up. And we make sure that they don't feel or remember anything.
Okay. And why did you choose anesthesiology for your residency, and did you enjoy it?
Oh yeah, I loved it. It's all hands-on, which is kind of what my personality is and my background in engineering. So I like that about it. Okay. And yeah, I mean, that was.
So you enjoyed it.
Yeah.
Now, what years were you doing your residency in anesthesiology?
2013 to 2016.
And where was your residency at?
In Pittsburgh.
Now, you mentioned your residency 2012 to 2016. Did you at some point you and Jessica got divorced?
Yes.
Or approximately when was that? Or when did you get separated?
We separated in 2014. Yeah.
During your residency.
Mm-hmm. Yeah, after 15 years of marriage, and we try to make it work. We got married very, very young.
Okay. Did you after that you guys were both living in Pittsburgh?
Yes.
And were you involved in Emil and Ophelia?
Oh yeah, 50-50 custody.
50-50 custody.
Mm-hmm.
You finished your residency in 2016. What did you do for work when you're done with your residency?
I was hired as an anesthesiologist by UPMC. I worked at UPMC McGee Women's Hospital. And then I was also hired by University of Pittsburgh as a part-time assistant professor.
As a part-time what?
Assistant professor.
Okay, so in terms of your work that you were you doing clinical work, actually treating patients in the hospital?
Yeah. So 4 out of 5 days, I was doing clinical work, anesthesiology, and basically 1 day a week. So 20% of my time I was doing teaching and research.
And so teaching, who were you teaching?
Anesthesiology residents, mostly at the hospital. And for the last 3 years that I was in Pittsburgh, I was the site director for the anesthesiology residency at my hospital. So I was in charge of the teaching of the residents at the hospital there.
And that was all in Pittsburgh?
Yeah.
Okay, now, after separating from your first wife, did you at some point start dating again?
Yes.
And did you try out dating apps?
Yes.
How'd that go?
I used some free dating apps in the beginning and met some people and finally signed up for a paid app, eHarmony.
eHarmony.
Mm-hmm.
And after you signed up for eHarmony, is that how you met Ariel?
Yeah, she actually found me on there and we connected on there and chatted on there for a little while. And I think we connected in February of 2016, and then we met in the bar at the end of March 2016.
Your first time you met her, first date-ish, what you want to call it, was at a bar?
Yes.
In Pittsburgh?
Mm-hmm.
Okay, and then did you guys continue to see each?
Yes.
Is that a yes?
Yes.
Okay, sorry, I should correct you. And after that, did you guys continue dating?
Yes.
I think you said you met in 2016?
Yes.
When did you and Ariel get married?
2018.
Between 2016 and 2018, where were you living?
We were both living in Pittsburgh in like kind of different suburbs of the city. She lived north of the city, close to where she worked, and I lived kind of to the west of the city. We were about an hour apart, but so we spent 1 week at my house with the kids when we had the kids, and then we'd spend 1 week at her townhouse up north.
And that was in Pittsburgh?
In Pittsburgh,
okay.
Yeah.
And you were working in the job you just described to us?
Yes.
Now, after your first divorce, you had 2 kids. Did you want to have more kids with?
I did.
With
Yeah.
Ari?
Yeah. Yeah. I had that in my profile on online dating and.
That you wanted to have more kids?
Yeah.
Okay. And did you and Miss Konig have kids together?
Yes, 2 kids.
And what are their names? And tell us when they were born.
Olin was born right in the middle of COVID, May 2020. Okay. And Vigo was born just a few weeks before we moved to Maui in 2023.
Just a few weeks before Maui?
Yeah.
Okay. In 2023?
Yeah.
So you guys are still living in Pittsburgh when, well, at least Olin, 2020, you guys are in Pittsburgh. Did there come a time when you and Ariel decided to make a move and move to Hawaii?
Yeah.
Tell us about why that came up and what was the interest and if it was a joint decision.
Yeah, it was a joint decision, and this is something that we kind of bonded over ever since we met, and we both love Pittsburgh and love the city and the town and Steelers fans, but we wanted to move somewhere where the weather's a little nicer. She knew I had family in California, and so we had talked about that for a while. And then after we started having kids, we started talking about it some more and realized that actually our main priority is safety and just finding kind of a place where we can raise our kids in a safe environment.
What do you mean by safety?
Just like the random gun violence, like school shootings and things like that, were really concerning for us. We wanted to go to somewhere where that's relatively rare or less of a concern.
How did you guys decide on Maui?
I came to Oahu actually once during residency, when I was doing my research fellowship, and just kind of fell in love with the atmosphere. There's just kind of a joy to life here, and the tempo is just different than anywhere else that I've been in the United States.
Okay. So you guys decide on Maui.
Well, and then we went to Maui for our honeymoon and our friend's honeymoon too, and that's kind of how we got introduced to Maui.
Got it. Now, you said that it was a joint decision about kind of putting the kids first and safety.
Yeah.
Was it gonna moving from Pittsburgh to Maui? Was it going to have an impact on both of your careers? And let's start first with yours. Tell the jury if it was. How was it, if any, it was going to affect your?
Yeah, it was going to have a big impact on my career. So I was going to have to give up the teaching and the research completely. And my job in Pittsburgh was at an academic medical center. And even when I wasn't working for the university, I was interacting with students, residents, and things like that.
And on Maui, that was
on Maui, it was just going to be like a community hospital and some kind of very, very different.
And what about the research part of your job?
Yeah, so I have to give all that up.
And you're willing to do that?
Yeah, we were basically committed, both of us, to going somewhere where we could focus on the family and slower pace of life, at least until the boys were out of high school.
Okay, so now you just shared about the effect it's going to have on your career. What about Ariel's career? Explain to that. She talked about being, at least for a while, in the nuclear industry. So when this decision was being made about moving, what was going on with her career, and what was her how was this gonna?
Yeah. So by the time we made the decision to actually move, which was like in the summer of 2022, it actually didn't affect her career that much. If we had made that decision earlier, it would have had a much bigger impact.
Why wasn't it going to affect her career that much?
So she was working. So before COVID, she was working 100% in-house, full time, and then during COVID, her job went remote, like most people's jobs did. And then during COVID, we also had Olin, and she realized at that point that she didn't want to go back to working in person again.
Okay.
That she felt she could accomplish a lot more at home, working and just be much more efficient. And it also allowed her to just be home more with the kids and the family.
Was she still?
Was
she still in the nuclear industry when you guys decided to move?
No. So and then she actually quit her job a few months before we started talking seriously about moving. Okay. And she was applying to jobs at software companies and other industries and nuclear as well. And then we decided to move, and so this was all kind of happening at the same time.
Okay. And was she able to get this job? She talked about a TerraPower that allowed her to work virtually.
Yes, and so she was actually hired. I think, like as I was interviewing in Maui, she got hired at TerraPower. So she started her job at TerraPower while we were still in Pittsburgh.
Okay, but they were going to allow her to.
And then after the move, yes. So she got a fully remote job based out of Pittsburgh for this company that's based in Seattle, and then we moved to Maui, and then she kept working for the same company.
Okay. I want to ask you, Emil. So Ophelia is older than Emil?
Yeah.
Okay. So when you guys start thinking about moving, how old was Emil, and how did that factor into the timing of when you were going to move and if?
So Emil is actually the reason we moved when we did.
Okay,
so,
explain that.
Yeah. So Ari and I had talked for a while about moving out of Pittsburgh, and the trigger was going to be when Emil graduated high school.
You guys are waiting. You guys are going to wait till he graduated.
Yeah, because we didn't want to leave him, and we didn't want to ask his mom if we could take him.
So what happened?
He basically talked us into letting him ask his mom, and because he's like, if you guys are going to go somewhere sunny after high school, I want to go with you, and I want to go before high school is over because I want to move somewhere earlier so I can make friends and kind of get connected to the community. And I said, I don't think your mom's going to let you leave. And he said, let me just talk to her. And after months of that, I said, okay, if you want to ask her, you can. And he asked her, and she actually said yes. And so that triggered us to kind of say, oh shoot, now we can move now. We can move earlier. And so
let me ask you about that. So at this point, Emil was about what age?
15.
Okay.
Yeah.
And so you talked about how you were married and while he was growing up, and then how old was he roughly when you guys got divorced, you and his mom? Roughly.
9.
Okay.
Yeah.
And so from when he was born till 9, you obviously very active in his life. Is that right?
Yes.
And then after that, you had him every other week. Is that right?
Yes. Yes.
And then come a time now he's 16, and he's actually asking if he can go to Maui with you. Is that right?
Yeah.
Okay.
Yeah. No, we've had a really good relationship.
Okay. And so that kind of made the timeline where you guys could go sooner. Is that right?
Yes.
And what about Ophelia? By the time you guys were moving, was she already over 18?
Yeah, she was over, and she had moved out of the house already, and so yeah, she didn't come to Maui with us.
Okay. Now, so when you first moved here, did Emil then finish high school on Maui?
Yes, Maui High.
We heard about how Miss Konig's parents or Ariel's parents also moved to Maui. How did that happen?
Yeah, no, they that was really nice actually, how it worked out. But because we didn't have any family here,
Okay.
and two young boys. But when we told them we're moving to Maui from Pittsburgh, and they were living in Florida at the time, they said that that's too far, and they actually decided
away from you guys.
Yeah, and so they decided they're going to move to California because they didn't want to move to Hawaii, but they'd never been to Hawaii, and so they had this trip planned where they were going to go look at a few different places in California, and we convinced them to come to Hawaii too for a few days,
Okay.
just to basically, visit with us.
Yeah, we're trying to see if they like it.
We just told them, just come visit with us and we'll show you where we're going to live.
Yeah.
This was right before we actually moved. And
Did they like it?
in less than 24 hours, they were like, we're coming here. Yeah.
And that was okay with you?
Yeah, it was great because they ended up buying a house just down the street from our house, and we see them, we would see them all the time, and they're a big help with the kids, and it was just nice to have family on the island.
So you, when did you guys move then to Maui?
So I had to give 6 months notice at my job. So I got a job offer in like August of 2022, but we didn't end up moving until end of February of 2023.
Okay. And your job offer on Maui was what?
It was so the group's called TMG, and we're the only anesthesiology group on the island. It's a private practice group. So
you applied with them?
Yeah.
And they hired you?
Yes.
So I know this is a big question, but I'm going to ask you to kind of just maybe summarize. You get here to Maui, March 2023. You got these two young kids, your son's here, your in-laws are here. You got a job. What was life like for you and your family from March 2023 until December 2024? Can you just summarize what it was like?
Yeah, it was amazing. The move was a little stressful at first getting here, but once we were here and settled in, it was our dream life. So we bought a house really close to the hospital so I could walk to work. It also meant that I could take all my call shifts from home, and whenever I was done at the day, I could be home in a few minutes. And it translated into me being home a lot more than I was in Pittsburgh at my previous job. And so that meant that I was spending a lot more time with the kids and with Ari and with Emil. I was doing a lot of home improvement projects. And then as a family, we were doing lots of exploring. Like every weekend we would explore Maui. We did a lot of, beach activities. We went to the beach almost every weekend, snorkeling, surfing, paddleboarding, hiking.
Okay. So it was a good life.
Yeah. We made a bunch of friends through my work and through Olin's preschool, some of his friends and friends' parents. And we were getting settled in.
Yeah. And let me ask you, Ariel, when you testified, when the detective asked her about how the marriage was before December 2024, she said it was a good marriage. Do you agree with that?
I thought it was a great marriage. Yeah.
Okay.
I totally agree.
I just had a question. That being said, during that time period, did it ever come up that area between that time period, did moving back to the mainland ever come up?
It did. So her job, and when she was first hired by Terra Power, they'd asked her to move to Seattle, and they said, "Hey, would you move to Seattle?" And she said no.
Okay.
And then a few times they had kind of asked her again to, if she would consider that.
Okay.
Our plan was always to at least stay in Maui until the kids graduate high school, and then we can kind of focus on our careers again and let the career drive the decisions.
Now, I was asking a little bit about your marriage during that time period, and this came up with Ariel. In your marriage back then, who handled the financial affairs more so, like, taxes, life insurance, insurance, finances between the two of you?
I did.
Okay. And why was that so?
I'm a very meticulous kind of person that keeps track of everything, and so it's just kind of more naturally in my
Yeah, pretty organized.
Yeah.
Did you have like computer files with different insurance, taxes, all that stuff?
And all of our things were joint. We didn't have any separate anything, and so I ended up taking care of most of those things.
And those computer files.
And they were all in a shared drive that we shared, and so she had access to everything, and she contributed and as well. But
Okay.
I took care of most of it.
Okay. And you would kind of from time to time look into the files or update the files or
all the time.
Okay.
Yeah.
All the time?
Yeah.
Now, you just described a great life and great marriage. Did there come a time in 2024, Gerhard, when that changed?
Yes.
First of all, in 2024, at some point, well, let me ask you this preliminary. Did Ariel have to travel for work?
She did. Yeah.
Okay. And that's because she was working virtually?
Yeah. Just like three or four times a year.
Okay. Did there come a time in 2024 when Ariel traveled to South Africa for work?
Yes.
Do you remember when that was roughly?
At the end of August of 2024.
And who was she going with, to your knowledge, at the time?
It was a pretty important trip for her because it was just the CEO of the company, another man that was high up in the company called Jeff Miller, and herself.
Okay. Now, I want to ask you this. By the way, when you guys were on Maui working, and she was working virtually, like where was she actually doing her work? Like when she was working?
Yeah, she had a home office set up, but it was in her house. In our house,
Okay.
but it was in our bedroom. So, and there was no divider or anything between it. So her desk was basically right next to our bed. So like a third of the space in the bedroom was taken up by her office.
And when what were her hours? Was she on Seattle time? She started?
Mostly West Coast time, sometimes East Coast time. So she would usually get up
Early.
either 4 or 5 a.m. and start work around there, and
So-
then work until around 2 p.m.
So were you because it was in your bedroom? Were you exposed a lot to
a lot
her
yeah.
work and her things she
Yeah.
was doing and the
Yeah,
people?
she has a huge monitor on her desk. She has one of those desks that can go up and down,
Okay.
And it's facing into the room, and all of her meetings are on speakerphone.
Okay. Prior to this, well, leading up to this South Africa trip, you mentioned did she go with a man named Jeff Miller?
Yes.
Did you have any concerns about Jeff Miller at that time?
No.
I know you mentioned no concerns, but was there anything weird on that trip, behavior-wise, that you took notice of? The South African trip?
Yeah, it was a really quick trip. It was just 2 nights. But the one weird thing was that on the second night, I remember noticing that she never contacted me at the end of the day, and that's kind of out of character. Whenever she went on work trips, she would always kind of check in at some point. And at the end of the day, even usually we would check in several times during the day as well, and just through text. We would text a lot.
Okay.
And the one night on that trip, she never reached out, and I was at work, and by the time I got home and realized that she hadn't reached out, I knew she was asleep, so I didn't reach out to her either. But normally she would reach out to me when she's done with her work day.
Did you see much of it at the time, or?
No, I took note of it, and I asked her about it, and she just said, like, "I'm so sorry. We got back late from dinner with the hosts that were hosting us, and I'm sorry. I should have texted, but I didn't."
Now, she returns from South Africa. Later on in 2024, did you and your family go on a trip to Kauai?
We did, yeah.
When was that roughly?
In October. I think it was October. Yeah, we told Emil as a graduation present, we'll take him to one of the other islands that he hasn't been to yet for a little trip, and he picked Kauai.
He picked Kauai. Now, did anything happen on this Kauai trip that made you become concerned to a degree about Mr. Miller?
Yeah, a little bit. Like,
What happened? Tell the jury what happened.
Yeah. So we were there at the end of I think from like Thursday to Monday or something like that. So it overlapped with her work week a little bit, and she was able to take most of the time off, but there was a few meetings that she still had to do that she couldn't. And so and they're early morning meetings because they were West Coast time, and I just overheard her talking to him on the phone and from the other room, and it just seemed that they had a very familiar tone. More so than what I was used to the way that she used to talk to him and the way that she talked to her other work colleagues.
Now, you get back from Kauai after the trip, from October to December. Did you notice any other red flags or concerning behavior?
Yeah. So
what happened?
The biggest, the only thing that I noticed was that she was constantly on her phone. She was just constantly on her phone.
Was that more so than usual?
Yeah, much more than usual. And she would hide the screen from me. So
what do you mean by that?
Like, if you're sitting next to somebody and they're on their phone, like you can just notice that they're sitting in a way. They're constant. They're always just like moving their.
What if you like walked into
screen.
a room when she's on?
Yeah, when I walked in the room, she would turn the screen off or turn her phone upside down.
Did you ask her about it?
I did several times, and she would always say, "I'm talking to Gianna. I'm talking to Gianna," which is her best friend. Who's
Gianna?
Gianna's her best friend.
Okay. So you did ask her about it a couple of times.
Yeah, more than a couple.
And you continue to see this concerning. Well, was this behavior concerning to you?
Yes.
And
I was curious.
Okay.
I was concerned. You're right.
And did she told you it was, don't worry, it was just Gianna?
Yeah, and she was like defensive about it.
Okay. Now, what did that lead you to do in early December? All this behavior, red flags.
No, when she kept doing it and she kept being defensive, I unlocked her phone.
Okay.
And while she was sleeping.
Now, do you recall when you did this? There's been talk about a San Luis Obispo trip, right? Were you guys going to go on a trip in December?
Yes.
And with who?
With our friends Brant and Gianna.
And so, what day of the week were you going to leave for the trip, if you recall?
So, Ari and Gianna were going to be there on Wednesday.
Okay.
And Bryant and I were going to join them on Thursday.
So the girls were going first.
Yeah, and then we're all staying there until Sunday.
The girls were going to go spend a night together.
Yeah, so they had like a girls' day planned, and they wanted to just go for the first day. The trip was mostly for Gianna's birthday.
So that was going to be on a Wednesday. When did you look into her phone?
On Monday night.
Okay, right before the trip, a couple of days before the trip.
Yeah.
So tell the jury what you discovered.
So Monday night, when I looked at her phone, I went to the screen time application on the iPhone, and then I noticed that the app with the highest usage was an app called WhatsApp. And I was
What is WhatsApp?
WhatsApp is a communications app. So it has texting, it has voice calls and video calls. So instead of using your phone's built-in texting or voice or video, you go through WhatsApp.
Okay.
And it's separate from the phone.
So then once you saw that?
Yeah. So then.
Well, first of all, I mean, was that surprising to
you?
you?
It was. I had not seen her on WhatsApp at all over the previous months. And so I was very surprised about that. And then I also saw that she had turned off all the notifications for WhatsApp. So she had everything silenced from WhatsApp. And it wasn't like on the main screen. It was like a couple pages over in a folder. So it was kind of hidden.
So did you open the WhatsApp?
Yeah. So I opened the WhatsApp.
What did you see?
And there were 2 conversations with Jeff Miller. And the way WhatsApp works is that your account is always linked to a phone number. And so the one conversation was a conversation with his work phone, and the other conversation was a conversation with his personal phone.
Okay. And so let's talk about the conversation with his personal phone. What tell the jury what you saw?
Yeah, it was. So what I saw. So this was Monday night. What I saw was that the messages from Monday and from Sunday, so the previous 2 days, it was like a full-on conversation the entire day long, and it would start off. Yeah, and it would start off at like 2 a.m. Hawaii time. So and Jeff Miller lives in Maryland. And he travels extensively for work. Like he probably travels 3 out of every 4 weeks. And I know this because I'm always hearing them on the phone and talking about that. So basically, wherever he was, he'd be texting her good morning, but it wasn't just like a good morning text. It was like 5 or 6 texts. It's like a whole, like a good morning. I had a great, I slept great. I'm looking forward to the day. Hope you're sleeping great. And then at like 5:45 a.m., her good morning.
She would be responding.
She would respond. And then the whole day long, like, this is where I am. This is what I'm doing. This is what I'm thinking. Until, good night at the end of the day. And that was for Sunday and Monday.
Okay.
So for the 2 previous days.
So Sunday is a weekend, right?
Right.
Yeah. So you saw on a Sunday, we saw the text from December
she's
1st.
I'm at work. I'm on call for the weekend, and she's at home decorating and hanging out with the kids and
texting him all day.
Texting him all day.
Okay.
And then
go ahead.
When I scroll back past that, it's very strange because then between so the thread was created on June 4th or something like that, because WhatsApp puts when the thread was created in the app.
Okay.
And there was no messages between June 4th and August 30th, which was like a few days after the South Africa trip. And then between August 30th and Sunday, it was very strange because there's like fragments of conversation or little short things, and then mostly just pictures and songs and links. And it was basically Jeff sending her a bunch of pictures of himself, a bunch of song links that she had saved, and her sending him like a bunch of pictures too of. Did
you when you said it was strange because there was things missing? Did it seem to you like things were being deleted?
Well, yeah, because obviously that was. I mean, there was an abrupt cutoff between like what's before Sunday and Monday and that conversation and everything else that was on there.
Let me ask you this. Seeing all of that, here you are a couple of months now, you had some suspicion, some red flags, asked her about it a couple of times. She denies it, defensive. Now you open it up and you see this.
Yeah.
Tell the jury how you felt. How did it make you feel?
I was devastated. There's obviously something going on,
okay. So
I didn't know what to do.
Okay. So what did you do?
So I had actually started using WhatsApp myself when we moved to Maui, because that's the main communication platform that the anesthesiology group uses. And so I was using it every day, communicating with the rest of the group and during our business meetings. And so I knew that WhatsApp, since even though it's primarily an app on your phone, there's a web interface. You can log into WhatsApp on your computer through the browser as well. And it'll basically just duplicate everything that's on your account.
And then what did you do the next day?
So I took her phone upstairs to my computer, which is in the hallway upstairs, and I logged into her WhatsApp on my computer.
So you could watch her.
So I could see, because
Okay. You mentioned being devastated. I mean, prior to this, did you have any, aside from we talked about the red flags, but marriage-wise, I mean, everything seemed okay?
Everything seemed fabulous. We were. We were very happy together. No red flags in terms of the marriage itself.
Okay. So now, you want to learn more. You want to what do you call it, like detective mode, kind of?
Yeah.
Okay. So now you logged on and you're able to watch her. And did you do so the next day?
Yes. Excuse me. Yes.
Tell the jury what you saw the next day?
So the next day, it was basically the same type of thing that they were doing on Sunday and Monday. So, they start off by saying good morning and then, just was in communication the entire day. But this day, she started deleting messages. And so one of the first things that she did is she deleted all of the messages from Sunday and Monday.
Okay. So when you went, make sure you put the mic a little closer. So when you saw the messages the night before.
Yes.
And now you're looking at it on the computer next day, and those messages you saw the night before are deleted?
Yes.
Okay. And then what?
And then I saw them communicate kind of in real time, because I could see it pop up on my screen too. And, as soon as the conversation proceeded, kind of past, she would kind of keep deleting the previous messages. So she was like, not deleting them in real time, but like throughout the day, she was deleting the previous messages.
And the content of the of the communications and what was being deleted, again, was it concerning?
Yeah, I mean, it was the same type of conversation that she was having with him on the previous 2 days, which is not a conversation you have with a coworker. This is a conversation you have with your spouse. I mean, this is
and after watching that all day long, what did you conclude? I mean, in terms of what was going on, did you believe?
I mean, she was having an affair.
Okay. Let me ask you this: while that was, did you because she was deleting these things? Did you try to save some of the messages?
Yes. So the first thing I did, actually, the night that I unlocked her phone, because on WhatsApp you can also export the thread basically and save the thread, and so I exported the thread to my phone. So I had copies of what was on there when I first discovered it, and then the next day on my computer, the only thing I could do on the web interface is take screenshots.
Okay. And you took some.
Yeah.
All right. So now you are faced with, this. You got this trip in a day or two. Do you confront Ariel right away?
Not right away. So the way that this was happening was that our trip to San Luis Obispo, there's no direct flights from Maui to San Luis Obispo, and so we coordinated that the layovers were going to be in Phoenix, which is where Brian Gianna lives, and Ari was taking a red eye on Tuesday night. And so on Tuesday, when I was first discovering and watching this kind of in person for the first time,
let me stop you there. So just to help the jury. So Monday night is when you first found the WhatsApp chain, is that right?
Right. So Monday overnight.
Tuesday
morning, I wake up and I start looking at them interacting in real time during the day.
And then Ariel's supposed to leave that night.
And she's supposed to leave that night.
Do you confront her before she leaves?
I do not.
Yeah. And then so she leaves. Who do you first reach out to talk to about this?
Yeah. So on Wednesday night, I'm supposed to leave to fly to Phoenix to meet Bryant and then go to San Luis Obispo.
Okay.
And Wednesday, like in the middle of the day, I call him and talk to him.
Okay. And why did you call? Why did you call Bryant to talk to him about it?
Few different reasons. One was that we were, about to go on this trip with them, and I wasn't able to. Like, I knew I was going to have to confront her as soon as I got to San Luis Obispo. So now it's Wednesday, and I'm convinced of, I'm seeing what they're doing, especially what she was sharing with them on Wednesday. So on Wednesday, she was spending all day in San Luis Obispo with Gianna, and she's basically keeping him up to. I mean, first thing is, like, as soon as she lands in Phoenix in the morning, she's like, just landed. I have an hour and a half. If you're free, we can chat. Can't wait to talk to you.
Is she texting you, keeping you up to date?
Like, I'm getting, I also got a just landed text, but like nothing else,
Okay.
and but she's like, reaching out to him, and on WhatsApp, like, you can see when a message has been read. And so as soon as she saw that he read her just landed text, she called him, like, right, she didn't wait for him to respond.
Okay.
And stuff. And like, I'm not getting a call. I'm not getting any of this stuff. And then during the day, she's sending him pictures of the places that they're of her and Gianna doing stuff.
So you're seeing this.
So I'm seeing this, and that's at that point I'm just like, I can't go to San Luis Obispo and not confront her about this right away. Like,
and going back to Bryant, right? So I know.
Yeah.
Did you guys have like fun activities planned? It was supposed to be a fun couple trip?
So I mean, it was supposed to be a couple's trip, right? And it was Gianna's birthday, and actually Ari planned it because she used to work for, one of the power plants that she that was her responsibility for refueling is just outside of San Luis Obispo. So she used to travel to San Luis Obispo all the time for work, and so
were you
planned like
were you
a bunch of
reaching out to Brian? And you said there's several reasons. Was one of it to kind of let him know, like, hey, this might not be the fun trip we had planned?
So the first reason was like, hey, like, this is, I'm just giving you a heads up. Like, I'm going to confront Ari with, basically an affair.
Was there other reasons why you wanted?
And then the other reason was that, the other reason why he's my best friend and I wanted some advice, but I specifically wanted advice from him because they had just gone through infidelity in their relationship. like 6 months earlier.
Brian and Gianna.
Brian Gianna. And
Okay.
so
They were dealing with that.
yeah, and so he had been dealing with this, and I was looking for advice and just needed a friend.
Just to be
talk
clear
to.
for the jury, in that situation though, was it reversed? Was
It was, yeah. Brian had like a one night stand, and Gianna found out about it.
So they had been dealing
kicked
with
him
that
out of the
for months
house
now.
and stuff. Yeah.
And so you talked to Brian.
Yes.
Do you fly up on the trip?
Yes.
When you get there, do you confront Ariel right away?
Almost right away. I mean, like right when we get there, they already have dinner reservations and stuff like that waiting for us. And so we go to dinner, and right after dinner, when we go back to the hotel, is when I confront her.
Did you talk to Gianna before you confronted Ariel?
Very briefly.
Okay.
Yeah.
Okay. And you told her what you had found.
I basically just gave, yeah. I told her briefly what I found, and then left to go talk to Ari, and left Brian to explain to her more.
So, where do you confront Ari? Were you in the hotel room?
In the hotel room.
You confront her with it. Tell the jury how that went and what Ariel's initial reaction was.
Yeah, I confront her with it, and she's immediately remorseful and doesn't deny anything, admits to it, and is crying and
let me ask you this. You say admits to it, and when Ms. Konig testified, she kept using the term you guys use the term emotional affair, but in that time period, what did she admit to? Having a
she admitted to having an affair. Yeah.
Okay.
Yeah.
With Jeff Miller.
Yeah, she admitted this was completely inappropriate relationship.
Okay. And so you mentioned
we called it an affair from the start.
And you mentioned she was remorseful and crying.
Yeah.
Okay.
Yeah.
Now, here we are now in San Luis Obispo. This is going on. What was your emotional state like at the time? In other words, what were you thinking needed to happen? And like, you guys were going to try to work this out or not, or while you're on the trip?
Yeah, no, I mean, it was tough. I mean, a lot of emotions for sure, but Brian and John were really helpful. And we were away from the kids and away from work and away from everything else. So we can kind of just focus on this.
Okay.
And
you guys reached some kind of conclusion as to whether or not you guys were going to break up or what?
Oh, yeah. So yeah, we both wanted to work on it. We both, well, she basically said, like, I'm so sorry. I can't believe I did this. And I'll do anything it takes to heal our marriage.
Okay.
And you and our kids are more important than anything to me. And, I'll do whatever it takes. And we start talking to Brian and Gianna, and they kind of help us talk about some things, and we figure out, what the next steps are going to be.
Now, during the trip in San Luis Obispo, did the topic of her possibly moving out come up?
Yes. That was one of the big conversations we had.
And did you guys settle in on, okay, she's not going to move out just right now, we're going to try?
Yeah, so I preferred for her to move out.
You mean like break up?
No, we were both committed to working on the marriage, but and this is what Brian and Gianna did too. So Brian ended up living in a hotel for like 3 months, and it helped them just focus on the affair and healing from the affair, and then they kind of moved back and kind of start working on everything else, and I felt that was an ideal solution.
Did she want to do that?
Well, both of us, we decided together not to do that, and because we had the two big complicating issues for us was one, our two little boys. So we at the time they were like 1.5 and 4.
So at this time when she was having this relationship with Mr. Miller, how old were the boys?
1.5 and 4.
Okay. And you're saying obviously if she moved out, it would have been traumatic on her.
Yeah, so we didn't want.
Okay. So you guys, it's okay. You guys decide to not do that, and
Yeah, we didn't want them harmed.
Okay. So let me ask you this: in order for her to not move out, to avoid that harm, Mayor Pro Tem.
Thank you. Excuse me one second.
You want water?
Yes, please.
You mentioned the kids. Was there a did Ari have other concerns about her moving out?
Yeah, and the other concern, and again, this is a joint decision, is that we wanted to protect her reputation with family and friends, and so Bryant was able to move out, and really nobody else knew. It was just Ari and I actually that knew, and that was it.
So in other words, if Ari moved out on Maui, you talked about you guys had formed a pretty good close group of friends. Her parents.
We did, and everybody lived right there, and it's a small community, and I mean, people were going to know that she moved out and would ask why, and
so that was part of the joint decision.
Yes.
So you guys are up there, San Luis Obispo, decide that we're going to try. It's not going to move out. What about where there's some talk about if we're going to do that, at least initially, was there some talk about what was needed to happen as it related to Jeff Miller and her job?
Yes.
What was that? Tell the jury about that.
Yeah. So, I mean, she obviously needed to terminate the affair immediately, but also to terminate all contact with Jeff Miller. And that would involve her quitting her job and getting a new job.
Initially, what did she say? I mean, was that something she was agreeable to initially?
Absolutely.
Okay.
And so we decided that was the plan. And she said she just needed a little bit of time. And so she didn't want to quit her job right away, but that she would limit contact with him. And so she actually sent him an email through work, like a work email, and said, basically, hi Jeff, from this point on, all of our communication needs to be in email only. If we do meet, because they would have virtual meetings all the time. If we do meet, it would have to be with one other person present. And she did this without talking to me, but showed it to me afterwards. Hey, this is what I did. Is that okay? And I said, that's fine.
So the plan was that she was going to quit her job and maybe find a new job. But in the meanwhile,
for sure, she was going to quit her job and find a new job.
Okay.
But in the meanwhile,
there was going to be some boundaries related to her interactions with Miller.
Yes.
Okay. Was she supposed to go on another work trip with Jeff Miller soon after the San Luis Obispo trip?
Yes.
To where and when?
So the San Luis Obispo trip ended on Sunday. And then on Sunday, I was going to fly back to Maui to take care of the kids. And she was flying to Seattle. And she had a week-long business trip in Seattle starting right after this
right
trip.
after? Mm-hmm. She's going to go straight? And Mr. Miller was supposed to be there?
Yes.
Did you later learn anything about the hotel situation related to that?
Not even later. It was. I mean, so while we were in San Luis Obispo and while we're still talking about all these things, she, I told her basically, I'm not okay with you going to Seattle. She said, no, I totally understand. And she said, I'm going to cancel that trip. And she admitted that she had changed her hotel from the hotel that she was supposed to stay in with her primary team that she works with at Terra Power to the hotel that Jeff Miller was in. And they already had dinner plans for Sunday night.
And then she canceled that trip.
But she canceled all of that. So she told work she had a family emergency and couldn't go. And so we flew back together to Maui on Sunday.
You get back to Maui on Sunday, and you there was some kind of initial conversations about what needed to happen with her job and whatnot. When you get back to Maui, are you still kind of just trying to figure out how to deal with this whole situation?
Yes.
Did you tell anyone other than Gianna and Brian?
No.
And was that for the reasons you talked about earlier about Ariel's reputation?
Yes.
But you did. We saw the email that you sent at some point to Mr. Miller's wife, right?
Oh, yeah. And I did that in San Luis Obispo.
Yeah. And that was in San Luis Obispo. Okay.
Mm-hmm. Yeah, that's the day that I found out.
Yeah. And
that's not true. That's the day that I confronted her about it.
And why'd you do that?
I just felt that if I was in her shoes, I would want to know.
Okay. Okay. So now you get back to Maui, and to your knowledge, immediately after was as far as you knew, Ariel limiting contact with Mr. Miller?
Yes.
Did she ever start to look for a new job?
Yes, right when we got to Maui, she was updating her CV and her LinkedIn profile and looking for jobs.
All right. At some point, did you start listening to some audiobooks and trying to get some advice about how to heal from this?
Yes.
And what did you learn from those books about what, was necessary if you guys were going to even have a chance at this?
Yeah. Listen to several books and talk to Bryant a lot, and there's a lot of different things that the books recommend, but the 5 main things are basically, the first is always to terminate the affair, obviously, and terminate all contact with the other cheating spouse.
Okay.
And all the books talk about, if this is something at your workplace, you need to quit your job or move departments or something like that, because it's something that's commonly happens between coworkers. And then the second thing is that the cheating spouse needs to put in the work to understand all of the damage that they've caused to the relationship, and because it's not immediately apparent, just how deep the trust issues are going to impact things, and potentially putting the family dynamics and the kids at risk and things like that, and all the different ways that you hurt your spouse. And so that was the second thing. The third thing is,
was there anything about privacy?
Yeah. So one of the main things is actively rebuilding trust, and that means that you're going to have to proactively give up privacy and then also tolerate some invasion of privacy. Meaning, basically, you need to tolerate if your partner is saying hey, can I see your phone, for a sec and see who you're talking to, or hey, I can I see who you're emailing, so
not get defensive.
And not get defensive. Yeah.
Okay. Now, and did you discuss those things with Ariel?
Yes.
And what was she doing these things?
In the beginning, and then very inconsistently the rest of the month.
Very what?
Very inconsistently the rest of the month.
So she was kind of initially willing to do some of these things, but then seemed to become unwilling.
Yeah. So basically, it seemed like her whole attitude changed really within a few days of us getting back to Maui.
Tell us about that.
She started minimizing the affair and trying to say that it wasn't a big deal. And she started blaming me for the affair and just saying well, you caused some of these things, and some of the, telling me some of the things that I was doing that, potentially contributed her doing.
Was she open to your questions about, hey, let me see your phone, or who are you calling?
On and off, she would get defensive and get irritated at me, basically asking those things.
So when she was kind of now backing off of some of the things you guys initially agreed to, did that cause you to kind of go into detective mode again and look into, try to obtain more information about the extent of her relationship?
Yeah.
Okay. And what new information, if any, did you learn at that point?
I was trying to talk to her about the affair and just trying to get more details, because we didn't talk about it in detail in San Luis Obispo. We were just kind of talking about big picture. Are we going to stay together?
Okay.
Are we going to move out?
But she admitted
all
to
these
it, though,
things.
right?
Yeah, she admitted to it. And then later, a few weeks later, I was looking, and the two main things that I found out. Let me just back up. So I was trying to ask her more questions about the affair, and she wouldn't basically engage and answer questions. And so everything that I found out is I basically found out on my own. And I found out that when they were in South Africa on our phone bill, actually, there's records of them texting just through regular text, up through past 10 o'clock on that night that she never got back to me. And then again, like a 1-minute phone call at 5:30 the next morning, local time. And I was like, that seems odd. And then in that combined with in the work thread that they had on WhatsApp, not the personal one, the work one, the next morning, they're talking about work stuff, but then they're also talking about how they can barely stay awake and they're both so tired and
that made you wonder.
Yeah, I just.
What else did you learn? What else new things did you
learn? And then the other thing was just the sheer scope of the number of deleted messages, because I saw that WhatsApp has a statistics area where you can go to for the app that shows you how many total messages have been sent or received since the last reset of the app, and she had deleted over 10,000 messages during that time.
Over what period of time?
I'm assuming during, so the thread was created on June 4th, and I'm not sure when. She said that the affair started after the South Africa trip, is what she admitted to me. So it was either over 3 months or 6 months.
And you start doing some
but it's like 50 to 100 or like 60 to 120 messages a day. If it's averaged throughout the whole day, and then 19 hours of phone and video calls too.
Okay. This is probably a dumb question, but did that make you feel better or worse about the situation?
No, it made me feel worse, and I was just feeling worse about the whole situation overall, because it takes some time to kind of process all the emotions involved with it and realize all the implications of this. Yeah.
Let me ask you this.
I was getting worse definitely in December.
The new information that you discovered, did you discuss it with her or try to?
I tried.
And how did that go?
She really wouldn't engage about anything with the affair. She kept saying, like, stop asking me questions. It feels like you're asking me 21 questions, like, things like that.
After, this new information, and now it's kind of seems like it's regressing her attitude. Did you ever ask her to move out in December again?
I did. Yeah.
Tell us how many times?
2 times.
And what happened?
So the first time was around the middle of the month. I just told her, like, you're not doing what you said you were going to do, which is to take accountability for your actions and to basically do whatever it takes to heal the marriage. And at that point in time, she became very apologetic and said, "I'm so sorry. Like, you're right. Like, I'll do all those things." But again, that didn't last. And so
the second time?
The second time was, and I remember the date because we had our first couples therapy session was scheduled for December 27th, and December 26th, we got into a big argument about the same thing. And I ended up sleeping on the couch that night. And
did you ask her to move out?
Yeah. So I asked her to move out, and I ended up sleeping on the couch that night.
And again, okay, so when you would bring up moving out, then she would say, "Okay, I'm sorry," and she would say she would recommit.
On the 26th, nothing was resolved that night. We just kind of got in a big argument, and I left and went to go sleep on the couch.
Now, were you having? I mean, again, probably a dumb question, but were you having a hard time with all of this?
Yes.
Could we pull up State's Exhibit S105 that's in evidence, please, Mr. Dirks? Did you turn to any sources to try and help yourself get some advice, get some healing? We talked about the audiobooks. There was this exhibit about Reddit as one after infidelity. What is that about? Were you looking at this? And tell the jury why, if you were.
Yeah, no, it's just a thread about people that are struggling with finding out their spouses had cheated, basically, and advice and also just kind of sharing stories so you feel like you're not alone.
Were you trying to get to a point where you could feel okay?
Yes.
Okay.
Yes.
Was that what you're trying to do?
Yes.
Okay. In other words, you didn't rush straight to get out of here. I don't want to see you again. Kick you out of the house.
No, not at all.
Okay. But it was hard. Was it hard?
It was extremely hard. And
but you were the audiobooks, Reddit. You were trying to get to a good place. Is that right?
Yes.
Okay. We can take that down. By the way, there was this mention about the word Darvo the other day by Inuma. What is? I mean, did it come up on the Reddit thread?
It did.
And what is that about?
And I don't remember the acronym, but basically it was, I came across it, and it's basically something that quite often happens. And so basically, you know, the person that got caught having the affair, sometimes in the weeks after, you know, they would try to turn the tide. So they would try to kind of take the spotlight off of them and move it to the other person, and basically say like, wow, but you know, but you did this and this, you know.
Okay.
And so it's a fairly common thing that people try to do just to deflect.
Defensive.
Yeah.
I think it was like attack. I forget but basically it's there was actually a term for it.
Yeah.
And from what you read, it's when the person who did the cheating tries to deflect and kind of turn it back on you.
Exactly.
Did that resonate with you when you learned about that term,
Yes.
Darvel?
Yes.
And why was that?
Because that's what she was doing. Like, so throughout December, it just felt like she was, you know, minimizing what she had done. And then she started bringing up all these things about our relationship, other things.
Okay. And I'm going to get to that. The audiobooks, can we pull up Exhibit D 126, please? Did you both listen to an audiobook called How to Help My Spouse Heal from My Affair? Or How to Help Your Spouse Heal from Your Affair? See that?
Yes.
And these are text messages between...
I'm sorry, what exhibit is this?
Sorry. D 126. I believe it's in evidence.
It is not.
It is. 1 second.
Take it down.
I apologize. So I did ask her about it. There was text messages between the two of you guys about an audiobook called How to Help My Spouse Heal from My Affair, correct?
Yes.
And is that something that a audiobook you both listen to in your efforts to try and get to a better place?
Yes. I know I listened to it, and she told me she did.
Now, you heard her testify that she told the detective that her interactions with Mr. Miller were some flirty texts. From what you saw back then and discovered, was that an accurate description of the extent of her relationship with Mr. Miller?
Not at all.
Understand.
Let me ask that again. You had conversations with Ariel where she admitted to the affair, yes?
Yes.
You saw the communications that she had with Mr. Miller, correct?
Yes.
There was all this stuff you just talked about. You heard her say, and when the detective asked her about it, she said there was no affair, and she described it as flirty texts. From everything that you learned about this situation, was that an accurate description of what was going on between her and Mr. Miller?
No.
Sustained. That's not restricting.
Isn't that? I'm sorry, I apologize. That's not the same question I asked. So you know?
No.
Okay. Let me think of what that last question was then. From what you, let me ask you this. I apologize. Let me ask you this one. From everything that you learned and you knew, was her relationship with Mr. Miller, can it accurately be described as just some flirty text?
No.
Sustained.
From what everything you learned and knew, was all that was going on between them flirty texts?
Objection. Same objection. Slightly different question. Overruled.
No.
We'll talk to you whenever there's a convenient break. We'll take our.
I think we're almost to a good place.
Just let me know.
Yeah, maybe 5-10 more minutes. Okay, if everyone's okay with that. Anybody? Okay. You know, we just talked about the audiobooks. Did she also admit in text messages to you that she had an affair?
Yes.
Okay. Now, at some point, do you guys start counseling?
Yes.
And what did you want counseling to be about?
About the affair.
Okay. And what did counseling turn into?
Mostly other things in our relationship. Also a little bit about the affair, but mostly other things in the relationship.
This might be a good time for a break.
Okay. Ladies and gentlemen, let's take a 15-minute recess. Ms. McCallum will come get you at 2:40. Leave your notebooks on the chair. All right.
Message about Gerhard, before we get back into the counseling, there were two exhibits I wanted to introduce, or at least attempt to introduce. This is exhibit 126. May I approach, Your Honor?
Yes.
So, Gerhard, we're talking about the audio books that you and Ariel were kind of reading to get, bouncing off each other, learning from. Did you guys text each other about it?
Yes.
Can you just look through this text and look through this document and let me know, is that a fair and accurate depiction of the text messages you guys are having back then related to some of the audio books you were listening to?
Yes.
Okay. Your Honor, move to admit 126.
Mr. Gardner, no objection. Where's the mark for identification as defendant's exhibit D-126 is received as evidence?
Mr. Dirks, could we please now publish the first page? So if we can blow up this top part here, how to help this one here, Mr. Dirks, please? Yeah. So one of the books that she was willing to listen to was called How to Help Your Spouse Heal from Your Affair, yes?
Yes.
All right, we can take that down. I was asking you about if she admitted to you in text message about a secret affair. May I approach with 125? Huh? Yeah. May I approach her?
Yes.
Okay. I want you to just quickly thumb through that and get a quick look at it. Is this a fair and accurate depiction of the text messages between the two of you on December 9th about the affair?
Yes.
Your Honor, move to amendment 125.
Mr. Gardner, no objection. Where has been marked for identification of defendant's exhibit D-125 is received as evidence?
Can we, Mr. Dirks, publish it starting on the second page for now? Okay, can we blow up the top part? Just that first message, okay? So this, Gerhard, was this a message that you sent her?
Yes.
You engaged and continued an elaborate secret affair instead of coming to me and asking to work on our relationship. Okay, can we take that down? And then at the bottom there, Mr. Dirks, can we blow up the response? And did she respond to you? If anything, I learned how stupid it was this time and know how to make sure it doesn't happen again. Is that what she texted you back?
Yes.
Okay, we can take that down. Now, Gerhard, you mentioned starting counseling and how it was kind of, about the affair, but kind of turned out to be more about other things in your relationship. There was evidence the other day about this recording device. Did you purchase this audio recording device?
I did.
And why did you do it?
So what was going on, some of what was going on in December, and it kind of came to a head on that morning, right before our first counseling session, okay. Is that she said that, basically she's so upset about other things going on in the relationship, okay. that she wasn't sure if she wanted to stay with me, and that, and then she kind of blurted out that Gianna thinks I'm a monster, and she had talked to her mom, and her mom also okay. agreed that this isn't a big deal. And so I was really concerned and suspicious that she was basically lying to them and, okay. and telling them a completely different version of what was going on in our relationship, and then also what the affair entailed.
Okay. And so the audio device was what?
So I was like, I have to catch her in a lie, basically. And so it was me like thinking like kind of like an engineer. How do I fix this? And I was like, I fix it by getting more evidence. And so so I bought that in the hopes of basically. So I was going to use it to record conversations that we would have, and then the two of us. And then if things weren't moving in the right direction, I can be like, listen, this is what you said. Listen, like this is what she's telling me, because if she's telling a different story to her mom Judy and to Gianna, then I could basically catch her in a lie.
Did you end up actually using it?
I tested it and figured out how to use it, and never actually used it for that purpose. We ended up not ever talking about the affair at home, and that was kind of one of the other things that she was able to do through therapy, is that we were not allowed to discuss the affair at home anymore.
Okay. And back at that time, were you just your head was kind of just spinning, and were you just trying to figure out how to get through it?
Yes.
Okay. So you start counseling, and you mentioned that you guys weren't talking about the affair at home anymore. And were you talking about it much at counseling? A little bit. So the counselor that we went to on Maui, the first couples counselor, it was fantastic, and it was in-person counseling, and she really listened to us both and made us both feel hopeful, because she basically said, like, this isn't the end of the world, everything that I'm hearing, and as long as you guys are both committed to making this work, like this is, we're going to get to a better place at the end of this. And so it felt very, very hopeful in that sense. Okay.
But the counseling sessions themselves were focused on other things, and then also on like general kind of relationship building things.
All right. So heading
in those
now,
first 2 months.
in February, heading towards March. Overall, how after I guess they're in counseling for a little bit, and overall, how were things going?
Good, actually. I mean, I felt really hopeful, and in kind of hindsight, I would describe it as taking Tylenol when you're sick, right? It makes you feel better. It's not actually addressing the illness. It's not actually, you're not doing anything about the disease itself, but it felt better because we were learning, communication techniques. We were doing a bunch of exercises to kind of define what we wanted our relationship to be like at the end of this, and things like that.
And you you mentioned not talking too much about the affair at home.
Yeah, and so we weren't allowed to talk about the affair at home either, so it kind of made home life easier,
Okay.
in that sense too.
Let me ask you this: heading into March, were you still committed to trying to make this work?
Yes.
Heading into March, were you still hoping that you guys could work through it?
Yeah.
So now we're into March, and as we've learned, Ariel's birthday is in March. The trip to Oahu, how did it come up?
I have to schedule my vacation basically 1 year in advance. So we plan vacation as a group, and we have to cover a bunch of different sites and stuff. And so we have like a vacation lottery like a year in advance. And so I had the week off of her birthday already.
Oh, you had scheduled from before? You'd scheduled your vacation around her birthday?
Yes.
Okay.
And so I had the week off for her birthday. That's one of the weeks that I had gotten off. And I always do that. I try to get her birthday off and my birthday off and things like that. So I asked her, what do you want to do? And she said, well, we don't have to do anything, but I've never been to Oahu. I would like to go Oahu at some point. It doesn't have to be this trip, but
let me stop you there. So the concept of going on a staycation to Oahu was first floated by who?
By her.
Okay. But to be fair, she said, well, we don't need to do it. I don't know if it's the right time. And what did you say in response to that?
I said, I mean, there's no reason not to. I have the time off, and she could take the time off. And
did you think it would be a healthy thing for you guys to do, given everything you've just been through the last couple of months?
Yeah, I thought it was great. We had just been to California for a week with the kids, and that went really well. And so we had taken like a nice family trip, and it just seemed like it would be nice to take a couple's weekend away.
Had you forgotten about the affair and Mr. Miller or anything like that?
Not at all.
Okay. But you were still hopeful and working towards a better place.
Yes.
And you thought the trip might be a good part of that.
Yeah.
Okay. So she brings it up. she says maybe it doesn't have to be now, but you say, no, let's do it. And do you start to plan the trip?
Yeah, I do.
What day were you guys going to get to Oahu?
Sunday.
And what airline were you going to? Well, you flew over on an airline, obviously.
Yes.
From the Maui airport.
Yeah, I can't remember which airline.
But from the Maui airport.
Yeah, from Maui to Oahu.
Did you and Ariel check bags or carry on?
Just carry on.
Did you go through the TSA checkpoint with her and your carry-on bags?
Yes.
Were there any problems going through the TSA checkpoint?
Not at all. No, the bags weren't searched or anything.
You land on Oahu on Sunday now, I think you said?
Sunday morning.
Sunday morning. What was planned for the first day?
The first day, we were gonna do like a couples spa therapy, like a couples massage at the hotel,
Okay.
and then just walk around Waikiki and shop and just kind of explore Waikiki.
And was that what you guys did?
Yes.
And how'd it go?
It went great. Yeah.
1 second, Your Honor. Let me also approach, please, or may I please approach with Exhibit D 173. Okay, may I approach, Your Honor? I'm going to show you this. What is that a photograph of?
That's a photo of us in the hotel room.
On the 23rd of March.
Yes.
Is it an accurate depiction of how you guys looked the day before this incident?
Yes.
Your Honor, I'd move to admit D 173.
Mr. Barnes, no objection. Will do mark for identification as defendant's exhibit D 173's proceedings evidence.
May we please publish?
Yes.
Zoom in again. Is this the hotel room you guys are in?
Yes.
Okay, and it's the day before the hike, yes?
Yes.
Okay. All right. We can take that now. Did you go to dinner the first night?
Yes.
Second day, you guys are going to be there. Were you planning on going on a hike?
Yes.
And why? Why a hike? Tell us about that. Is that something you guys would do often? Tell the jury about that hiking.
Yeah. So we would hike often, and we would travel often too. So we pretty much wherever we went, we typically would hike at some point during the trip. And we weren't like crazy campers or anything like that. So we wouldn't do like a bunch of overnight things, but we like to do hikes. And she also wanted to see Oahu, and so I was looking for hikes that we could do that would kind of show the island.
Okay. And I'll get back to the particular hike and why you chose that one. But did Ariel enjoy hiking?
Yes.
Something you guys did all the time?
All the time.
Okay. I believe D 156 is in evidence. May I publish D 156, Your Honor?
Please.
Okay. So we zoom in on that photo. So is that
Yeah, that's at Iao on Maui.
okay? And that's a hike you guys would do.
It's like a secret hike behind the Iao monument that you can do if you know where it is.
Some steep cliffs here and there.
A lot of them, yeah.
All right, you can take that down. You know, there was testimony about how the hikes that day on the Palipuka Trail, it made her feel uncomfortable, Ariel. Had you guys been on hikes or activities before with equal or greater heights and cliffs?
Definitely.
Did you guys ever go bungee jumping?
We did.
Okay. Tell the jury about that, where that was and what that was like.
Yeah, so we got engaged in South Africa. We did a 2-week trip there and met a lot of my family and friends and did a lot of sightseeing and got engaged. And as part of that trip,
bungee jump.
We went bungee jumping.
Off of what?
It's called Blokran's Bridge. It's a bridge that spans a beautiful canyon in South Africa, and it's a 700-foot bungee jump. It's one of the tallest bungee jumps, one of the tallest commercial bungee jumps in the world.
And Ariel did that?
Yes.
Could we please also pull up Exhibit D 149? That's already in evidence. Let's let the clerk confirm it.
Please.
Okay, thank you. Would you guys go zip lining? Or
Yes.
have you gone zip lining?
Yes.
Okay.
Yeah, that's Costa Rica.
That's in Costa Rica? Costa Rica?
Yes.
Okay. We can take that down. In your entire relationship, when you know, there were, whether it would be bungee jumping, the hikes with steep cliffs, zip lining, had she ever expressed any concern about hikes before?
We are both very cautious people, and we stay safe, and so we don't end up going close to the edge. Our friend Gianna likes to go like and pose for crazy pictures, and we didn't pose for the like super crazy pictures, but we would always do the hikes and without any concern.
Okay, even ones with steep drop off.
Yes, for sure.
Okay, now there was testimony from Detective E. Numa about some of the searches you did on hikes. And first of all, there was some searches in there about Maui hikes. Why were you searching hikes about Maui in that early March time period?
I was looking for hikes on Oahu, and then while I was looking at hikes, I just started kind of looking at hikes that I had meant to look up in Maui too. We hiked a lot on Maui, and had done all of the kind of the ones that are easier to find out about, and so we were talking to a bunch of people that are from Maui and getting recommendations for hikes. And so when I was looking up hikes, I was looking up some of the Maui hikes as well. I also looked up some hikes on Kauai that I'd heard about that I wanted to do in the future.
Did you also hike with Emil?
All the time.
On Maui?
On Maui, yeah. He loved hiking and jumping off waterfalls.
Okay, so you do the research. Do you come across the Palipuka hike?
Yes.
And what did you learn about it, and why did you choose that one? What were the things that made you choose that one over the other ones that you researched?
It just seemed like a really cool spot that you end up in, where there's this hole in the mountain you can look through and take pictures. And the hike itself seemed fun because it provided a bunch of great views, but it was also kind of close to Waikiki, and it wasn't too long of a hike.
Why did it matter if it was really long or not?
We didn't want to spend the whole day out. So we were only going to be here from Sunday to Tuesday. And so Monday was our the only day that we were here the whole day. And we wanted to hang out by the pool for
so
part
was
of
the
the
plan, go on this kind of shorter hike and then go hang out at the pool the rest of the day?
Yeah.
Did you also make a dinner reservation at
Yes.
Set?
Yes.
For that night?
Yes.
Did you explain to Ari ahead of time that you had found this Palipuka hike?
Yes.
Did you tell her a little bit about it?
Yeah.
Did she object to it in any way?
No, not at all. She sounded excited.
Excuse me?
She sounded excited.
Okay, second day. Now, you said the plan was short hike, spend some time at the pool, go to dinner. Let's talk about that day. So that was that her birthday, we've heard?
Yes.
So you guys wake up, and already in evidence is State's Exhibit 133. May we publish that, Your Honor?
Yes.
Okay. Did you give her a birthday card that day?
Yes. Yes.
Okay, we're not going to read the whole thing, but did you mean the words you wrote in there?
I did.
Okay. Did you? We can take that down. Did you also get her a birthday present?
I did.
What did you get her?
It was a necklace, like a Koa wood silver necklace.
Okay. You wake up. What do you do before heading out to the hike?
We had breakfast at the hotel, and then next door to the hotel was a bakery where we got some coffee and some pastries.
Okay. May I approach with D175?
Yes.
What is this a photo of? Well, do you recognize it?
Oh, that's Ari at breakfast at the hotel.
Okay. Is it a fair and accurate depiction of how she appeared on the day before you left for the hike?
Yes.
All right. Could we please admit D175 into evidence?
No objection. What is remarked for identification as defendant's exhibit D175 is received into evidence.
Can we please publish? Okay. So this is a photo from that morning before the hike?
Yes.
Okay. All right. We can take that down. Thank you. Now, as you're, were you going to drive to the hike?
Yeah, we had a rental car.
Now, did you receive an email that morning that you shared with Ariel before the hike dealing with life insurance?
Yes.
So first of all, let me ask you, let's back up a little bit. You talked about January, February, and you guys kind of get to this place where you're in counseling and you guys decide you're going to be together and you're working on it. Did there come a time when part of what you did during that time was assess the life insurance situation of you and Ariel?
Yeah.
Tell the jury about that.
And really, it was pulling the trigger on life insurance. So I used to have life insurance in Pittsburgh through my employer, and didn't have life insurance when we moved to Maui. And it was always on the to-do list, and just got busy with life and other things. Originally looked into it the previous year, but never went so far as to contact the life insurance agent and actually go through with it. And in January, we were kind of working on big picture relationship things, and I was like, oh shoot, we still have to get life insurance. And so I talked to Ari, and we both applied for life insurance at the same time at the end of January.
Did you get the same amount?
No.
Why not?
The idea was that if one spouse would die, the other one would be able to continue on and live in the same house. And so it was, since I made significantly more money than she did, it was basically enough money that she could pay off the house if I would die.
So what so what was the plan in terms of the amount you were trying to get on your life for her?
1.5 million.
Okay. And then when you guys did the analysis of what, if something happened to her, you would still have your salary to pay for the house and whatnot.
That's right.
So what was the amount that was decided for her?
$250,000.
Okay. And the 1.5 million that you were trying to get on your life, was she the beneficiary?
Yes.
And vice versa?
Yes.
Okay. So 250 if something happened to her, but 1.5 million to her if something happened to you. Is that right?
Yes.
Now, when you went about securing the 1.5 million on your life for her, did it happen in two parts?
It did.
And so the first part was for how much?
1 million.
And when did that roughly get approved in relation to March 24th?
A few weeks before.
Okay. The morning of March 24th, did you receive an email about the other 500?
Yes.
And what was the email?
That policy had gone through, and I needed to DocuSign the final documents to make it effective.
And did you DocuSign it that morning?
Yeah.
Your Honor, can I approach with D116?
Yes.
Dr. Konig, I'm showing you D116. I want you to look at it, and a lot of pages to it, but just the first page. Tell me what is D116?
This is the email from AAA Life that is asking me to DocuSign the policy.
Okay. And what date and time did you receive? Well,
I received it on Monday, March 24th at Monday, March 24th, 2025 at 8:02 a.m.
Okay. And is this a fair and accurate depiction of the email and attachments you received on the morning of the hike?
Yes.
Your Honor, I have to move it into evidence.
No, Judge. Was the mark for identification of defendants exhibit D116 is received into evidence?
Could we please publish the first page, Mr. Dirks? Okay. So let's look at this. Okay. So Gerhard, at the top it says, please DocuSign. It has your name. It has the AAA life insurance. I guess that's AAA. Is that who you did?
Yes.
Is that who you got your life insurance from?
Yes.
And the date there is March 24th, 8:02. Is that right?
That's right.
And this was for the extra 500 you were adding on to the million of life insurance you got for her a few weeks before, right?
Yes.
Okay. Did you discuss this additional 500 that went through with Ms. Konig, and that the email came in and you DocuSign? Did you tell her about that before the hike on March 24th, 2025?
I did, because we were in the parking lot after the coffee shop, and I was on my phone. I was like, oh, you know what? My, the last of my life insurance just went through. They're asking me to DocuSign it, and so I was doing that.
All right, we can take that.
Just want to let her know that I'm not like just texting or something, like, because we were out together.
Okay. So you were telling her what it was that you were looking at.
You're nodding your head, is that a yes?
Yes.
Thank you.
And so from that point on, if something happened to you and in an accident or whatnot, she would get $1.5 million, correct?
That's correct.
You guys drive up to the Poly Lookout after that?
Yes,
You get to the parking lot. Was it crowded when you got there?
it was.
Did you guys go? What did you guys do first after you parked?
We went to go. Actually, I think she went to the restroom first.
And the porta
But
potty?
no, there's a bathroom
Okay.
at the Lookout,
Okay.
and then we went to the Lookout.
You went to the Lookout. Now, Ms. Konig testified about this thing about how it looked like they were hikers trying to find the trailhead, and then you said, oh wait, we want to be alone. Did that happen?
No.
How hard is it to find the trailhead?
It's not hard if you know where it is. It's not marked with a sign or anything, but it's right behind the bright blue porta potties, and there's a permanent rock wall, and it's like rock, like kind of almost like an altar right there. So if you know what to look for, it's really easy to find.
After looking at the Lookout, did you guys start the hike?
Yes.
You head up the trail, and as you're heading up the trail, did you guys stop and take any photos?
Yes.
Okay, and can we? I believe S-131 is in evidence. Can we publish it? Let's just let the court confirm.
Yes.
Okay, thank you, Your Honor. Okay, so is this a photo that was on right after you, kind of shortly before you? I mean, right when you started the hike? It was,
Yes.
And who posted that?
Ari did.
Okay, let's take that down. Now, continuing on the hike, what happens at some point? What did something happen that led to an argument?
Yes.
Tell the jury what happened that led to an argument. Well, first of all, how far up into the hike was it?
Not very far, just like 5 minutes. Like after about 5 minutes of hiking, you get to a part where it flattens out a bit, and the edge isn't like the cliffside isn't open, but there's a couple of spots where you can get to the cliffside if you wanted to. So we're kind of still in that area, the same area that picture was taken.
Okay.
And Ari says, "Hey, I need to talk to you about something. I'm working on this project with Jeff Miller, and I'm gonna need to travel with him again, and I need you to be okay with that. Is that okay?"
Okay. And so she was kind of telling you like, hey, there's just things at work going on. I need you to be okay with this. And asking you to trust her.
Yes.
Okay. And again, you mentioned you guys weren't talking about the affair at home anymore because of counseling, correct?
That's correct.
And you guys weren't talking about it in counseling a lot at that time?
We hadn't gotten to kind of the core of it yet.
So she brings this up. What is your reaction to it?
I'm very surprised. Yeah.
Were you upset and angry?
I wasn't angry. I was surprised and upset. And I told her no. Like I'm not okay with that. And not only am I not okay with that, like I'm never going to be okay with that. Like we haven't dealt with that part. Like the only reason why I was okay with her still even working there is because we had placed these limits on their communication. But in my mind, like she still needed at some point to quit her job, and this was only put on hold while we were trying to deal with all these other things. She basically said like, well, I can't quit my job right now because I don't even know if I want to stay with you. So we were dealing with like the issues that she brought up first, but it's not like any of the affair had been resolved at all. Like it had just kind of been put on hold. And so
how did you feel that she would even think that this would even be okay?
Yeah. I mean, it made me realize that we were just not on the same page at all in terms of like, here I am just kind of like sublimating my feelings and focusing on her hurt and waiting patiently for her to do the same to me. And this made me feel like she wasn't intending on doing that ever.
So what did you say back to her? Were you guys kind of arguing about it?
Yeah, we were for sure arguing.
Okay. And then, so what did you say anything to her?
I just said,
out?
yeah, I said like I need you to move out. Like this has gone far enough. I need you to move out. And I'm going to tell people why you're moving out, and I'm going to show them what you did, because like unless you face this and unless you take full accountability for this, like we're never going to get through this.
So and that was like after you guys have been kind of arguing for a while about. I mean, an argument starts. You guys are arguing. You're telling her no. You're telling her all these things.
Yeah, I mean the argument developed more slowly than what just happened, and there was other things said too. But
that's how it culminated with you telling her, well, if that's the case, if that's how you feel, you got to move on.
Yes.
Okay. What did she say anything to you about her mom and Gianna?
She did. So like earlier in the conversation, she'd be like, well, what if my mom chaperones my work trips with him? And I was like, no, like I'm still not okay with that. Like, and that's not a long-term viable solution. And then later in the argument, when things kind of got heated, she was like, actually, my mom just said that she'll chaperone the trip and she thinks Jeff is interesting and can't wait to meet him. And I'm like, you're obviously telling them a whole different version of what happened than me.
So in the argument, in her effort to say for you to be okay with it and go on the trip, she said, well, what if my mom chaperones me?
Yes.
Okay. After, it comes to this point in the argument where you say, well, you know what, you got to move out there. I'm going to tell everybody what you did. I mean, it got to kind of it was not a good conversation. It sounds like.
Yeah.
Okay. So what did you do next?
I stomped off. I just stomped off up the trail. And this was a point where we were both really kind of just upset with each other. And I went one way and she went the other way.
How far up did you go?
5 to 10 minutes.
Okay. Why did you turn around?
I was kind of at a loss of not kind of a loss. I was I just didn't want to be there. Like
did it make sense for you to keep going on this hike?
No. I like 5 to 10 minutes in, I was like realizing kind of where I was, and I was like, I don't want to be here. I want to go home and like start dealing with what we need to deal with. I don't want to, I got to the point where it opens up and it's like these beautiful views, and I'm like there by myself and upset. And I was like, I don't want to be on this hike by myself, upset, and I don't want to do this hike. I'm going to come back and do this hike at a different time when I'm happy. I was really looking forward to doing the hike.
When you headed back down, were you expecting Ariel to be where you had left her?
No.
Where were you expecting her to be?
I thought she went to the car because I saw her head down the trail.
And there was testimony that when you said when you got there, you said, "Oh, you're still here." Did you say that?
Yes.
And is that because you assumed she had gone back to the parking lot?
Yes.
How far away from the parking lot were you guys when this argument started?
Like 5 minutes, or less, probably. Yeah.
Okay. Now you get back. What is her demeanor and behavior like now?
Like a 180 reversal, basically. So she was like extremely apologetic, and said, basically, I'm so sorry. You're right. Like, I need to take accountability and like, let's just, not ruin the day. I don't want to ruin the day. I don't want to ruin our trip. And let's keep talking about this in therapy. And she said like, I won't travel with Jeff.
Did you guys end up taking a selfie?
Yeah. First she was like, again, like almost manic, like super happy, and was trying to basically, get me to be in a better mood. And she was like, I'm gonna climb this tree, take pictures of me in this tree. And so she handed me her phone and I took some pictures of her in the tree. And then after that, she said, let's take a selfie by the cliff's edge.
That was her idea.
Yes.
Okay. Did you guys take one?
We did.
And what happened after that?
Right after the selfie, I just remember kind of staying at the edge there and looking over the edge and just kind of still in thought about everything that had just happened and what's going on. And then I felt like a shove, and I was almost pushed over the edge.
Okay. You felt a shove. Okay. Who shoved you?
Henry did.
What did you do right after that?
Barely caught myself and turned around and looked at her and was like, what the fuck was that? Like,
Turn around and it was like, what, was like kind of in shock. Like, what the fuck was that?
yes.
Okay. And then did you move towards her?
Yeah, I did. I was like, just asking her, like, you know, what was that? And started walking towards her. Because at this point, she was like 5 or 10 feet away from me.
So you walked towards her, and you mentioned when you're walking towards her, where were your hands?
Out.
Okay. Now, did you get close to her?
Yes, eventually, yeah. Well,
And by the way, when you start walking towards her, is she saying anything?
not initially, but I turn around and I'm asking her, like, what the hell's, you know, what the fuck's just happened and what's going on? And as I'm starting to walk towards her, she starts yelling.
She starts yelling.
Yeah, help me, help me.
Okay. And then what happens?
And then I just keep walking to her, like, what are you doing?
Were you
And I
telling
get
her, like, why are you screaming?
Yeah, what are you doing? And I get to her and I'm like, touching her, just putting my hands on her arms. And I was like, what are you doing? What's going on?
What happens then?
She keeps yelling and she kind of grabs my wrists and throws herself on the ground and pulls me down with her.
So now you guys are on the ground?
Yes.
Okay. When you're on the ground, what starts to happen?
She's holding on to me and I'm trying to figure out what's going on, but I'm also at this point trying to let go of, like, trying to get free because she's like actively holding on to me. Like she has her leg like wrapped around one of my legs and like is actively holding on to me and is yelling. And so I'm trying to, get free. And I get my one arm free and I try to use it to get my other arm free. And she grabs me by the testicles. And
Let me stop you there. Did you ever, in the course of this whole thing you described so far, ever try to pull her towards, push her off, or drag her towards the cliff's edge?
No, not at all.
Okay. So you're on the ground. She's kind of holding on to you. You guys are, would you just kind of like a scuffle going on?
Yes.
Okay. And her legs wrapped around you?
Yes.
You mentioned, we got right up to the point where you said she grabbed your testicles. Is that right?
Yes.
How hard did she grab it?
I mean, this was, like
Pretty hard.
she like was holding on to me by my testicles, basically, like that hard.
Okay. Did she grab it and let go, or did she grab it and hold on?
She grabbed it and held on.
Now, what happens after she does that?
Then I try to free my testicles. And so I'm like thrashing with, and I get both hands free and I'm trying to get her to let go of my testicles. And then she hits me with a rock on the side of the face.
Okay. She's holding on to your testicles. You're kind of focused on that, obviously. And then at some point while you're focused on that, and
it happened all really fast.
Yeah.
But
that's I'm glad you raised that up. Was this like happening slowly where you had
it
time
all
to-
happened within probably less than a minute, maybe
quickly,
slightly more than a minute, but 2 minutes or something.
but you weren't timing it.
From the moment that like we were on the ground and she was grabbing my testicles was like
it happened quickly.
Everything after the grabbing of the testicles happened very quickly.
Okay. And you weren't timing it or anything.
No.
This is just your estimate. Okay. So now she's holding on to you, she's squeezing your testicles, and you kind of dealing with that. And she's on the ground and you're kind of on top of her?
Yes.
Okay. And you said then you felt you got hit with the rock.
Yes.
Where'd you get hit?
On the left side of my face.
How many times?
She kept doing it. The first blow she landed really well, and after that I was able to block fairly well. She did like land a couple more, but not as bad as the first one.
She still got your testicle?
Yeah, so she's like holding my testicle and just like hitting me like this.
And now do you stop dealing with your testicles?
Just focused on the rock at this point.
Okay.
Yeah.
Okay.
Yeah.
Did it hurt when you got hit with the rock?
It did.
Could we publish what's in evidence as Exhibit D30, Your Honor? Yes. Okay. Gerhard, is this where you got hit with the rock?
Yes.
Is that the area?
Yes.
We can take that down. Now, you get hit with the rock. Explain to the jury what happens next and why.
I was able to wrestle the rock out of her hand.
Does she still have your testicles?
Yes.
Still squeezing them?
Yes.
What do you
And
do?
I was able to like, so we're like, she's hitting me and I'm like blocking, and then I start like, and I get
Is
her
there a
wrist.
scuffle over the rock?
Yes.
Is it near her face?
Yes. I mean, it's
And
it's
then what
right.
happens?
And I finally get the rock.
What'd you do?
I hit her with the rock.
How many times do you think you hit her?
I hit her 2 times.
And when you did, was she still holding on to your testicles?
Yes.
At least initially?
Yes.
Why did you hit her? Why did you react that way?
Just on instinct to defend myself.
How fast was this all happening? Pretty fast?
Really fast.
Okay. In between when she hit you with the rock and in between the time she hit you with the rock and when you hit her with the rock, were you able to safely retreat and get away from her?
No.
Yeah. Why not?
She was holding on to me.
Including your testicles?
Yes.
Did you hit her in the face or the eye with the rock?
No.
Where you said 2 times, where did you hit her?
On the side of the head.
Okay. So we've seen these photos of the stellate laceration. You caused that by hitting her, right?
Yes.
Okay. Did you continue to hit her after those 2 hits?
No.
And why not?
Because she stopped fighting. She let go of my testicles, and I was
Okay.
able to stand up.
And then you stopped.
Yes.
There was testimony about the 2 witnesses. Did you stop hitting her because the witnesses showed up?
No, I didn't know that they were there until after I stood up.
Did you see blood?
Yes.
Was there a lot of blood?
There was a lot of blood.
Did you see her kind of scoot down towards the witnesses?
Yes.
Did you try to stop her in any way?
No.
You let her get to them.
Yes.
Did you hear her yelling to the witnesses, he's trying to kill me?
Yes.
Gerhard, did you have any syringes on the mountain that day?
No.
Did you try to poke her or stab her with any syringes?
No.
Okay. Now, Gerhard, she scoots away. She's now with the 2 witnesses. You see a lot of blood. What do you physically do next?
I'm just in a daze, and I just kind of watch her crawl away and then leave with the other 2 hikers.
Okay, she got the hikers. What do you do next? Was her bag and your bag there?
Yeah, so I just kind of reflexively gathered up all of our stuff, and then I start walking up the trail.
Let me ask you this. At this point, immediately following what just happened, you saw, you guys had this scuffle. You saw a lot of blood. What was your state of mind and emotional state like right now, right at this point that we're at?
Severe emotional distress.
How did you feel at that time about the fact that you had responded and defended
Horrible.
yourself? Let me finish the
Horrible.
question.
Sorry.
How did you feel about the fact that even though you say it was, you were defending yourself, how did you feel about that she was bleeding?
I felt horrible.
Did you ever plan on hurting her that day?
No.
Did you ever want to hurt her that day?
No.
You reacted to defend yourself in the heat of that moment. You said yes.
Yes.
But did you still feel bad about it?
Yes.
You mentioned that you were in some kind of extreme emotional distress, I think you said.
I can't believe they ended the day and they put me in with some ducks or something. You know what? That's yes. So no verdict today. They are heading home. 9 a.m. Yeah. Yeah, real happy. I just confirmed it. When I was looking at the thing, they had put me in with some ducks. I'm like, why am I looking at ducks hatching? That's what they put me in with. I'm like, what is this? Disgusting. I don't want to see that. I'm good. So it looks like we're gonna be in verdict watch tomorrow. Just Shamrock said he's facing 5 years to LWAP. Yeah, so our play tomorrow is I will be streaming some stuff in regards to the Fulio trial, the last motions before we actually go into trial. We will be going into trial for the Fulio case for the last 4 defendants, in front of our judge, Cisco. We were previously in front of her with Alicia Andrews. So we're going to see how she's going to act in this next case. It's 4 defendants that are all facing the DP. So if you just checking in and tuning in with us, that will be what we'll be checking out tomorrow. For the most part, unless they got jury duty. Now they may have, if they just doing jury selection tomorrow, we may not start court tomorrow. I don't know how they're going to do that. So that's kind of playing by ear, but hopefully we'll be able to listen to opening statements tomorrow. That will be awesome. So the jury went home today. So I want y'all to tell me, are we putting a 1, he guilty, 2, he not guilty? What are we putting? What is the issue with the jury right now? Texaco gate. Oh gosh. Not because of the balls. Yeah, so my question is, are we putting a 1 that he's guilty and why are they still deliberating? Yeah, I know, real happy. I seen that Pretty Lies was covering that case. Yeah, I seen that she was covering that case. That's awesome. Yeah, I kind of figured that we'll be here. We'll be here. I was like, I can't cover that case because I want to cover the Fulio case. And I was like, I'm not going to be trying to cover all these cases at the same time. I am not. I am not Court TV. My baby is texting me, calling me. Too much stuff to decide when a jury gets given. That they do have a lot of options. They do have a lot of options, and they're going to be going through all those options. I don't know if he'll get the highest charge. I don't think he will. And then, I guess they have to be real about what they're doing and what they're exploring. So, I guess it's okay that they're back there. It's only been 2 hours, and let me give y'all the time so we'll know where to pick up tomorrow. I'm trying to see if it'll show me. Wait a minute. I'm gonna write it down. Yeah, I can't believe they got me looking at a bird cage. Like, oh my goodness. I can't believe that's where they drop you off at. That's where they redirect you with their string. I shit you not. This is where they got me. Look, this is what they got me looking at. They dropped me off. They redirected their string to a bird cage. I'm cool. I don't want to look at bird cages. Yeah, so we will start probably at our regular. We'll start early, guys, because I'll stream early, maybe about 8 or 9 o'clock Mountain Standard Time. And then it will be on Verdict Watch for our Hawaii trial. But I be missing y'all in the morning when we don't have anything to do in the morning. So yeah, we got to get up early, and we're gonna have to start something in the morning. Okay, real happy. Have a good one, sweetheart. Thank you. Yeah, so we got to get up early, and we're gonna have to do our one too. Because I'm thinking even if Julio trial, if they're going through jury selection, it'll probably take them a while to get through jury selection. So we will get our stuff together in the morning. All right. Well, I think we did it, right? We did it. Night, Billy. I want to say thank you to the mods, all the new subs, all the new members. I'm your girl, Sweet Pea. Y'all know we got our outro song, and I'm going to let us do it like we do it. Make sure you have your notification bell on. And if you are on the replay crew, please drop a message. I see them all. I try to respond to them all. It's so helpful, and I so appreciate it. Y'all know I love you guys. You so funny, real happy. I cannot deal. I can't look at these things. We will be here all day long. We'll be looking at these. All right, guys, let's do our outro.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, shadows showing out. This little YouTube corner's what community's about. Therapist, you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we'll forever take it to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach strolls and causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we'll forever take it to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. Estes razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white cloth way, managing volunteers like she runs the whole land. Cynthia brings inside, would take sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard-lived, tries to support her with pride. Melly shows up a family for cooking for his dog. A steady caring presence through the courtroom fog. in Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baka loves her grand, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind of vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvier, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shadows, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Just sweet Pea in the mouth and the child we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
Everybody have a wonderful evening, and I will see you in the AM tomorrow. Peace.